petitioner have, and my lord,
It's not in the list.
is running as item number 106 on the monthly list, my lord, not in the daily list, my lord. Kindly include in the daily list, my
It
lord.
is returnable date on 13 July. It
13
was not listed.
It was listed on monthly list, my lord, but as item number 106, my lord.
Okay.
Grateful.
Today is not the mentioning date.
Lordship, with your Lordship permission, I'm mentioning a matter. Lordship, the matter relates to defreezing of the bank accounts. Lordship had called for a report from the concerned bank. Lordship, we have contacted. They're ready with the bank report, Lordship. The bank is the respondent authority. Lordship, it's running as item number 117 in the monthly list, Lordship.
Who are you?
Lordship, I'm the petitioner. My bank account has been freezed. I'm praying for defreezing of that bank account.
Today is not the mentioning day. You have taken the mentioning because the 13th July was the fixed date, but it is bygone. Today is not. Go to the cause list. It is mentioning. Come tomorrow. Yes.
On the 10th July, this matter is supposed to be
under a compelling circumstance. Under a compelling.
expiring on this Friday, Lordship.
Friday.
Under the compelling circumstances, I am just specifying before your Lordship that this is the item number 136, which was running in the list of your Lordship on 8th of July. Till date, the order has not been uploaded, Lordship.
No.
That's why I am
sorry. Not a single order is.
I have just brought to the notice of the register.
Which matter? Why not brought to notice of me to me if the advocate has stated that?
No, yesterday I have already specified that, but in today, I am sorry for that, but it is my.
No, give the writ number. Because in my chamber, I understand the very same day or the very next day in the morning, I sign all the order.
That was coming.
If there is a correction in the evening,
yes, that was coming under the specially fixed matter. In that matter, item number 136.
Which date?
8th of July, Lordship. I am giving the number.
8 July 2026. What is the number?
WPA 816 of 2026.
816.
2026, Lordship.
816.
816.
Okay.
That was item number 136.
Today? On
8 July. 8 July. 8 July. 8 July.
So what interim order was extended? No.
There was an order which has been, direction has been given of filing affidavit, and there was a certain order specified that. Okay. I couldn't intimate the authority, Lordship.
Lordship, this.
Yes.
Lordship, this Lordship, one matter was supposed to appear. Lordship, kindly listen to the urgency once. Lordship, one matter was supposed to appear in the list on 14th of July, Lordship. It did not appear in the list.
Come tomorrow. Today is not the mentioning day. In view of the above, recruitment process initiated by advertised number 12 of 2022 for the post of Keeper State Archaeological Museum is set aside and quashed. Accordingly, appointment of respondent number 7 to the post of Keeper is set aside and dated 31st of July 2025 is also set aside and quashed. The respondent authority is directed to initiate a fresh recruitment process to fill up the vacant post of Keeper immediately in accordance with the recruitment rule and the West Bengal Service Commission's rule from 1982. If the candidates who have appeared in the recruitment process in terms of the advertisement number 12 of 2020 become overage, the Public Service Commission shall consider the relaxation of their age if they made any request for relaxation of their age. Dispose of.
Lordship, let the file be.
Yes, ekta record karun. The original file as well as the mark sheet is returned to the Learned Council appearing for the PSC in court today. Take it after lunch.
Your Lordship,
yes.
If I may mention.
Yes, item number 2. Who is appearing? This court did not find any justification to interfere with the so-called notice dated 20th November 2024 and the impugning order dated 11 March 2024. WP is dismissed.
Grateful. Your Lordship, I am unable to service the service to the DP.
Who is for the petition number 1?
My lord, I
appear
for item number 3.
Yes.
My lord, I am seeking to withdraw this petition
Hmm.
as it has been filed in the wrong group. It's actually a service matter, so it should be group 6.
So want to release?
Yes, my lordship, I am praying for a leave to correct the presentation form
Hmm.
so it can be presented to the appropriate court.
I'm for the bank, my lord.
The counsel for the the matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. Counsel for the petitioner submitted. The petitioner has filed the present writ application before this court inadvertently as the matter coming under the group
Group 6.
Group 6. Full stop. He also prays for leave to correct the group in the presentation form. Accordingly, petition is granted leave to correct the group in the presentation form. Full stop. WPA number 9784 of 2025 or 26. 2025 is released from the list of this court with the liberty to the petitioner to mention before the appropriate court having determination.
Your lordship, if I may mention an urgent matter.
Yes, item number 4.
My lord, this is that matter, my lord. Lordship, my lord, direction was given to seek
Yes.
instruction, my lord, as to whether, my lord, the affidavit was filed.
Yes, my lord. Filed by all the doctors, my lord.
Then what is your instruction?
My lord, every doctors have to file that bond.
File.
Yes.
So why the original has been released to the other 6
No,
persons?
my lord, the officer told me that there is some verbal communication with the petitioner that if they want withdraw this application, then they shall release the documents,
No.
my lord.
Let them give undertaking before this court, my lord, we shall withdraw.
No, my
Now
lord,
you do one thing.
this
Bring
was-
all the original tomorrow here. Now you will dispose of this.
Yes.
my lord, day after tomorrow, my lord.
Okay, day after tomorrow. The Learned Counsel for the state on instruction submit that the authorities are informed that if the petitioner intending to get the original certificate from the authorities, the authorities will release this original certificate of the petitioner. In view of the above, the state is directed to produce all the original certificate before this court on 20th July
In
2026.
respect of 4 to 9, all the
2026 with respect to all the petitioners. List the matter on 20th under the same heading. Bring and I will dispose of.
Great.
My lord, I'm for the bank, my lord. I have been served a notice for non-prosecution and I have intimated the petitioner also.
You are for the bank.
Yes, my lord.
You are not proceeding. What?
No, I'm not proceed. The petitioner's advocate had served me a notice for non-prosecution and I had intimated him last evening also that the matter is listed.
Have you got an order? The matter is listed as to be mentioned on the prayer made by the counsel for the bank. Then counsel for the bank submit that she has received an written instruction. She has received a communication from the learned advocate of the petitioner on 23rd of June 2026 that the petitioner will mention the matter before this court for withdrawal of the instant date application. Police. The copy of the communication dated 23rd June 2026 be kept with the record. As the learned advocate for the petition has communicated the bank that the petition is not going to proceed with the matter.
the petition.
You are withdrawing.
Yes, sir, my lord.
So you are appearing for the petition.
Yes.
Get it in.
I have intimated him last night.
Learned counsel for the petitioner. Mentioning has to be mentioned. And counsel for the petition submit that he has instruction to proceed with the matter and paid for withdrawal of the instant date application. In view of the submission made by the counsel for the petitioner, WPA number 27662 of 2025, it is dismissed as withdrawn. The written instruction be kept with the record.
Great.
Your lordship, this is an urgent one. The matter was listed for hearing on.
In item number 11, lordship, I get for the petitioner, my lord, I have been instructed to withdraw this matter, my lord.
Where is the instruction?
My lord, instruction within me, my lord. He have given me
What
the
is your
written
name?
instruction. My name is Pintu Kanar, my lord.
Huh?
Pintu Kanar.
Pinku?
Pintu Kanar. Pintukar.
Pintu Kara. Learned advocate for the matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. for withdrawal of the writ application. And counsel for the petition submitted, he got the instruction from the petition that the petition is not intending to proceed with the matter and prays for withdrawal of the instant writ application. In view of the submission made by the counsel for the petitioner, WPA 1461 of 2026 is dismissed as withdrawn.
Grateful to your lordship.
Next,
I appear on behalf of the petitioner.
yes,
Your Lordship, I have instructed to not to proceed because of tender matter. There are subsequent development. Your Lordship, kindly excuse me, this is scan copy because the communication is forwarded to me in my email.
yes, record. The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. Counsel for the petitioner submitted. He has received the written instruction from the petitioner that the petition is not intending to proceed with the matter according to press or withdrawal of the present date application. In view of the submission made by the counsel for the petitioner and the communication dated 8th of July 2026, WPA 11146 of 2026 is dismissed as withdrawn. Communication be kept with the record.
Lordship, kindly indicate the interim order, it will be vacated.
Interim order in fine stand vacant.
Yes, please still.
I am for the respondent authority matter.
13, Your Lordship, I am appearing for the Union of India.
Yes, who is for the petitioner? It is listed as to withdrawn. Who is there?
Yes, Your Lordship, for withdrawal it's listed. Petitioner is not appearing, Your Lordship.
Enter key. The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. The petitioner has mentioned the matter before this court on 14th of July 2026, seeking leave to withdraw the present date application. When the full stop. And consider submission in full stop. Today, when the matter is called, none appears on behalf of the petitioner. In view of the reasons mentioned in the withdrawal list, mentioning list, comma, WPA number 13641 of 2026 dismissed as withdrawn. Interim order is vanished and vacated.
I am grateful to Your Lordship.
Your Lordship, this matter was
Yes, yes,
14, I am for the petitioner.
yes.
My lord, last occasion, 2002 and 12, my name was in the voter list
Hmm.
and I casted, petitioner cast a vote.
Good.
But this year,
All
the name has been deleted.
correct.
We prefer an appeal which is pending before the concerned authority. I have annexed the appeal. I have served all the respondent. Affidavit service is ready, my lord.
Hmm.
So direction is for early hearing.
How it
Otherwise,
is, how
we
it
are
is listed today?
not getting.
Huh?
Leave.
Leave.
We are not getting any passport.
Where is the affidavit of service?
That is
not FM.
Why,
not affirmed.
They have accepted. They accepted it will be affirmed within 10 minutes.
Let the matter appear on
My lord,
on 21st of July 20.
my lord,
Next.
we have served, my lord.
Next.
My lord, kindly consider we have served within 10 minutes. I will affirm this. My lord, kindly consider, my lord. Huh? Well, let it be tomorrow, my lord. We are suffering, my lord. Let it be tomorrow, my lord.
Once you mention, you could have alert.
Yes, my lord.
You are not afraid. David, come on.
My lord,
21st.
we have ready.
On your wish, the court cannot. Yes, who is for the item number 15?
My lord, let it be tomorrow, my lord.
What is the matter?
2 p.m., my lord.
What is the matter?
Your Lordship, I'm seeking
My lord, let it be
so by Your Lordship, I'm being led by Mr. Kumarjit Banerjee, Your Lordship.
Though the matter is listed as urgent motion, as item number 15, when the matter is called and counsel for the petition prays for time, let the matter appear on 4th of August
Your Lordship,
2025.
I'm just seeking a short pass over, Your Lordship. Lordship, item 15, Your Lordship, the matter was supposed to appear on 23rd July, Your Lordship.
I am
However, the
appearing
matter
for the-
wrongly appeared, Your Lordship.
Which
Today.
matter?
Your Lordship, item 15 was to appear on 23rd July, Your Lordship.
Okay, let it come on 4th, no problem.
Your Lordship may let it come on 23rd July in that case, Your Lordship, Your
No,
Lordship.
no. Yes. When it is listed, then it is listed. Yes. Who is appearing? Item number?
Your Lordship, item number 16, I am for the petitioner, Your Lordship, led by Mr. Auditro Basu, Your Lordship.
Ah.
Lordship, on the
Last occasion, your lordship directed to concerned police station to file a report, lordship.
Hmm.
There was
Yeah.
a report. It took to
And in the lordship, in the police report, it has been all stated clearly, your lordship, if that there was no financial transaction and no movement could be detected between kidney recipient Mr. Chintu Khara and donor Mrs. Rupa Shaha.
was at choice.
Yes,
Other side to copy.
yes.
Yes, my lordship will see the report. The last report that was given
Yes,
on
I
the,
got the report. Yes, what is the case?
yes. My lordship will kindly take, my lord, page 9 of the report.
Now today report has come. What is your case? You come on merit.
Yes, my lord, the document that has been given today, they say, my lord, that no financial transaction or no middleman could be detected between the kidney recipient and the donor. Now, my lord, this is, but if this is the situation, then perhaps, my lord, the verification report is incorrect. Kindly see page 9 of the report that was handed over on the last occasion, which is the verification report. Kindly see page 9.
Yes.
Yes, well, kindly see serial number 1, nothing is established. Well, this is perimeteria with the report that has been given today. But Malad, kindly see what is the conclusion at the bottom of page 9. It is not clear how both the parties came in contact and became family friend or driver. No documentary evidence or any photograph was produced. Hence, link between both the parties could not be ascertained, hence not recommended. But this is the case of non-near relative. So if it is a case of non-near relative, but it is not possible for me to disclose documents or to corroborate the relationship between the recipient and the donor. The act, lordship sees the act, near relative has been defined. Son, daughter, something. The act is there. Kindly see section 2R. Yes, sorry, section 2, section 2I. I defines near relative. Near relative means spouse, son, daughter, father, mother, brother, sister, grandfather, grandmother, grandson, or granddaughter. But this is a case where, my lord, the donor is not a near relative. If the donor is not a near relative, my lord, it is not possible for the recipient or the donor, my lord, to corroborate the relation between both of them.
Yes.
But the Supreme Court has now held that, my lord, if it is on account of love and affection between two parties, and if it is on account of humanitarian ground, then, my lord, the application jointly filed by the donor and the recipient should be allowed by the authorization committee.
Yes.
And that is, my lord, even apart from that, my lord, what they have done is, my lord, my application was there.
Yes.
Yes, now, my lord, kindly see, my lord. I'll just take your lordship through the report that was submitted on the last occasion. The report which contains of 10 pages. My lord, the last document which is at page 12.
Who has submitted this?
But this was filed by the state.
Now, where is the rejection order?
Yes, rejection order, my lord, the impugned order is in my writ petition.
Where is that?
My lord, page 63. Page 63, 19th of June 2026.
Yes. Information pre-revisions not recommended by state committee at the board meeting on the basis of the unfavorable report from the district level verification
committee.
Status report at board committee has already been published. Where is the state committee?
Yes, kindly takes, my lord, the previous page, page 62.
Yes.
This is the, my lord, state level authorized, my lord, this is the notice that was published, status report. My lord, kindly say, I am serial number 9.
Yes.
Yes, Rabindranath Tagore Hospital, I have not been recommended due to unfavorable report. Now, my lord, their case is that there is an unfavorable verification report given by the state level verification committee.
Correct.
Now, my lord, the verification report, lordship will find, my lord, what they have done is, my lord, kindly first takes, my lord, page 10 of the report submitted on the last occasion, which comprises of 12 pages. Page 10.
Yes.
My lord, page 10, my lord, is the document issued by the, my lord, district inspector.
Page?
Page 10 of the report.
Issued by the deputy superintendent.
Yes, my lord, it was, yes, deputy superintendent. He forwards an inquiry report.
Correct.
The inquiry report is at page 11,
Yes.
which was prepared by the district intelligence officer. Now, my lord, page 11, my lord, kindly see what he says. With due respect, I beg to inform you that as per your kind order, I have inquired the matter. During inquiry, I had been to village such and such to inquire the matter physically. During inquiry, it is revealed that there is no blood relation between the donor and the recipient could be established. But I am not it's a non, so blood relation is irrelevant. No possibility of official dealing could be established. Nothing could be established. My lord, in fact, my lord, the inquiry report, perhaps in my humble submission, is, if I may use the expression, vague. So far as the facts and circumstances is concerned. Now, my lord, kindly comes to, after this January 2026 report, my lord, there is a verification committee's report at page 9, which is 15th of May 2026.
Yes.
This is only one page report, 15th of May,
Yes.
page 9.
Yes.
Yes, my lord, kindly see, here, my lord, towards the bottom, it has been indicated that my case has not been recommended. My lord, after the box. The reason is because, kindly see, it is not clear how both the parties came in contact and became family friend or driver. No documentary evidence or any photograph was produced. Hence, link between both the parties could not be ascertained, hence not recommended. But the issue is that since link was not established, that is the reason why the case of the donor willing to donate an organ for the benefit of the recipient has been rejected. Now, this was forwarded at page 8 on 20th May 2026.
Yes.
20th May 2026. Now, my lord, kindly see what the Supreme Court has said. My lord, it cannot be the case of the
Kindly come to the
today's report.
Yes. No. This order said the section 7.
Section
Rule 7. Rule 7.
Rule 7. Yes. Authorization committee. Yes, there is a. I have seen that rule, my lord. There is a. Towards the bottom, it says. Is your lordship on, my lord, rule 7, sub rule 3, Roman.
Sub-rule 3, Roman, first you come to the Roman 3.
Yes.
Roman 3, examine the reasons for the donor wishes to donate. Correct. And Roman 2.
Sub-rule 3, lordship is on.
Yes, 7, sub-rule 3.
Yes.
II.
Yes.
Prepare an explanation to the link between them, the circumstance which led to offer being made. First is this. Correct. Commercial, it is okay, it has come. Then III. Examine the reason why the donor wishes to donate. Correct.
Yes.
Then examine the documentary evidence of the link, that is a proof they have lived together.
Yes.
Correct. Then examine old photographs showing the donor and the recipient together. And elevate there no middleman taught or involved. That is the police report is there. So first you have to 2, 3, 3 III, and 4.
Yes. Now, my lord, kindly see, my lord. But perhaps this provision, my lord, some compliances of these provisions is not possible if it is non-near relative. Not kindly see what does it say. II Roman 3 Roman 2 3 II prepare an explanation of the link between them and circumstances which led to the offer being made.
Correct.
Next one says examine the reasons why the donor wishes to donate. Not I have given the documents in respect of that so far as Roman 3 is concerned. Now Roman 4 says examine the documentary evidence of the link that is proof that they have lived together. Not if it's a non-near relative, but they cannot live together.
No, not live together. It's okay, not live together. But see, if you X is a good friend of Y.
Why? Yes.
So there was some marriage program, birthday program, or the family relation. There will be some photographs. So
Yes.
that is so that how you prove the link.
Yes, link. Well, I
Otherwise,
understand.
tomorrow anybody will come file an affidavit and stating that yes, I am willing to donate my organ without any without any financial benefit. So that's why this rule is to be followed.
Yes,
So-
yes, I follow.
So that's why now their report is also there. No financial. That's why this court has called with regard to non-financial that the police has to see whether the financial
Absolutely.
is
But
not.
I'm grateful.
With regard to the linkage, you are telling that you are a best friend. If you are a best friend, so how something is to be proved. Either some of the witness has to come. Yes, I know. Then they are the persons and they are the good friends for the last several years, or the photographs, or any something.
Yes.
So that
To establish the genuinity.
genuinity. That's
To
all,
establish
nothing
the
else.
genuinity.
That is the thing.
Yes, now, Mulad, kindly see, Mulad, there is, Mulad, I have seen, Mulad, the Supreme Court has said that perhaps the only reason for which this act and the provisions have been brought forward is to ensure that there is no commercial dealing. Mulad, that is of paramount importance.
That's why I call the specific
Yes,
report with regard to
absolutely.
because I cannot call the report from the police with regard to linkage. Linkage has to be proved by you only.
Yes, Mulad,
Correct.
kindly see my application, the application that I have submitted, that is Form 11. Form 11, my application for transplantation is, your lordship will find that page 26 of my writ petition.
Yes.
Yes. But kindly see, this is the joint application filed by the recipient and the donor.
Hmm.
But kindly see towards just after the blanks are filled with their names and addresses. But kindly see B. By reason of affection, attachment, or other special reason as explained above, on humanitarian ground, being a family friend. But this is the only reason, family friend. Now, Mulad, kindly appreciates, Mulad, it might not be possible for a person to establish the link of a person who will be his family friend. But the example that has been given under Roman 4, 3 Roman 4 is that proof that they have linked together. Two families, they might be friends, they might be staying or residing in two different cities, but still they might be friends. It is not possible for one family or the member of that family to prove that they have lived together. Because if usually they are two different families, the usual thing is they will not live together. X stays with his family in Delhi, Y stays with his family in Mumbai. Now, X and Y are family friends. Now, there will not be any possibility.
That is a proof that live together. That is the example.
Yeah, that's an example.
That is it. That is not the mandatory.
Yes.
That is easy. That is easy being that is the as an example.
Yes, yes, I follow. My lordship is on that I have to establish a link to establish the genuinity that the donor is a genuine person.
Yes, actually you are having the good relationship with the recipient.
Recipient, yes. Mulad, kindly see, Mulad, the Madras High Court judgment. But this is reported in 2024 SCC Online Madras 1633. But I am only on this, Mulad, that these rules to find out Mulad, lordship will see Mulad the genuine approach, whether it's a genuine attempt on the part of the donor. But Mulad, a non-pedantic approach should be applied because there is grave urgency. Kindly Mulad, see paragraph 17 once of this Madras High Court judgment. Yes, Mulad, kindly before that, Mulad, kindly see para 14 once. Before para 17, para 14. But I'll just place para 14. I am conscious of the decision of the Honorable Division Bench of Bombay High Court reported in 2012 SCC Online Bombay 64. It was held that where the donor and the recipient are shown to be near relatives and the case does not fall under any of the three exceptions set out in section 9(4) of the Act, the authorization committee has no power to make further inquiry about the motive of donation because in such cases there would be no commercial element. After so holding, the learned judges went on to observe that where the donor is not a near relative, the burden is on the applicants to establish the real intention by placing relevant material for consideration of the authorization committee, and a heavy burden lies on them to establish. Now kindly see para 17, which is at PDF page 10 of the judgment. Let us put ourselves in the shoes of the applicants. They can only assert that there is no commercial dealing. They cannot be called upon to prove the negative. Rule 17 provides for scrutiny of application. In case of doubt, explanation can be sought from the applicants and there can also be verification done through the officials of the government. Too much of burden cannot be laid on the shoulders of the applicants unless there is a definite material to establish that there are financial dealings involving the parties. Permission ought not to be withheld or rejected. If the donor states that out of love and affection he or she is making the donation in the absence of any credible reason, the averment should not be doubted. The government must come out with definite guidelines in this regard, otherwise the issue will be left to the arbitrary discretion of the authorization committee. If the recipient is well placed and connected, the decision of the committee will swing in his favor. If the recipient is not at all, if not all that influential, by passing a template order, permission can be rejected. One must take note of the fact that Parliament never intended to rule out donation by non-near relatives. The parliamentary intent ought not to be frustrated by adopting a rigid approach. One need not take a cynical view that a non-near relative will not donate out of altruistic considerations. But this is Malad. So Malad, two submissions Malad. A non-pedantic approach should be Malad applied in these type of cases.
Yes.
This is number one. And second, Malad, this judgment Malad clearly says that whenever the donor asserts this positive statement that it is on account of a humanitarian ground or on account of love and affection, Malad, the averment or the statement of the donor Malad should not be doubted. Here, Malad, the police report, the police verification, all stages Malad are clean, Malad, and your lordship has seen Malad that there is no financial implication involved at all. If Malad, there is no financial implication involved in the matter, Malad, but in my humble submission, the application for transplant of the kidney, Malad, should go through. Relevant paragraph. Yes.
Yes.
Yes, Malad, kindly see what the Telangana High Court has also held. Malad, I have found one more judgment. Malad, this is Malad, all the whatever I have found, Malad, it goes on to hold, Malad, that once, Malad, kindly see Malad, paragraph 29. Many judgments have been considered. Kindly see page 9 of the judgment, page 9, paragraph 29. Page 9, towards the bottom, Malad, you will find the page number, page 9 of 11. Yes, para 29. Malad, the quintessence of the above judgments is that the authorization committee has to inquire.
Para 29.
Para 29. Malad, page 9 of 11. Yes, Lordship will kindly take this.
9 is not here.
I'm so sorry, Malad. Kindly take this. Where is the?
Yes,
Yes, kindly, I have only one copy. I'll just
take this, but page 9 is not there.
please. I'm so sorry, it's not there.
Yes,
Kindly gives me one moment. Yes, kindly see page 9. Yes, the quintessence of the above judgments is that the authorization committee has to inquire whether there has been a commercial transaction between the donor and the recipient. If the result of the inquiry is in the negative, then evaluating the evidence on
that
record.
is with regard to the finances.
Yes.
There's no dispute at all.
Yes, the
But
approach
with
of the
regard to the how, with regard to the relation linkage, how it can be,
this
that
is
is the only.
yes, but
Madras High Court has dealt with, but it has not been elaborated. So how the linkage? Because see, even police authority, you will go and you will say, if police examine you or the committee will examine you, they will say yes, we are the good friend for the son. So for the 20 years, 7 years, 5 years, whatever it is, how you can link that 7 years relation with both
I have to
recipient and the
corroborate
donor?
the relationship
Yes,
between the
that is
donor
how.
and the recipient.
How?
Or may I then come back tomorrow, Malad? I'll just see
How?
if I find out some.
Because it is not the quasi-judicial proceeding.
Yes, I understand.
The
I follow.
evidence and all these things is to be done. So how it can be?
No, I've seen that provision, but even I was a bit surprised to see that to establish the link between the donor and the recipients when they are non-real relatives.
Non-real relatives, it is not totally bar.
Yes,
but
I have to establish or
some
corroborate it
stat-
with
some
material
co-
evidence.
Some material evidence
Yes,
is
I'm grateful
required.
for that. But may I just
That
come
is
back
only-
tomorrow?
That is the only, because on the first day, the with regard to the commercial transaction, there was no clear-cut report. Now the police has submitted
Yes,
with
yes,
regard
now the
to
police
that.
has given
There is
it.
no commercial transaction. Now with regard to the linkage, the police again said that the photographs, because they are going by the rule 7, rule 3.
Yes.
So, but you have to establish.
Very well. May I do this? May I come?
Have you executed an affidavit before the executive
Yes,
magistrate?
those documents are there. Yes, those documents are there.
Come.
Kindly see page 47 to 50.
So then it has to be examined whether that is be taken as an evidence.
Yes, Lordship,
to the best of knowledge and the true.
Yes, kindly see page 47.
Yes, I have gone through.
Yes, kindly see, this is the affidavit of the respondent number 7 donor. Kindly see the next page. Kindly see paragraph 3, that I would like to donate my kidney to Chintu Khada, aged such and such, son of such and such. As far as the arrangement for the donation of my kidney to Chintu Khada, son of such and such, the same has been effected directly between me and his. Paragraph 3, he says that the donor is donating out of her own will and volition.
Yes.
Now kindly see paragraph 5. Paragraph 5, that I am donating my kidney to Chintu Khada, son of such and such, out of compassion, without any pressure or financial consideration, solely to save a needy person.
Okay.
Now, the donor's father has also affirmed an affidavit, which your lordship will find at page 50. Page 50. This is the donor's father. Kindly comes to page 51. And kindly see paragraph 3.
Donor's father.
Donor's father.
What is the age of the donor?
Donor's age is 39 years. And donor's father age is 71 years.
39 years. Expressing no objection to the donation of the kidney by my daughter.
Yes, father has given a no objection that
Yes.
yes.
No.
And Lordship will see paragraph 3, 4 and 5. 3, 4 and 5 at page 51. The father is well aware.
Yes, I've gone through that.
Yes. And in fact, most importantly, your Lordship's order that we have found out, Lordship has delivered a judgment on identical facts and circumstances, page 64.
Yes, paragraph 10.
Yes, in fact, paragraph 12.
10 starts.
Yes,
with regard
10 it starts. On humanitarian grounds, Lordship has categorically found out, Lordship's finding is at para 12. The authorization committee has refused the request of the petitioner only on the ground that they have submitted an invoice of 2019 that papers to be freshly prepared, manipulated and this court fails to appreciate that once the donor has given an affidavit, though it was executed before the learned magistrate stating the fact that he is the well-wisher of the patient and intends to donate his organ only to save the life of the patient, and during the police verification also did not find any financial transaction has been made, but the authorities in flimsy manner has refused the request of the wife of the petitioner for giving the authorization for transplantation of the organ. So, I think, what your Lordship has held that once the donor or the donor's relative, affirms an affidavit indicating their readiness and willingness to show that there is no undue influence or any coercion involved, but I think, the application for transplantation of the organ, should go through.
Correct. Okay, you think on that point.
Yes, I'll come back tomorrow. I'll
come tomorrow.
I'm told tomorrow might be a holiday. May I come back on Friday? At the top, if
I don't know how the court functions. Like this, all the times you will take the resolution. Counsel for the state has filed report. Let the same be kept in the record. Learned counsel for the petitioner prays for time according to adjourned. Let the matter appear tomorrow under the same heading. Yes, next.
Okay.
And the affidavit of service, my lord. This relates to the fraudulent declaration.
Just a minute.
I'm sorry.
एकटा काज करो ना हमारे चमरे पठिए थे बुक के साथ भेज दो. Yes.
This relates to my lord the fraudulent, incorrect, if not fraudulent, authentication of my.
Appearing for the respondent.
I've served, my lord, all. The bank has refused service. It has come back.
Bank refused.
Bank refused.
Which bank?
Indian Bank. Office at India Exchange Place, not half a kilometer away. And the affidavit of service, may I just hand over, my lord, the principal respondent has received. That is, my lord, the respondent number 1. Indian Bank has refused. It's very strange that a bank refuses service. Even I was surprised. The envelope has come back saying refused.
10/7.
On 10th of July.
IBFC received.
IBBI has received. And my lord, primary respondent who is answerable is, my lord, respondent number 1, National E-Governance Services Limited.
You through mail, it's sent by mail.
Sent by, my lord, speed post. My lord will find page 5. The letter is at page 4. Now they give this thermal receipt.
Yes, yes.
Page 5, your lordship will find.
Yes, what is the matter?
My lord, this is incorrect authentication of a debt as authenticated by me. I am the guarantor. Your lordship had occasion to deal with this in another matter, my lord, I've seen. I am the corporate guarantor of a company which availed of a loan. My lord, against me is
You are the corporate guarantor.
corporate guarantor. I am not the principal borrower. It's a group company. It's a group company. I am a corporate guarantor. of this company which has availed the loan. Now, my lord, the proceedings were initiated not against the principal borrower. Proceedings against principal borrower have not been initiated. Initiated against me before the Honorable NCLT under Section 7 Financial. Now, my lord, with the amendment of the IBC, your lordship is aware they have to file a proof of debt which is recorded with an information utility. Respondent number 1 is such information utility. May I just hand over, my lord, I've prepared a short list of dates which will show that on 3 occasions, this one more you have. Anyway, my lord, on 3 occasions, they filed the Section 7 application, it did not have. Then they sought time to get this recording from the information utility. Time sought, time adjourned, not filed. On the 3rd occasion, they filed. From that, I come to learn that I have purportedly authenticated the record of default by the information utility. So the procedure, as your lordship is aware, the financial creditor uploads the debt with the information utility.
When it was uploaded?
It was uploaded, my lord, on 29th of April. 29th of April, they uploaded it. Now, my lord, on 5th of June, they give me a supplementary copy in the NCLT proceeding disclosing the certificate of default issued by the information utility, which says that I have authenticated, admitted, accepted, acknowledged this debt. When the Section 7 proceeding is already pending in IBC, Section 7 proceeding is filed on 29 January 2026. All this while, they don't bring this certificate. On 5th of June 2026, they bring this certificate showing that I have authenticated debt and default. This is it's very suspicious. I would never do that because it's automatic admission. Now, my lord, what is interesting is if your lordship kindly sees ex facie, my lord, there is no. Where my papers gone? If your lordship sees now the information utility regulations published by the IBBI, which have the statutory force, because IBBI is the rule-making body, they provide that the mode and manner in which it is to be communicated to me. The first is, if I am a registered user with the information utility, it goes straight to me. Second is, if I am not a registered user, it has to go to the registered email address given in the MCA portal, which is my master data. Here, my lord, that did not go. And the regulation is very clear. It is only failing which it goes to the address given by the bank. Now, kindly have my petition once, please. Bank knows what is the email address. Kindly have my petition.
So when you received the information?
I received the information, my lord, when on 5th supplementary affidavit filed on 5th of June, then I received this information. I wrote to the information utility on 22nd June that you give me proof that I have authenticated this. You have filed an incorrect certificate.
So you have taken that on the back date you have authenticated?
No, authenticated correctly, but I have not authenticated.
That's why you're telling that on so and so you authenticated.
Yes, not back date, but authenticated currently, but actually not authenticated. Not authenticated by me. And I have raised grievance with the information utility. I have filed complaint with IBBI. There is no response by the information utility. Kindly see once, please, my lord, the Section 7 application which the bank files. Because today, my lord, I will only show your lordship, my lord, what is the incontrovertible position, because they are not appearing. So I, my lord, owe a higher duty to your lordship. Kindly see page 55 of the petition. I am Simoco Telecommunications South Asia Limited. This is my master data which the bank annexes to the Section 7 application. This is part of the Section 7 application which starts at page 24. 24 is my Section 7 application. Now, part of that is my master data as on date, annexed by the bank in the month of January 2026.
So they have disclosed in their Section 7 application with regard to the master data.
Yes. Now, my lord, kindly see email ID. Your lordship sees sanjay.ghosh@simoco.net. This is my email ID as per master data. Bank is aware of this. Sanjay.ghosh@simoco.net. This is the registered email ID of which bank is aware. Now, my lord, kindly come straight to what is the information which is now given. Kindly come to page 424, please, my lord. This I receive as and by way of a supplementary affidavit.
424.
Yes. starts at 414 is the supplementary affidavit. Kindly see the date of the supplementary affidavit, 5th June 2026. Section 7 filed in January. This is a supplementary filed in 5th June. I have already appeared. I know this proceeding is pending. Kindly come to 424, please, my lord.
Yes.
This is the certificate or record of default issued by the respondent number 1. Kindly see, issued by information utility under sub-regulation 4 of regulation 21 of the regulations. Now kindly see, I am not concerned with this because this is name of corporate debtor, modern Mobitech. Kindly come to the next page once, please, my lord, how this is done. Kindly see 425 once.
No, this is with regard to corporate debtor modern.
Yes, I am not modern, but I am just showing your lordship, my lord. I am just showing your lordship how this process is to be done. Kindly come to 425, please, my lord.
Yes.
Email ID, your lordship sees there, please sit down. info@modernmobitech.com. Now kindly see alternate email ID. This is all information given by the bank. Kindly see alternative email ID.
Where from your?
At the bottom of page 425.
That's ultimate, yes.
Yes.
Prosenjit.
Prosenjit Mukherjee at Simoco. Kindly note, my lord, simocosystem.net.
Yes.
This is the alternate email ID of the borrower. Corporate debtor. I'm sorry, borrower, the principal borrower. I am Simoco Telecommunication South Asia Limited. This is the email ID of one Prosenjit Mukherjee, simocosystem.net. Now, this is as far as the principal debtor is concerned.
No,
now, kindly turn to 426.
No, 424, that is the Form D.
Yes.
Correct. That is in the name of the modern Mobitech.
Yes.
Correct.
Kindly keep that aside.
That is the corporate debt.
I am not. He's the principal borrower.
The principal borrower. Correct.
Kindly
Now
see that.
the 425.
Yes.
425 is connected with that only.
Yes, your lordship is right. 425 is relation to the debtor is debtor.
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 Correct.
And your lordship only makes a note of the email ID once, please.
Email ID Prosenjit Mukherjee.
Grateful. Now kindly turn over to 426. Now this is me, guarantor.
Yes.
Simoco Telecommunication South Asia Limited. Kindly see email ID.
Yes.
And this is not the email ID given in the MCA data. Regulation.
So they have taken the another email ID.
Yes. I have admitted that this is the email ID of my director. I have admitted. But my director is not the person who is competent to authorize or authorized to admit this, because the regulations say that it has to be sent to my email ID. Now kindly see the regulations of 2024. This is now the regulations. How it is to be done. Kindly come, your lordship has. This is the regulations amended up to 13th August 2024. Now, this regulation was subsequently amended on 2nd June 2026. I am giving that also to your lordship for your lordship's record. But this is not relevant because the 24 regulation was prevailing. The June regulation had not come in. But there's no difference. That is why I just gave it for the completeness. Kindly now see the 24 regulation once. Kindly come to 21. Authentication of default. Your lordship has a 24 as on 24.
Yes, yes.
Kindly have internal page 18, my lord, the numbers at the bottom of the page.
Yes.
This is authentication of default.
Yes.
Kindly see 21. 2. For the purpose, so one is an information utility, that is R1, shall expeditiously undertake the process of authentication and verification of information and default as soon as it is received. Now, for the purpose of self-regulation 1, the information utility shall deliver the information of default to the debtor, seeking confirmation of the same within 7 days. Remind the debtor at least 3 times for confirmation of default in case the debtor does not respond, not relevant. Now, kindly see C, very important. Deliver the information of default or the reminder as the case may be to the debtor, either by hand, post or electronic means at the postal or email address of the debtor. First is registered with the information utility by him. I am not registered. He admits I am not registered. So failing which, it is, now kindly see 2, recorded with MCA 21. This is MCA 21 is the second. and the Sursai registry as repositories or any other suppository. So nothing of this is done, failing which submitted in Form C of the schedule by a financial creditor. So without exhausting 2, you cannot go to 3. The language is very clear. Failing which?
Failing which by financial credit.
Okay. So financial creditor has given this information. It is misleading because he knows my MCA 21. He has himself disclosed that in the month of January. Now the information utility owes a duty. Kindly now see 21A. Kindly see the dereliction of duty by the information agency now. 21A1. Where 21A reads verification of information before issuance of a record of default. An information utility shall verify the key details such as email address of the debtor. If the information utility is cast a duty to verify my email address, it should have gone to the MCA portal and verified my email address. It would have not found this email address. Document showing proof of debt, etc., etc., before issuance of record of form of default in Form D. And then I am given an opportunity, Malad, also to dispute the default, which is it 2. So information that
is subsequent.
That is subsequent. But here I have not received intimation because he's gone and given it to somebody else who is not there in my MCA. And this as at 426 your lordship has seen. Now kindly see at 427. Now kindly compare with 427. What is the procedure? Because that procedure they follow in case of the principal borrower. Kindly see 427. Communication details your lordship has.
Yes.
This is in respect of the principal borrower who is shown as the debtor. Kindly see email category MCA.
Yes.
So first they send to MCA. The email registered with MCA. The mail is delivered.
So it is gone to the personage.
Yes. MCA, because that is the MCA. Then Form C, primary info at modern Mobitech.
No, then email category MCA.
That is the email address of the debtor recorded with the MCA.
Correct.
And they have delivered it. So that is why they are following the procedure given in 21.
No, then the MCA.
Yes.
So mail type initial. So the address is same thing. Prasanjit Mukherjee.
This is of Mobitech, not me.
Achha, okay.
Kindly compare. This is of the debtor. Now kindly see the treatment meted out to me. Now kindly come see the treatment meted out to me, where they show the communication given to me. Kindly come to 430, please, my lord. Lordship has 430.
Guarantor.
Yeah. Now, my lord, kindly see communication with other party. Simoco telecommunication. The petitioner guarantor. Form C, primary. No attempt to serve on MCA.
Yes.
This is, my lord, the long and short of it. The procedure known in law is not followed. My lords have repeatedly held if an act requires something to be done in a particular manner, it has to be done in that manner, otherwise not at all. Now, I have raised, well, may I just, one formal, may I cite, my lord, this is since AIR 19, since 1918 Privy Council, this has been the law. Kindly come to here, payment of compensation. Kindly come to paragraph 14. The remedy for failure to pay interim compensation is thus provided. The method and modality of recovery is clearly delineated. It is a well-known principle that if a statute prescribes a method or modality for exercise of power, by necessary implication, the other methods of performance are not acceptable. While relying on the decision of the Privy Council in Nazir Ahmad, bench of 3 judges said, where a power is given to do a certain thing in a certain way, the thing must be done in that way or not at all. Lordship sees the italics, pass it on B.
Yes, got it.
So here the thing which is required to be done is you have to serve on the MCA address, registered address. If it fails, then you go to the next, which is given by the bank. Bank knows my MCA address, bank does not serve. I, my lord, raised grievances about this promptly. Kindly see my letters, my lord, all of which are not replied to.
What is your prayer?
My prayer is, my lord, that this declaration, this record of default should be quashed.
Where is that?
Kindly come to page.
Where is your default declaration of default?
This is that form D, your lordship saw, my lord, 424. I'm sorry, 424 was of the borrower, principal borrower. Mine is at,
Where is your,
beg your pardon, Miller.
where is your,
Fred?
where is your communication?
I'm so sorry. Kindly have page, annexure P4 at page 454. Because it provides a process of raising a grievance also. And I raised that grievance. Urgent representation recording the purported authenticator status. And kindly see paragraph 4 at the next page. Four and 7. He is an independent director in my company. Kindly see 7. Prosenjit Mukherjee is a director of Modern. The principal borrower is not authorized to receive communications. Simoko, he merely happens to use an email ID, which is a shared domain, does not hold authority to respond, merely being an independent director. He's not an executive director or a promoter director. So the fact of the matter is, my lord, they have shown it as authenticated, which they could not have. And paragraph 23, I have called upon them to change the status at page 459. To which there is no response. Then the reminders are sent at 461 onwards. Again, and then a complaint is made to IBBI also, because the IBBI is the parent body. At 474 is a complaint made to IBBI against the respondent number 1.
474.
Yes, my lord. IBBI is also not acting upon the complaint. But this is fairly recent. Page 470, if your lordship wants to see. Well, my final relief which I seek is a certiorari quashing this.
Where is which document you want to quash? Where is that?
That is the authenticated document.
That is where is the authenticated document?
At 424.
No, 424 is the 424 of the creditor.
Well, this is the only authenticated document.
It's the only.
Yes.
It
records. No, it doesn't. It records of all, because if your lordship sees, it continues.
So this will also give the benefit to the borrower also.
My lord, kindly limit it only to me. Kindly clarify that.
How it can be the single formed in with regard to the both? Because it's a corporate debtor, not the guarantor.
But this is the only document which they've disclosed along with their supplementary affidavit in my regard. So this is their supplementary affidavit.
Very sure that you have been authenticated.
Kindly see. It is all, my lord, communication with other party, your lordship will see.
That's correct. But page 426 is guarantor.
Guarantor.
It is given to you, but where is your authentication? Which date it was authenticated?
No, they've just shown this document, but I don't have any other document. Because this is part of the supplementary affidavit.
How you can say that you have been authenticated by the?
That is the allegation made in the supplementary. If your lordship kindly comes to the supplementary ones.
Nobody is appearing for the NACL?
NACL, nobody is appearing.
They can say whether they have issued any order.
Paragraphs 3 and 4, my lord.
Page
417. Starts at 417. Then paragraph 4, record of default. Financial creditor has obtained without prejudice the financial creditor has obtained the record of default issued by the information utility in Form D.
The financial creditor. What about the guarantor?
He is the, I am the, in this proceeding, I am the corporate debtor, he is the financial creditor. He's saying, kindly see, without prejudice, financial creditor has obtained the record of default issued by the information utility in Form D, wherein the status of authentication of default is recorded as authenticate, thereby independently corroborating the existence of default.
The record of default duly established default, the date of default is.
The date of default for the corporate guarantor is 17th April when the guarantee was duly invoked. So he's using this certificate for both.
Guarantor to the principal borrower.
Yes, that is me, the petitioner before your lordship. Date of default for the corporate debtor.
Let the NESL come, then.
Let them come, my lord. Kindly grant me limited protection only to limited to me, my lord.
For what? But there is no, I don't think how it can be with the one form, both will be affected.
My lord, because
authenticated.
This is the authentication they're relying on. Kindly see the orders which I handed over a list of dates. This is what they filed pursuant to these orders of court.
That's correct, but how? With regard to the corporate debtor and the guarantor, how it can be a single authentication?
Kindly see page 409, please, my lord.
Relying upon then
they are relying upon this. That is what is issued. And to me, my lord, ex facie, my lord, kindly only appreciate this. The service of notice to me is bad.
Which notice?
These notices, my lord, the service of notice of default on me.
Correct. That's why this is so with regard to the corporate debtor. That is the problem. That is not totally.
Because if your lordship sees 430, please, my lord.
That is a communication.
Kindly give me a minute. Right. One second. No, but that is the form which is filed.
Yes.
It cannot be one authenticated with both corporate debtor and guarantor. It can't be.
It seems to be that, my lord. Kindly see 440.
It seems then if they said that it seems there and now it has to be.
It has to be, my lord, because that
but it has to confirm, but they're not appearing.
They are not appearing, my lord. Kindly
One
only.
advocate is appearing in the matter.
Yes, my lord, I'll show your lordship the order which was made by lordship in another matter, similar circumstances. They appear yes, if your lordship so desires. And my difficulty is this: this supplementary affidavit they filed, and now the matter is kept for hearing on 17th.
17th of?
On 17th of this month, which I have stated in para 25 of my petition. That is rushing, my lord. The document which has not been issued in accordance with law is being relied upon. You see paragraph 25 at page 18. There is tremendous, may I just place it, my lord? There's tremendous urgency in the matter in view of the fact that before the learned NCLT, Section 7 petition under the IBC is now listed for hearing on 17 July. Okay. But let this document not be relied upon qua me. That is all that I say.
The petitioner has filed the present application. Where is the prayer? Just a minute. Where is the prayer?
Prayer is at page 27.
27, 22.
19, I'm sorry, 20. I'm so sorry, 20.
Passing and setting aside the impugn form D. The same form 1424. That's your.
There are 4 forms like this, my lord, for each of the accounts.
No, the prayer A, which that is the
yes,
424.
Yes.
The petitioner has filed the present application challenging the form D. Form D, wherein the status of authenticated of default has been recorded as authenticated on what? When it was authenticated, what is the date?
My lord, authentication 31st May
31st of May 2026.
At 5 a.m. in the morning.
2026. Full stop. The petitioner, Mr. Thakkar, under senior advocate, submit that the respondent number 2 bank has filed super aega. The petitioner has filed the affidavit of service, but in spite of service of notice, none appears. But the respondent number 2 has refused to accept the notice. Okay, na? Good. The respondent number 2 filed a petition under section 7 of the Insolvency and Bankruptcy Code 2016 against the petitioner as corporate guarantor before the NCLT, Kolkata, without disclosing any record of default and carving due to rely upon the NESL certificate at the time of hearing if required. The NCLT police, on receipt of the notice, the petitioner has appeared before the NCLT. The respondent number 2 filed a statement of the alleged default information with the respondent number 1 for the first time, well after the institution of section 7. The petitioner submit that in section 7 application, the bank has disclosed the MCA certificate of the petitioner, wherein the email ID of the petitioner is recorded as this Sanjoy bracket mein dot eta, page 55. Ghosh at Simco dot so. He submit that the bank had the knowledge with regard to the email ID of the petitioner, but the correspondence has been made to the email ID of prasanajit.mukherjee @ simocos system.net. He submit that the petitioner has not received any communication, but has uploaded the Form D with the status of authenticated on 31st of May 2026. Full stop. Had the learned counsel for the petitioner peruse the materials on record the full stop. On receipt of the said Form D, the petitioner has made representation to all the concerned authorities, but in spite of receipt of the representation of the petitioner, none of the authorities have taken any steps with regard to the representation submitted by the petitioner. Accordingly, the petitioner has filed the present application. The petitioner has prayed for interim order for staying the operation of Form D with regard to the petitioner herein as the learned NCLT as on 17th of July 2026. The proceeding is as the learned tribunal has fixed the matter on 17th of July 2026. But the learned counsel for the petitioner peruse the materials on record. This could find that the bank had the knowledge with regard to the registered email ID of the petitioner, and the same was disclosed by the petitioner in the section 7 application. But the authentication status has been forwarded, but the authority have communicated with the different email ID, that is the Prasanajit Mukherjee @ simocos system.net, which is not of the petitioner. Considering the above, this court the petitioner has further relied upon as per the Insolvency and Bankruptcy Board of India within bracket Information Utility Regulation 2017, which amended up to 2026. Which provides that an authentication default be delivered, provide that an information utility shall expeditiously undertake the process of authentication and verification of the information or default as soon as it is received for the purpose of sub-regulation 1 of the information utility shall deliver the information of default to the debtor seeking confirmation the same within 7 days and deliver the information to default or reminder as the case may be to the debtor either by hand, post, electronic means at the postal or email address of the debtor. debtor thus registered. It is further recorded that the record with MCA 21 and the Central Registry of Scrutinization Asset Reconstruction of Security Interest of India Registry as repositors or any other statutory repository as approved by the board, failing which by financial creditor, which is the bank, include the second schedule of the Reserve Bank of India. He submitted the authorities have not followed the same by sending the information to the petitioner in the registered mail ID, but have used the mail ID of the director of the petitioner. Considering the above, this court find that petitioner has made out the prima facie case and balance the convenience. Accordingly, operation of the impugned default authentication form D with respect to the petitioner is stayed for a period of until 13th of August 2026. Let the matter appear on 13th August 2026. Full stop. The respondents are directed to file their affidavit in opposition within 3 weeks. Reply, if any, they are to be filed within a week thereafter. List the matter on 13th August. Then 18th Corridor.
So directly for the petitioner. Well, on the last occasion when this matter was taken up, there was a proposal.
What has happened?
But we have rejected their proposal. We have rejected their proposal.
You have rejected the proposal.
Yes.
The proposal was same that to accept bid without in physical form. That was the proposal. We rejected it from the beginning.
What is the other proposal?
That was the proposal that we rejected in the beginning. So
Yes.
whereas it may be rejected this time.
Yes.
No, my lord, may we proceed with the matter because we have been troubling your lordship with this matter for quite a long time. So just a short recap, my lord. 2 or 3 documents, my lord, then my lord, I'll go back to my arguments. My lord, page number 352 is at the earliest point of time. Then, my lord, page number 358 is their first response.
300?
52 first, then 358. 58. No,
52.
252, 352 is my email. 358 is their initial response.
This is the first, your first email.
No,
352
my first email is at page 352.
Yes, 352 is the first email.
First email. With your lordship, note the time 2:06 p.m. on 28th of May. Where the bidding process concluded, or the bidding process concluded at 2 p.m.
Yes.
on that day itself. Within 6 minutes comes their first response, which is at page 358. Please take me at the second paragraph. One of our service experts will reach out to you shortly regarding your query complaint. 13 minutes thereafter is their second response, which is at page 359.
Yes.
Again, my lord, the third paragraph, we would like to inform you that we have checked. Bid has already ended. Also, there is no provision to extend the bid once the bid is ended. So proceed further accordingly on GM for future reference, etc.
This is sending by the GEM only.
GEM only.
Yes.
So these are, my lord, the immediate responses on their side.
Yes.
Then, my lord, on the same day, my lord, I give a detailed email, which is at 361, my lord, at 9:52 p.m.
Yes.
But there are 2 tenders, there are 2 matters before your lordship, my lord. This letter at 361 is for both the matters. But what is very important is, my lord, please take, my lord, 4th paragraph.
We immediately reported the issue to the GEM help desk as well as to the concerned authorities. Screen recordings with GEM customer support executive clearly evidencing the issue have been preserved and are enclosed herewith for your kind perusal. Now, what is very important is the next paragraph. It is pertinent to mention that the GEM help desk team remotely accessed our system through any desk for troubleshooting purposes and themselves attempted BIP submission multiple times. However, even the GM representatives encountered the identical issue repeatedly, wherein the portal redirected to the login page immediately after the OTP verification. Consequently, the GM support team also failed to complete the submission process successfully. Now, my lord, there are other letters. I will not bother your lordship with those. Now, kindly take, my lord, how they resolved the issue is at page 365. 358 and 359, my lord, are the immediate responses, and issue resolution is at page 365. We would like to inform you that a resolution has been shared to you for the raised concern, and we are waiting for your confirmation on the same. Kindly reply. Please find below the resolution details. We would like to inform you that we have checked. Bid has already ended, so there is no provision to extend the bid once again. So the response is, or the resolution is, that time has expired, no latitude. Then, my lord, after 4 days is another letter at page 371 from their side. It's identical. Third paragraph.
Yes.
Now, my lord, your lordship was pleased to, my lord, call for report, my lord, from both the respondents. Please have a look to, my lord, the report of GM, which has been filed. One Mr. Manoj Kumar has signed it.
A report of
Manoj Kumar, respondent number 4. Report by way of affidavit on behalf of the respondent number 4.
Yes. This is of respondent number 4, GEM.
Yes, my lord, GEM.
Yes.
But I will not trouble your lordship with the ECL one because this was operated by GM at that time. Please have a look to para 5. Upon conducting an examination of the records available on the GM portal, we found that there was no technical glitch on GM portal on 28/5/26. Pertinently, the bid was floated on 13/5/26 and the bidders had time from 13/5/26 till 28/5/26, that is approximately 15 days at 14 hours to participate in the bid. I firmly deny the averment made by the petitioner that due to technical glitch, he was unable to submit the bid on 28/5. It is submitted that there was no technical glitch whatsoever and no complaint regarding non-submission of the bid due to technical fault of the portal of the respondent number 4 was reported as such. I submit that in order to successfully participate in a bid, a bidder is required to complete each stage of the bidding process. Now, this is the embellishment. The contemporaneous letters do not say what is stated in paragraph 7 and 8 of the report. I humbly submit that in order to successfully participate in a bid, a bidder is required to complete each stage of the bidding process in the prescribed manner. In the present case, the petitioner was logged out of the system as it failed to complete a mandatory stage of the bidding process, as is evident from the video recording between 108 to 124 submitted by the petitioner to the help desk of the respondent number 4. Therefore, one thing is admitted, that at 1 o'clock 108 and at 124, Millard, I had approached the help desk. The aforesaid video recordings is annexed and annexed 1. It is submitted that the system is designed in such a manner that each stage of bidding process must be duly saved before the user proceeds to effect final submission of the bid. As evident from the video recording submitted by the petitioner to the help desk of the respondent number 4, the petitioner accessed the upload document stage of the bid submission process. However, it failed to save the stage and instead proceeded directly towards bid submission. Therefore, my lord, the final conclusion which your lordship would not find in the contemporaneous my lord, letters, that my client had failed to save each of the stage and then proceed further. But that is not possible because, my lord, if I cannot go to a subsequent stage without saving the previous stage, my lord, the portal itself will tell me save and proceed. A button remains that save and proceed, save and go to the next stage, something of that sort, which is not there. My lord, the help desk people who had also, my lord, on real-time basis, not subsequently, on real-time basis at 108 and 124, my lord, also did not tell me that you are not saving and not proceeding. Or since they had accessed my computer, my system, but they could have also, because the help desk is to help me, not to find fault. Anyway, but they also, my lord, did not contemporaneously say so. Therefore, my lord, 4 things, my lord, come out, my lord, from this affidavit or the report. Number 1 is, my lord, there is no denial that I had accessed the help desk on real-time basis. Number 2 is, my lord, there is no government over there that help desk asked me or advised me to save and proceed to the next stage. The third is, what is very important is, that save and proceed to the next stage, this procedure was also not, my lord, adopted by the help desk because they had had remote access to my system. Fourth is, my lord, as I have said, my lord, these are the embellishments. And, my lord, what is very important, my lord, this is not an expert who has filed this report. Kindly see, my lord, who has filed the report. Paragraph number 1. I am presently working in the capacity of the Deputy Chief Executive Officer. He is not a person who is controlling the system. System means, my lord, the internet or portal. Therefore, my lord, the fifth point is that, my lord, an incompetent person who is not an expert in the field has, my lord, filed the affidavit.
Yes.
So the variance is between what was said to me on 28th May and the report which has been filed on 16th of June 2026. But we had taken an exception to this. Please only note down the paragraphs, my lord. What I have said verbally, my lord, is pleaded over here. My lord, it's by Shyam Sundar Marodia. Yes, to the report of R4. My lord, may kindly take, my lord, please take, my lord, paragraph 8. 8 and 9. 8, 9, 11, 12 to 14. 8, 9, 11 to 14. So this is what, my lord, I have verbally submitted is, my lord, pleaded over here.
Yes.
Number in this, my lord, background of facts, my lord, my respectful submission is, my lord, as an intending bidder, my lord, the only right that I have at this stage is, or a fundamental right that I have is, that a right of participation. This is what, for what, my lord, I have come over here, that my right to participate,
yes,
has been snapped by way of some technical issue. Maybe their side, maybe our side, whatever it is. Let us not go into that. Number two, the fundamental point for your lordship's consideration is, my lord, whether fundamental rights, my lord, can be done away with for technical reasons. But as, my lord, the Delhi High Court puts it, my lord, whether fundamental rights can be overridden, my lord, by, my lord, technical issues. But I'll rely upon 3 judgments, my lord, very short. Please,
But the Supreme Court says if it is there's no fault on the part of the GEM authority or the respondent authority with regard to technicalities, so the burden cannot be put upon the respondents also.
Milord, it is not a question of their fault, subject to correction, Milord. Again, Milord, I cannot say the Supreme Court is wrong. But Milord, in a case your lordship finds, because my case is very simple and which is not denied, that Milord, contemporaneously I was Milord corresponding with or taking the help of the help desk.
Correct.
Now, if I can understand, Milord, that there were some glitches on my part, let us presume for argument's sake. Then also, Milord, the help desk, Milord, could have rectified it. The help desk also, Milord, could not rectify, Milord, whatever is the glitch, well, on whosoever side it is. Therefore, Milord, should Milord, my fundamental right go a-begging?
No, but the problem then again they have taken the plea. Okay, the help desk could have been given to, but you have informed about 206 hours. That is
Yes.
after the
Yes.
period is
Definitely,
over.
yes.
After the period is over, how far then they can continue this?
Milord, the point is, 2 o'clock it ended. 206 is my Milord first response.
206, yes.
Therefore, Milord, the first response may or may not, Milord, contain all the details. Because otherwise, Milord, I would have been hauled up of, Milord, delay in reporting to the GM. Therefore, I have to wait till 2 o'clock. And one can expect that within 6 minutes, when I have, Milord, contacted them, but it will definitely be a very short letter. It takes time to type it out. It's not that easy. But at least, Milord, I, as an intending bidder, will make attempts till the last moment. That is 2 o'clock. Therefore, there is only a time gap of 6 minutes. Now, please consider, Milord, whether this time gap of 6 minutes is such a long time that I could have gone to a lawyer, get it, Milord, drafted with skillful drafting, keeping all Milord points included in it and Milord given to it. Therefore, Milord, on the other hand, your lordship will find this is a case where your lordship will find that there are Milord improvements in the report which is not there in the contemporaneous records. I mean, and there is what is their case? Their case is not that my system is at fault. Their case is that I was at fault in not saving and going
not
to the next
saving
step.
that. Not saving that.
Yes. Now that was not also told to me by the help desk. They don't say that the help desk advised me.
Now the question is, what is the duty of the help desk? What is the duty of the help desk with regard to the process when the e-auction process is going on?
The help desk, Milord, as I understand, is to ease out, Milord, the difficulties.
So when the help desk is received,
10 according to
206.
No. 108 and 124. Oh my God. Well, this is what my understanding of the report. Please have a look at it once more, Milord. Subject to your lordship's correction. Para 7.
Para 7
of GM's report.
GM's report.
Please take away the third line. In the present case, the petitioner was logged out of the system as it failed to complete a mandatory stage of the bidding process, as is evident from the video recording between 108 and 124 submitted by the petitioner to the help desk of the respondent number 4. The video recording is annexed. Therefore, 108 and 124 I have submitted. The help desk could have told me, looking into the video recordings, that, sir, you are not saving it and going to the next stage. That's not there. The next paragraph doesn't say so.
Yes.
But the first response or the first two response on the same day doesn't say so. And in fact, the final resolution also doesn't say so. But please take just once moment. once kindly come back to Milord page number 365.
রিপোর্টটা অন্য রিটের পড়ছে না, এটা অন্য ওটা 3 PM এর রিপিটিশনটা পড়ছে না, রিপোর্টটা 2 PM এরটা পড়ছে। রিপোর্টটা এটা পেপার 2 PM, রিপিটিশনটা 3 PM। কোনটা 2 PM? 2 PM টা? আচ্ছা হ্যাঁ, তাহলে
Please take Milord page 365.
We have checked the bid already been ended, so
Yes.
no provision for extending the bid. So
Yes. That's all.
yes,
Resolution is that we cannot extend the time. Now these are Milord subsequently Milord which has Milord creeped in their mind Milord, now they are saying so. Now please have a look to my two decisions Milord. Kindly take note at Delhi High Court where Milord the facts are almost same. I mean the technical issues are almost same. Here Milord, the product of the petitioner over there Milord was published in the website for participation. Thereafter, Milord, the bid from the website, its product went away. Therefore, Milord, this dispute arose because could not submit their bid. But please take me paragraph number 2 in the second page, fourth line from the second page. The petitioner states that once the product published on the GM product portal, the bidder can participate and bid for the tender. The petitioner further states that on so and so 2 days prior to the last date of submission, suddenly the product of the petitioner, which was earlier published and being shown on the screen, disappeared from the portal. Therefore, Milord, disputed. Now, kindly see what was their response. Where at page 2 at the bottom, same as ours, almost same. Where at the bottom of Milord page number 2, dear sir, madam, we have received your request in our portal and we have forwarded our request to the concerned department. We shall be working with the concerned team to solve so and so. Then Milord, emails were sent. Now paragraph 7 is the response in the contemporaneous letter, and here same. Kindly see para 7. Respondent number 1 does not dispute the fact that there was a technical glitch at its end which disabled the petitioner from participating. The submission.
The respondent number 1 does not dispute the fact there was a technical glitch at
right.
their end. But
Right.
here yes.
Here also, Milord, there is no dispute. They have not said that there is some technical glitch at my end. Here, Milord, the subsequent in the report they say that I did not save and proceed. The submission of the learned counsel for the respondent is primarily that the existing technical system of the respondent number 1 does not permit it to receive any further bids once the tendering process is closed. Same as ours. Now, Milord, skipping over a few paragraphs, please take Milord para 11.
Yes.
In our view, the portal developed by GM should have the flexibility to deal with such like situation where it should be possible to override the system with the express permission of the highest ranking authority and under adequate supervision so that person who may have been left out from the bidding process for no fault of theirs due to technical glitch in the system are able to participate. We may also observe that time and again we are informed that in cases where technical disqualification of bidders is held to be bad by this court, the GM portal does not have the facility of opening their financial bids in case the financial bids of other qualified bidders have already been closed. This again demonstrates a lack of proper programming and anticipation on the part of the respondent number 1. The fundamental rights, where this is where I would like to lay emphasis, the fundamental rights of citizens cannot be sacrificed only because the system developed by the respondent number 1 has such limitations. It is for the respondent number 1 to remove. Now here the same thing is said that time has expired, therefore no further latitude. Delhi High Court, with respect, I would Milord, request your lordship to adopt the view of the Honorable Delhi High Court that how can you program things in such rigid manner that once the time ends, because there may be so many situations which may arise. But suppose when my electricity goes, take an example.
Nowadays, every gem is the creator now.
Yes, yes.
All
Every 10 days, one case is coming in the tender with regard to the fault of the gem.
the other case, my lord, I have not, my lord, made James as a party.
Now, the relief that has been granted by the Honorable High Court is made at para 15.
So on that day, I told the state advocates, I will go pass an order, the gem is to be closed, all the manual is to be.
Yes.
Yes.
But this is where what Miller, the relief that is finally granted in view of the above para 15. We allow the writ petition. The petitioner is permitted to submit its bid manually in a sealed cover, so and so, so and so. But the rest is procedural. Now, this is a case where it went up to the financial bid stage. Ours is a case where we are still Miller at the evaluation stage in the technical bid, as my learned friend had informed the court on the last.
Yes. Next. अच्छा ये क्या फिक्स मैटर है कि না না 12টা আছে তো আমি কি বলছি আপনার ফিক্স ম্যাটার আছে কি না fixed matter is there. Oh, 12 noon. Come tomorrow. Tomorrow is already.
I have no difficulty.
তোমার কি তুমি যাবে নাকি রত্তান্তে?
It's declared. Is there any declaration?
No, not yet. Well, your lordship will be knowing that. I think my learned junior has some personal problems rest of the week. Could it be Monday or Tuesday? Monday ka baat may it be, huh?
Because of the tender, I have only my concern.
I wanted to complete the fixed matter is there.
Yes.
Otherwise, I could have been completed. 2 बजे भी है.
In that case, may it be next Wednesday to please you. ঠিক আমার কোনো অসুবিধা নেই আমার জুনিয়রদের may it be Wednesday.
Wednesday. Land Council for the petition argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 22nd within 5 matters. The interim order is extended till the next date.
Well, may it retain its position in the list.
Yes,
first very good.
First 5 matters.
I'm grateful.
Yes.
Led by Mr. Bhattacharya and Mr. Dasgupta, my lord. This matter relates to the horizontal reservation of the persons with disabilities, my lord.
Yes, you've taken instruction.
My lord, I got it right now. But it appears, my lord, that there was, my lord, or there is a subsequent notification of 2016.
26.
Yes.
Pendency of the case,
Yes.
you have
I
rectified
would
that.
like to, my lord,
Are you
kindly, yes. Kindly give me some time. I will take instructions, my lord, because
My lord, with regard to the new notification, my lord, we have filed a supplementary affidavit.
Supplementary affidavit.
Yes, sir. Because ACTA grievance has been
26.
Supplementary affidavit. So,
I have solved.
Supplementary are not given?
Yes, my lord, I
okay. এটা তো অন্য অ্যাপ্লিকেশন এটা তো নয়
তো পাইনি তো
I'm telling you,
একটু দেখো এই কথা বলার দরকার
Learned Counsel, Learned Advocate General submits that he has been briefed in the matter, but he requests further time to.
Well, I appeared on the last occasion also.
Yes, but he prays for some time to take further instruction. According cases adjourned, let the matter appear on
19 বছর হয় একজন মেয়েকে ভালো লাগে না এই আপনি ইনস্ট্রাকশন এসে পৌঁছে এটা রাখছি আমি তোমার কাছে কপি আছে
আচ্ছা আচ্ছা আমার কাছে
নাকি তুমি রাখবে
না আপনি রাখুন আমার কাছে
18th August at 12 noon.
লর্ডশিপ আগে কমপ্লিট থেকে ডাকো বুঝলে মঞ্জু আগে থেকে ডেকে বসো।
Yes, next.
হ্যাঁ, organize করো।
Item? Yes. 1819 আছে? Yes, 20 who is appearing?
On behalf of the petitioner.
Petitioner? Additional Director General.
There
Wait.
is an application we have filed in Lordship where because the interim order had expired, we have taken out an application that is also appearing.
Yes. When it is going to expire? Today? Already expired? Yes. You are appearing for? You are appearing in person?
Yes, sir.
You are the respondent in the matter?
Yes, sir.
Which respondent?
So I'm the
What is your name, sir? Naresh Kohli?
yes, sir.
Yes. Yes, what is the matter?
That subsequent registration with MSME blood will not give any benefit to the private respondent. That's the case when they have.
Why the authority has filed? Why the police authority has filed the writ petition?
But that is the agreement was between this authority and this private respondent. And he has filed an MSME claim before the MSME tribunal blood. That is subject matter of challenge. We have challenged the jurisdiction of MSME on the ground that the agreement was executed. I'm sorry. Read by Mr. Judge.
That's pure question of law, whether or not an organization which was subsequently registered MSME can get the benefit of MSME provision
Only.
retrospectively. That's the issue. Now, there was an interim order at the stage. Today, we are here paying for extension of interim order.
Yes.
Yes, sir. Good day, sir. So I read somewhere that the courts of law are the first place of refuge for scoundrels and thieves. And that is exactly what Kerala police is, sir. And I'll tell you why I'm saying it, sir. And why I'm saying it, sir. They made us test the equipment, gave perfect results, after which they asked us to do certain other functions and made a hot pot. So we took them to the MSME Council. So 7 hearings spread over 6 months. Every time they would say, we will find a solution, we will find a solution. On the last occasion, they said the SP Telecom has gone on tour and give us 1 week more. So the convener said, I will not give you 1 week, I'll give you 2 weeks. But this time come back and make a final decision, otherwise I'm moving to arbitration. Last time they came back after 6 months, they say, the government has decided not to pursue the project any further. So the convener said, no problem, you pay the money and you go. So without even telling, they approached the High Court. Now, sir, that is on 9th of August 2024. Sir, in today's, what they've served me just now, they themselves are admitting that 2024 and 2026, 2.5 years almost, nobody can even decide a simple question whether an MSME has got registration after the execution of the contract, but before the supplying of the completion of the project, is he eligible? So there are multiple judgments. My previous lawyer, Mr. Rohit Banerjee, he has shown them to you. So he's shown you, I can show them to you again if you want. So there's nothing for you to decide, sir, except simple thing that whether I am eligible for registration as MSME, even though I have registered after the date of execution of the contract. That is the only thing, sir. 5-minute job, sir. Now, and sir, put yourself in my position, sir. These people are big giants. Banks are giants. Small MSMEs, they can put us like this, grind us thing till we break. And I'm broken. I'm bankrupt. The bank has taken, I'm forwarded in the bank, they've taken my property. I'm living in a rented property and that rent is expiring on 31st July. So because I'm an SME, MSMEs moreover, sir, are all owner-driven companies. So you destroy the company, you destroy the owners and their families.
Yes.
Sir, don't allow.
Who is
sir-
appearing for the micro small MSMEs?
Pardon, sir?
Who is appearing for the MSME?
Shamrat Sen was appearing late.
In the past, in the previous panel,
Now you are appearing.
Milord, we can appear, Milord, if Milord.
You are the main person.
Yes,
We have
we
to.
can appear.
You have to address this court.
So, Milord, let a copy of the application has to be served.
Sir, I shall be serving.
You, sir.
Sir, I'm mad. Sir, I'll give it to her just now if you want. This petition you want?
No, the
No.
total petition.
No,
there.
I shall be.
He will give
Writ
it.
petition along with all doc. You have filed the affidavit.
Yes, sir.
Have you filed the affidavit? Have you filed the affidavit?
No, recently, no, sir. Whatever the affidavit.
Not
have
recently.
given
You,
in the
you will
past.
use the affidavit or not?
Previously, yes.
Previously.
No, sir.
Sir, before I was being represented by a lawyer.
That's why I am asking, sir. You are the respondent number 4.
Oh, correct, sir.
Correct. This writ petition is against you
Right,
as
sir.
well as the authorities.
Right, sir.
Now you wanted to file the affidavit in opposition, or you will argue the matter only on the basis of point of law.
Sir,
If you
I will
say
argue
that
this. There's
you will
nothing
argue
to
the
argue,
matter,
sir.
you will not
Yes.
file the affidavit in opposition. I will record that. That's
Record
it,
it, sir. Record it.
Yes,
sir,
madam.
Sir, all I'm requesting you humbly, sir, humbly. Sir, if you want to decide against me, do it. Decide on merit, but dispose of. Sir, don't. I cannot take it anymore, sir. I'm
But without
collecting.
the state, how I can?
Right, sir. So, with a very short date, please close the matter, sir. And I'll tell you, sir, the one more reason why they're running away from the MSCB council. Sir, they're sure to lose. And I'll tell you, please give me 2 more minutes and I'll show you can understand the whole thing. Sir, just see this.
Keep your energy with you. Come when the matter will be taken up for final hearing. I will hear all the things what you want to submit. Yes.
No, I will give you later. I'll give you later.
Learned Council appearing for the state press for a direction upon the petitioner to solve the submit that she has been recently engaged in the matter to appear on behalf of the respondent number 1, 2, and 3. 1, 2, and 3. As such, she prays for a copy of the writ application along with the documents. And the private respondent number 4 is appearing in person. He prays for early hearing of the present writ application. At the land full stop. The petitioners have filed an application being Can 3.
Yes. Can 3.
Can 3 of 2026, praying for extension of interim order.
Sir, please don't extend the order, sir.
Yes.
Sir, please don't extend the interim stay. Sir, please don't do it, sir. I will not approach. I will not do anything. Just next hearing.
No, see, they are already enjoying the interim order. If interim order is not extended, I will fix a specific date. Don't worry. Don't
Okay,
worry.
sure. Thank you, sir.
Yeah, bola? Interim order. Then the private respondent has objected for extension of interim order. Full stop. At the Learned Council for the respective parties, full stop. This court find that the petitioner is enjoying the interim order and as such, then the private respondent submits that he will not use any affidavit to the writ application. He will argue the matter on merit. Full stop. Consider the submission made by the council for the parties as well as the private respondent in person. The interim order is this court find that the petitioner already enjoying the interim order since long. Accordingly, for the interest of justice, the interim order is extended. Extended till the next date of hearing. Full stop. The petition is directed to serve the copy of the writ application along with all documents to the Learned Council appearing for the state by tomorrow, by Monday, by 20th July 2026. Full stop. You will also not use the affidavit.
If it is point of law, then.
This is a point of law. Let the matter appear on. Give the date at 2 p.m.
Then, sir, tomorrow?
Not tomorrow. 12 p.m. ने दे दो कोई एक दे दो अगस्त में देखो 12 में क्या है
मैंने any day after 27.
7th of
No, sir.
It's a course.
Hmm?
এখানে যে মিশে রাখলো
19th August at 12 noon.
19th August?
Yes.
19th August, sir.
If you want short date, but I cannot fix the date, then I will fix any date that the same thing will happen. Okay, Kete then. Fix that.
Sir, please make a short date, sir. I am suffering,
Okay,
sir.
let the matter appear on 2nd of, let the matter appear on 4th of August 2026 under the same idea. 4th August. Interim order is extended till 4th August. Next.
'21, my lord, I have.
Good day, sir. Thank you, sir.
Madam, appearing for the petitioner.
My lord, I am appearing.
Have served again the second
But I
time.
am appearing on behalf of Union of India, my lord. My lord, last day, my lord, yesterday, my lord, we too have been engaged, my lord, through mail, not yet received any copy of the petition from the concerned department, and also we have to, my lord, take instruction from the authority.
Delayed payment.
Delayed payment, my lord, 111 days delayed payment. As per MSME Act, Section 16.
Yes.
There is a provision of giving penalty in terms of interest, 3 times the market rate of interest. That means 19.5% compounded monthly. And that amounts to, if I calculate this, might have given a calculation in my petition.
1,83,000.
1,83,700, something like that. My lord, that is what.
Pay.
My lord, we have to take. My lord, we have to take instruction. Lord, not yet received, my lord, the brief.
You not received the
No.
brief.
Yesterday we have been.
How soon you will come?
My lord, 15 days time, your lordship.
Land Council appearing for the Union of India.
Union of India.
And what about
South Central Railway?
What about the other railways?
South Central
Railways also.
Appearing
Railways also.
Land Council appearing for the respondents. Submit that he has been recently engaged and he requires 2 weeks time to take instruction. Full stop. In view of the submission made by the council for the respondents, case is adjourned. Let the matter appear on 6th August 2026 under the same heading.
Grateful to you.
Affidavit of service be kept in the record. ऊपर कर देना. Next.
Okay. For the petition.
Lordship, what happened, Lordship? These are relating to supply of cooked diet, Lordship. Supply of cooked diet in Bhuvan Government Hospital, Lordship. Lordship, initially rate was enhanced in 2013, thereafter 2017. But the authority could not able to give effect 2017 rate as because, Lordship, there was a court's order and they restrained themselves. Lordship, I am letting They restrained themselves and they did not give any effect, Lordship. So we moved to the Honorable High Court that 2017 they have fixed one rate. So let them give that rate to all the table yards, Lordship, because 2013 last date was enhanced. So the Honorable Court enhanced the rate and directed the state authority that come what you fix that rate. So you give effect that rate and that rate was given, Lordship. Lordship, I am showing that order, Lordship. 2023, Lordship, again rate was enhanced. Again, it was stayed, Lordship. Lordship, there are 2 matters are pending before Lordship also. So we are praying that, Lordship, praying that let the enhanced rate be given in terms of that order earlier. Lordship, kindly see the order, Lordship.
Who is appearing for the state?
I am appearing for the state.
Just to supplement, coordinate bench passed an order. I will praying before my lord, kindly pass this order on that tune in respect of the enhanced circumstances. Because on that date, one rate was fixed. State, this your lordship's court said, if it is state, then it is totally incompetent. This is diet supply with the patient. It cannot be stopped. And at the same time, it cannot be seen the person who is supplying is sustaining loss. Meaning thereby the bad quality will go to the patient. On that consideration, court says is subject to.
Now it is fixed, 5 rupees.
No, that has not been fixed. That has been
5 rupees ready.
5 rupees, my lord, when I joined here, 5 rupees was there.
Now they have fixed it.
Not
My,
yet fixed.
my lord, I have to take instruction.
Not yet fixed. Asan sir. I will be praying on that line.
Yes.
Now what
35.
Yes.
My lord, I have to take instruction.
What instruction? Already judgment is there.
35.
Order of the coordinate bench is there. Why you are not considering that?
I got this brief today, my lord.
Today. Okay. When you will come?
Peruse that. Can you once come to paragraph 30, page 38?
দেখো ওখানে অ্যালাউ তো করবে না আমার ওয়েস্টেজ অফ টাইম হবে ঠিক আছে আমি যাব বলেছি যখন আমি যাব
This should be stopped. All time to come.
Yes.
Paragraph 13, my lord, kindly once come, page 38, paragraph 13.
Interim order was merely
बोलो बोल रहा हूँ
41.
কোথায় আছে দাও
20.
চেকের মামলা আমি করো না
এটা আমার না
তুমি
I got the bill.
তুমি করো আমি বললাম
আজকে পেয়েছি তুই।
আজকেই পেয়েছি করো
I got the bid, Malan, 1 hour ago, Malan. I have to take your instruction, Malan. Malan, give me a Malan, Malan, next occasion, Malan, fix the matter, Malan, Wednesday, Malan. I shall do that, Malan.
Come with the
And paragraph 20. Let I indicate
go
here
through the
also.
judgment.
13 and 20.
Yes.
You to close over Ayan. Follow. Paragraph 20, page 31. Yeah.
Go to the judgment, consult your administration, and come with the total instruction.
দাগমার এটা দেখে আছে ঠিক আছে বলো can you fix the date
Learned counsel for the state submitters, he has been recently engaged in the present case and he prays for take instruction. According to case is set down, let the matter appear. When?
Wednesday, next Wednesday.
You're sure?
Yes.
within past 10 matters.
Let
Just mention in the
10 has gone to the 100.
I know that. This is the reaction of the court. 10 became 20 now.
Let the matter
Mentioning but it has come.
appear on 29 July within 10 minutes.
Bro, you're talking ধরার মতো হয়
Affidavit. Yes, next.
Grateful.
Next.
Before Miller,
23, my lord, I am challenging the virus of
may I?
Central Act, my lord. Transit
Before my lord takes up the matter, my lord, I will just point out one particular aspect. My lord, on the same cause of action regarding challenging the virus, the matter is pending before the Honorable Supreme Court of India. And 2 other matters were filed before this Honorable Court, one by way of a public interest litigation, which was before the Honorable Division Bench, and another matter, Lordship, where the matter has been, my lord, basically adjourned sine die in view of the pendency of the Supreme Court matter. Lordship will kindly have a look at this particular order. I'm also giving a copy to me. Button. Correct.
Yes.
My lord, one more indulgence. I'm praying for your lordship. My lord, I'm also asking my learned friend that whether they have, whether they have served this copy to the learned attorney general or not, as is required, because he is challenging the virus of the act. So under these two,
kindly grant me leave, my lord, I shall serve.
Let first go out of the list. If we come
lord, that is
because
both
your
points
notice
will- Lord,
unless the Supreme Court decide the matter.
It is my duty to inform your lordship as your
Thank you.
lordship's officer, because he will go and pressing his
Second
matter.
ASGI has brought to the notice of this court that the similar prayer is pending before the Honorable Supreme Court in the writ petition within bracket as civil number 548 of 2026 within bracket Lakshmi Narayan Tripathi and another versus Union of India and another. In view of the above, WPA number 11926 of 2026, go out of the list for the present, liberty to mention after notice to the party.
I'm grateful.
My lord, may I find my affidavit of service?
Affidavit of service, Captain.
My lord.
My application. Simple application. Well, I made the register of assurances. I have made an application for a certified copy of a title deed, one of my chain title deeds of 1984. I made that application, my lord, back in
to whom?
to the register of assurances, my lord, and I've also deposited
Certified
the
copy.
certified copy, only for issuance of
So
certified.
what has happened?
They've not responded. I've written to them representations.
For that
asking-
writ petition?
Because they're not taking any steps. I've even made an RTI as to the status of my application. No response. It's a simple inaction writ.
Yes,
So that-
madam. You're appearing? No.
My application is at page 38. August 25, it's still pending.
38.
Page 38. This is my application, and the fees that I've deposited, Malal will find that at page
Fees also
45.
deposited.
Yes,
Why
madam.
you're not going to the consumer forum?
So it's the register. I have no grievance against any private body. Should ideally, Malal, this is a case which should actually go to the consumer forum. But
I had dealt with one matter.
hopefully, Malal, we don't have to see that.
Yes.
But I don't have any instruction, my lord.
What instruction? They are asked for the certified copy of one deed. They are not provided. They made a representation that depend. Let
it be considered. Let the representation. Yes.
The grievance of the petitioner in the present writ application that the petitioner has made an request to the registrar of assurance, record section on 18th of August 2025 for providing the certified copy of the sale deed registered by group number 1, volume number 47, page number 261 to 268, being serial number 1178 of 1984, registered in the office of the Registrar of Assurance, Calcutta. He submitted in spite of receipt of the petition has also deposited the fee.
Yes, Malal.
Where is
That's
that?
at page 45 onwards.
Has
The receipts are there.
deposited the requisite fee for obtaining the certified copy, but in spite of receipt of the representation and the requisite fee, the respondent authorities have not provided the certified copy of the aforesaid deed. Full stop. At the land counsel for the respective parties, this court find that the petitioner has made a request to the Registrar of Assurance for providing the certified copy of the deed mentioned above, but that has not been provided, though the petitioner already deposited the requisite fee for obtaining the certified copy. In view of the above, the respondent number.
Respondent 1 should be Malal. Malal, respondent 3. Respondent 3.
The respondent number 3 is directed to consider the representation of the petitioner dated 18th of August 2025 by giving a personal opportunity of hearing to the petitioner and to provide the deed to the petitioner on completion of all formalities within a period of 4 weeks from the date of receipt of this.
What are the affidavit of service name?
Affidavit of service completed. Next.
My lord, I beg to appear for the DVC, my lord.
My lord, I am part of the petitioner.
7280 should be 7280 1992. Good. आप connection में उठो ये
Yes.
My lord, first of all, my lord, before my learned friend submits, my lord, I have a question, my lord, whether your lordship can take up the matter. It's a service related matter, my lord.
What is the matter?
Service related matter. If your lordship takes it, I have no difficulty.
Now, what is the matter? What is the prayer?
My lord, the sum and substance of the matter is that in the year of 1986, I joined with the organization of the respondent. After completion of the 26 years of service, I applied for the station living permission and 14 days on leave that was granted for the purpose of treatment of my wife who was staying at the...
How this court? The service matter. How this
This is-
court?
this is a-
How the group 9 will come in?
My lord, this is a hearing matter. The Honorable Justice Arindam Mukherjee had passed that it will be mentioned for the purpose of hearing.
And
I
my
have brought
duty
a
to
copy
point
of
out,
that.
my lord, nothing more, nothing
Affidavit
less.
completed.
No.
What order you are?
No, my lord, we have not filed any affidavit.
Then, if the matter is ready for hearing, then the hearing matter.
Order was passed relating to furnishing of the statement on the part of the respondent relating to retail benefits dues to me.
Correct, but how this court can, the affidavit is not filed. If the ready matter, the court can take the irrespective of 2024 onwards, no problem. But here affidavit is not ready.
But no order have been passed for the submission of the affidavit.
Huh? That's
No.
why they have not asked for
My lord, only order have been passed to the extent that the respondent.
production of the document.
Yes, yes.
Yes, but
But that can be done by next week, any day, my lord. If your lordship
Uh,
pleases to take up the matter, will next week.
this court find that this court is not having the determination to decide the issue raised in the present writ application. Accordingly, WPA number 16144/2024 is released from the list of this court with the liberty to the parties to mention before the appropriate court having determination.
Don't take me amiss, my lord.
That's good. That's good to mention before this court because this court is not having all the things to go through.
Yes,
When,
well-
when then he will half argue the matter, then it will instruct to this court.
Yes, my lord. Difficulty for the court also, my lord. Great.
46, I take to appear on behalf of the
Your Lordship, in this matter, Ms. Pawana Rao Choudhury appearing based respondent number 5, that is Punjab National Bank. She has engaged in courtroom number 18.
Who?
That Pawana Rao Choudhury.
Okay, respondent number 5. What
Respondent
are
number
the
5.
respondents?
We are respondent number 1.
There are other respondents, I think.
Huh?
My lord, I am appearing for respondent number 6 IBPS.
6.
Lordship, keep it at 2 p.m.
Banking personnel.
They are the main respondent, my lord.
Respondent number 5 is the Punjab National Bank.
Yes, Lordship.
This is the-
We are
the
engaged in
particular
courtroom
prayer.
number 18, Lordship.
My lord, it is that, my lord, the present petitioner is a disabled 70% suffering 70% disability. My lord, despite that, my lord, his certificate was issued in a way that it has not being accepted by the PNB. When he was checked by the doctor, it was found that 70% disability which is not likely to improve.
Disability with regard to what?
Disability, locomotor disability,
Motor.
joint, locomotor disability, and it was categorically stated in the doctor's checklist that it is not likely to improve. However, despite that, the temporary disability certificate was issued. And that is why, my lord, they are not accepting my disability certificate.
This has not been placed before the board of doctors.
Yes, no, my lord, he has been placed before the board of doctors, and my lord, that certificate is still, my lord, as a temporary, whereas, my lord, the notification issued by the ministry is categorically stating that when there is not likely to improve,
Yes.
it has to be a permanent disability certificate. We agree by that
Even
only.
permanent, or if it is to be given for the considerable period of 3 years or 5
Yes,
years,
yes.
subject to review.
My lord.
Subject
My
to
lord, but that is the problem. My lord. My certificate is 70% locomotor disability, which is 70, which is not likely to improve.
What is the prayer?
My lord, that is why I prayed before that, my lord.
Where is the disability certificate?
My lord. This is certificate one. Certificate of the page number 44, my lord, onwards.
Disability
40,
medical board.
yes, and thereafter 45, my lord.
Who is appearing for the authorities? Who has issued this? Department of Empowerment of Person with Disabilities? Which hospital?
My lord, Bangur Hospital. We have also made a party, then. Bangur has also been made a party, my lord. The Ministry of Health and respondent number 4 is Emar Bangur, and Ministry of Health is also a party, my lord. My lord, if your lordship sees page number 44, you will find it is categorically written. 70% disability not likely to improve.
Yes.
So, and despite that, my lord, I am, my lord, suffering.
Preparing for the respondent 4. You are appearing for whom, madam?
I am for the state, my lord.
That's why state means the same.
Yes, sir.
Before this skirt, state means all, not only
yes.
C. Sitting in the corner.
I have to take the instruction, my lord.
Take instruction why if it is 70% and why it is on the temporary.
Yes, ma'am.
Under
when it is-
provision of law. How soon you will come with the report? And where is the this is the report, where is the recommendation? It should be a recommendation of the doctors. It is online you have given. There should be a board of doctors, 3, 5, 7, whatever it may be. Then there will be a recommendation. On the recommendation of this, I don't think how the certificate is valid without the photographs.
And will not also kindly come to page number 58 for once. The same doctor, subsequently, when I was rejected with my appointment, my lord, I again approached, and this was issued. My lord, may I read page number 58? It is declared that the diagnosis of above said person is recommended for 9 years, 9 months, but in the future his disability percent will increase.
I have to take instruction. Kindly give 15 days time to take
15 days,
instruction.
in the meantime, my lord.
What?
Very, very well.
Land Council for the state press for time to take instruction. Accordingly, case is adjourned. Let the matter appear on 6th of August under the same heading. Come on that affidavit. Come on that day. Only you have to see why it is temporary, why it is not a permanent basis, or for the specific period. Specific period with the liberty to review. These are the two things can be done. But as per the act, it has. If it is 70%, then why? Temporary, why temporary? And you are telling that your doctor is telling it is not chance to cure that.
Yes.
Then
My
come on
lord,
that.
my lord, may I pray only one thing, my lord? On that day, if some preference may be given, my lord, otherwise it may not be called, my lord, that is fine.
Yes, next.
Most obliged, my lord, most obliged.
Classification of an account of an MSME as NPA without, my lord, following the procedures under the RBI guidelines.
No inquiry. No inquiry.
No. My lord, in fact, your lordship's judgment is that I am armed with that. I need not say anything more, my lord. I'll only show one document, but the affidavit of service may be kept in the record. But I'll show only one document because, my lord, courts, including your lordship, has consistently held that you have to raise the issue. But kindly takes, my lord, page, my lord, 60. I'm sorry, my lord. Just kindly, my lord, take, my lord, page 69 of the writ petition. This is my reply to the 13.2. Kindly come to paragraph 12. Paragraph 2, page 69. At the outset, it is stated that the entire action initiated by the bank is founded on the illegal and premature classification of our account as non-performing asset on 14th December 2025, which classification has been made in complete disregard of the binding regulatory framework governing micro, small and medium enterprise. It is a matter of record that the credit facility in question was sanctioned to us with a sanction dated such and such under the MSME category itself by the bank. Once the bank has consciously sanctioned the facility treating the borrower as an MSME unit, the bank is territorially bound to follow the special dispensation and protective regime mandated by the Reserve Bank of India for MSME borrowers and cannot resort to mechanical recovery measure as if the account was an ordinary non-MSME loan. It is further stated that the Reserve Bank of India, in exercise of its power under banking regulation, has framed a comprehensive framework for identification, revival, and rehabilitation of stressed MSME accounts. The said framework has reiterated through successive circulars, including circular dated such and such.
Yes.
It mandates that once an MSME account shows signs of stress, the bank must necessarily undertake a structured resolution process. Such process includes identification, incipient stress, communication with the borrower.
There are 3 stages.
Yes, the stages are there. Now, this is on record. Thereafter also, they have gone ahead, my lord, and my lord, taken steps under 13.4. And my lord, we have, my lord.
Now, what is the stage?
My lord, we have, my lord, filed section 17. I must be candid, and I have said it. But my lord, this challenge is nothing to do with securitization. I am saying the classification of the account as NPA itself is bad, which I can always.
When NPA?
Yes, the NPA has been 14th December 2025. And the reply which I showed your lordship.
And when you applied for that is
yes,
as an
February 2026
MSME. When
yes,
you applied
yes.
for the loan,
that is mentioned at page 70. Page 70 top. Page 70. My reply. It is a matter of record that the credit facility in question was sanctioned to us. VDA sanction dated 28th October 2024 under MSME category itself, which your lordship will find at page 36. Page 36.
Yes, who is appearing?
Lord, I am appearing for the bank. Lord, the first thing, Lord, I want me to submit, Lord, that the petitioner is not guided by the scheme. Why I say so? My lord, the scheme says, it's at page number 52 of the writ petition, that the provision made in this framework shall be applicable to MSMEs having loan up to 25 crores, including accounts under consortium or multiple banking arrangements.
Where from you?
Page eligibility number 1.
The
Eligibility
provisions made the framework applicable to the MSC loan limits of 25 crore, up to 25 crore, including the accounts of consortium or the multi-years. So what is the
My lord, my instruction is that
So what is the loan amount here?
here it is less than 25. Here it is less than 25, admittedly. But aggregate, my lord, of all the banks, my lord, that I have is more than 25.
Then every bank has to take the
Separately.
my order is there.
Absolutely.
Every bank has to adopt the framework of this Reserve Bank of India and to consider every bank. You cannot say yes, SBI, Union Bank, other private
Artificial
NBFC
legislation, I should
taken into consideration. That cannot be. Every bank has to take their own and to follow the procedure prescribed under the guideline scheme.
Lordship, and second point, my lord, that I've gone through your lordship's judgment, and lordship has relied on somewhat that judgment of Honorable Supreme
Two
Court.
judgments of your
I had
lordship.
to,
One is Visitsa retail and another is Moham League.
My lord, the writ petitioner, my lord, was all along informed that the property, my lord, that the account is it's irregular in payment. At that point of time, my lord, no step was taken by the writ petitioner for invoking it. And once, my lord, steps were started to be taken under 13, my lord, the Surface Act, my lord, they come up with this objection. My lord, so, and my lord, there is a responsibility on the bank, and my lord, as for the summons judgment, my lord, there is also my lord, responsibility on the part of the trade, my lord, the borrower itself.
Justice Bela Trivedi's order.
Well,
Justice Bela Trivedi's order
Yes.
there. It is of
My lord, all I'm saying is they can,
responsibility of both.
And
they
in
can
this,
consider and reject.
in
But
this-
at least that exercise has to be there.
Yes.
Lord, and so, my lord, in that case, my lord, there is a provision, my lord, in that judgment also that he has to file in by way of an affidavit that invoking the provisions of the scheme. That has not been done here. And this is, my lord, done after they have filed a Section 17 application, my lord, while, my lord, they have taken steps against the Surface Act proceedings. After that, my lord, afterthought, my lord, they have filed this writ petition. Well, I follow my lordship's judgment also. It covers that once 13(2) has been filed, they have taken it under 13(3). But my specific point that, my lord, initially when they were made aware that this loan is irregular, at that point of time, my lord, they were aware of it, but they didn't take any steps. And they never asked to come up with any steps or rescheduling or that.
No. So, what do you want to file affidavit?
My lord, kindly, my lord, a short affidavit.
How soon?
For fortnight.
The respondents press for time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Reply, if any, there to be filed within a week thereafter. Let the matter appear on.
My lord, I was considering beseeching your lordship to consider prayer G, my lord.
Let them come.
Let them not do it.
Initiated.
Because everything stems from non-classification. Classification as NPA.
Correct. You
Prayer
initiated.
G, my lord.
Actually, if that way, so I'll have to make some submissions because the Honorable Supreme Court never prevents the bank from declaring NPA.
17, let it come. Yeah, let the matter appear on. 25th August.
Short affidavit. He's your
2 weeks, 1 week.
1 week, my lord.
2
My
weeks.
lord, everything else, my lord, to abide by the result of this petition.
Naturally.
Some protection, my lord. Otherwise, I have prima facie shown some case, my lord. It is not considered.
Affidavit of service kept with the record. Any action taken by the authorities will kept abide by the result.
That goes without saying.
Your lordship
Taken by
take obviously has a different weight.
Any action taken by the authorities shall be is abide by the result of. Any action taken by the authorities shall be abide by the result of.
My lord, I am for the respondent back, my lord.
Appear for the petition. Lord, I have served the notice. Notice is properly served. Thereafter also, Lord, I have mentioned the matter before your lordship. Your lordship has better today. That notice also I have given. This
What is the prayer?
Yes, my lord, this matter relates to the
Lord, kindly before going to the Lord, may I just indicate three things.
Yes.
After mentioning the matter, Lord, the notice was given to the respondents. Lord, here the matter is, Lord, with regard to payment of, Lord, arrears of tax in terms of the lease deed and, Lord, interest thereon. Lord, there was an approval of the higher authority of the bank. Lord, the lower authority of the bank, Lord, did not act in terms of the higher authority's approval. Lord, I am covered by the judgment of this honorable court, Lord. In the similar circumstances, Lord, the single bench of this honorable court has passed the judgment, and the bank has went up to the division bench of this honorable court. Division bench also, Lord, confirmed the order of the learned single judge. So, Lord, at the present moment, Lord, I want, Lord, in terms of the approval at page 30 of my writ petition. Page 30 of my writ petition. Legal notice was also given at page 67. They have just denied that by way of reply at page 77.
Competent authority has been approved the renewal of the lease of the branch premises under your occupation on the following terms.
I want execution of that approval. In this
So you are ready with this approval?
Yes,
So these are
I have accepted that approval.
Now they are still in occupation.
Yes, a portion of that building is still in occupation of the bank. A portion has been released.
Correct. So what at that time there what was the total?
The entire portion has been occupied by the bank. That's why, Lord, this next, Lord, the decision of both the parties, and thereafter this approval, how much amount they will pay, how much amount they will not pay. I am, Lord, just seeking, Lord, the interpretation.
Yes, madam. What is your instruction?
My lord, there are serious disputed question of facts.
But what is the dispute? That let me understand. What is the disputed?
I need to come out with my documents, my lord. I need to file affidavit.
You are denying with regard to this 4th March 2024 letter.
My
If you
lord.
are telling that this officer has not, and this is the
My
full
lord,
document.
under normal circumstances, every condition are preconceived before the registration of the lease is done. Every area they are consented by both the parties. The areas are mutually agreed upon. Payments are being made, and then only, my lord, the lease deed documentations are registered. So this is a subsequent fact he is taking up.
What subsequent?
And my lord, this writ jurisdiction, this is a personal contractual liability, my lord, that cannot be entertained by a writ court.
Okay.
Yes.
If your lordship comes to para 36 of the petition itself, he itself states that, my lord,
page 87, page 100 will reply that.
My lord,
87, page 100.
he himself says that a claim, though arising out of a contractual obligation, page 14, my lord, of the writ petition, para 36. The writ petitioner himself is stating that though arising out of a contractual obligation against the respondent authority.
Which paragraph you are reading, madam?
Para 36, my lord, page 14 of the writ petition.
Okay. Arising out of the contractual obligation against the
He
respondent.
himself is admitting, my lord, it's a contractual liability.
Yes.
It's a personal contract, my lord. It cannot be entertained. The writ court doesn't have jurisdiction to entertain. He has to approach the proper court below. Civil court.
Yes. Next.
My lord, and I have documents, my lord. I'll come up with affidavits, my lord. I need direction.
If you want to argue the matter on merit, I will hear the merit here in now.
My lord, I have documents
into the fact.
which I don't have the documents right now, my lord.
For the maintainability, what is the requirement of the document? If you want to argue the matter on merit, on maintainability, you argue the matter, I will decide here in now.
My lord, I need to take directions because, my lord, he has not served notice. I did not get the notice.
There are two options to you, madam. If you want to argue the matter on the threshold that the writ petition is not maintainable, then you argue, I will take your no.
My lord, I am seeking
If you
direction
say
of
that
affidavits, my lord.
you will file the affidavit in opposition, then I will file the affidavit.
My lord, I'm seeking for affidavit.
Only one submission may I make. My lord, let them file affidavit, my lord. I don't object at this stage. Lord, only, my lord, the pendency of the writ petition, your lordship knows, my lord, the matter will be pending for considerable period. Lord, pendency of this writ petition, my lord, will not debar them, my lord, to act in terms of that 4th March. What? 4th March, my lord, the otherwise, my lord, I am not in a position to have
the respondents press for time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Reply, if any, there to be filed within a week thereafter. Full stop. The respondents also raised the point of contempt. The same is kept open. Please the matter on 11th August 2026. Affidavit be kept with the record. Affidavit of service be kept with the record. Next.
I'm going to.
Under the adjourned motion. Yes.
29, Your Lordship, I am led by the learned ASG. So the files have just been transferred from the erstwhile ASG to the new ASG, Your Lordship. So we're seeking some time.
So I'd like to place the facts of the case. My father,
Who is appearing?
I'm appearing.
You're appearing.
Well, I have served it. In the middle of, I am first of all served, then none appeared, again served and fighting it. My father, Rakhal Chandra Samanto, was a freedom fighter.
Freedom fighter. Yes.
After commencement of 1972 Act, that is 72 scheme, that is the Freedom Fighters Pension Scheme 1972, he applied. But it is alleged by the government that on the basis of that application, sanction was done along with 32 others. But my case is that sanction letter for less the PPO, for less the pension was ever received by my father.
By?
My father. My father did not receive the sanction order. Neither the sanction order, nor the PPO, nor even the...
When your father died?
And died in 1984.
1984
died. 84, died.
When the sanction letter was issued?
They issued in 74. 74. With effect from 72. But that was never served. Well, I will come to that document. I have annexed in the writ application. Subsequent to...
And before your lordship takes up the matter, my lord, the newly ASG appointed has been engaged in the matter. Your lordship.
Yes, Your Lordship, I made the same prayer, Your Lordship.
No, let me understand. Hear me. I will play a very innocuous prayer, especially for the reasons. But I believe you will not harm anybody, neither me nor him. Well, let it be hard
to the court.
Yes. Let it be hard, and I will pray. Ultimately, I will pray for a direction for filing the affidavit in opposition, annexing the document as alleged in the impugn order.
Affidavit in opposition? Or supplementary?
Supplementary affidavit. No. I will not. I will pray for. They have relied upon some document in the
reply
order.
Okay.
So I will pray your lordship may direct them to file the affidavit in opposition, annexing those documents. That may help both the courts and the us to argue on the point. So let the place case with them. Because my mother applied after the death of my father. After the application, pension was sanctioned originally in favor of my mother. Sometimes in 1984, 85. In the sanction letter, your lordship will find I have annexed that at page 47. Petitioner's name along with another sister who is no longer in this world was mentioned.
In the approved list. In the approved list. Sanction list.
PPO. In the PPO.
In the PPO.
Okay. Mother was sanctioned pension at the rate of rupees 300, which includes rupees 50 for each of 2 daughters. That is mother, as per the scheme, that was given. So my name was indicated or written in the PPO of my mother. My mother was getting the pension till her death in 2015. After the death of my mother, 2015. After the death of my mother, my client, that is the petitioner before lordship, approached the paying bank for transfer of the pension in favor of her, as per the scheme or the circular. So I applied. That was not responded. Again, remainder was given. Again, the demand justice was given. Nothing was done. Then I had to come before this court on earlier occasion, when the Honorable Court, after going through their communication, directed that take the decision within certain time, and if she is found eligible, then grant the pension. Now, after that order, my lord, the under secretary, your lordship, can you take pen to
Okay,
page?
let the file affidavit, but this court is of the view that the petition is to be disposed of only after exchange of affidavit. And this court find that affidavit is required to be filed by the authorities. Accordingly, affidavit in opposition is filed within 3 weeks. 4 weeks. Reply with
2 weeks.
With reply within 2 weeks. List the matter on
at a fixed date bill.
Let the affidavit come first. With the whether they will file within 4 weeks. Let us say. Let the matter appear on 6 weeks over, on 28th August.
My lord, one indulgent thing. My lord, affidavit annexing documents they relied upon.
If they will not file, you mention, I will direct. Let them file.
Grateful, dear Lordship.
Well, item number 29, Lord, I make for the rest number 6, Lord.
But affidavit filed today may be kept in the record.
Yes, item.
Lord,
I am for the petition.
my lord, item number 30, Mr. Tiwari is appearing for the Union of India, my lord. Due to some personal difficulty, he is out of town, my lord.
Who is petitioner? What is the prayer?
Here, my lord. For cancellation of the impugned letter.
Huh?
Cancellation of the impugned letter. That is page 27.
Page 27.
I made a fax, my lord. I made an application, my lord, for passport, and inadvertently, my lord, the date of birth has been
date of birth does not match with the
and
PP.
PP. That's why I made an application for correction, for revision of the date of birth, along with my all documents, and submitted all documents. That is school certificate, voter card, Aadhaar card, and everything. But the authority says that his nationality
Okay,
is
you
doubtful.
do one thing.
And
take instruction.
My lord, I'm not in the panel, my lord.
So Tiwari will come
Mr.
on
Tiwari,
Monday.
he will be back next week, my lord. Kindly make it not this week. Monday he will be
Coming on
available.
Monday.
Yes, my lord.
You come on to Wednesday. Land Council for the passport authorities prays for time. According cases adjourned, let the matter appear on 22nd. Affidavit to be kept with the affidavit service kept with the record. Come on 22nd. Next.
In this matter, my lord, an innocuous prayer is being made by the petitioner. Seeking
I am from the Information Commission in this matter.
seeking disposal of the complaint presented under section 80, with section 20 of the Right to Information Act, my lord, which is at page number 42 to 48, my lord, pending since 13th October 2023. Well, initially, this petitioner has
Before whom? Appellate authority or?
I am the appellant. I am the appellant.
No. Before whom? Appellate authority or the SPIO?
Below appellate authority, my lord,
Appellate
that is
authority.
State Chief Information Commissioner. Not in the proceeding under section 19.
Kindly take it up day after tomorrow, Lordship. Kindly, I need to instruction, or maybe this is the appeal is disposed of by the commission. Maybe, I'm not sure. That's why, Lordship, I am appearing on the Information Commission. In the, that's why only one day, day after tomorrow.
That's what, my lord, I'm submitting, my lord. Lord, 7 September 2023, a second appeal proceeding got disposed of. That order is at page number 38. There was certain direction passed upon the respondent number 2, who is the SPIU. Lord, that direction passed by the respondent number 1, since not being complied by the respondent number 2, a complaint proceeding was presented on 13th October 2023. That is complaint under section 20, read with section 18 of the RTI. What I'm humbly beseeching very innocuously, my lord, that let this complaint be nobody.
Kindly take it up day after tomorrow.
No, one the authority is directed to provide and you are not provided. So what?
No, commission is not provided any information. There's direction to the certain authority to provide the information.
Where is the second appeal order?
Yes, my lord, that is at page number 38.
38. Who has commission?
By the
State Chief Commissioner.
Yes, madam.
Is the first appellate authority.
No, madam.
The second appellate authority.
The second appellate authority.
Yes.
Please provide the means so. Where is the order?
My lord, the operating portion of the order is at page number 39. That is point number 5. Query
After
number-
deliberation decision, query A is exempted under 8. No need to supply. Query number B, E, F are not information of 2 of RTI. C, reply should be given by the SPIO. 3. What is the 3? A, B, C.
C is, my lord, talk with my lord will see whether any sanction plan.
Whether
on the
any
same
sanction has been obtained by the construction of building or metallic. Yes, yes, then
Query D be replied, keeping in mind section 8 of the RTI Act.
D. If the answer query 3 is yes, please provide me copy of sanction along with it. Yes. Yes.
Matter was disposed of.
Matter is disposed of, but the SPIO not supplied the copy.
I am not for
Well,
the SPIO.
That's why. You're not for the SPI, you're telling that his case is that appellate authority has disposed of the appeal, directing the SPIO to provide the copy. So you're appearing for whom?
I'm appearing for the municipality, my SPIO.
Municipality. Well, who is that?
My lord, may I SPIO? My lord,
I am for the second appellate authority. That is my order, Lord.
Correct. So he's not against you. He's telling that. So what you're telling that they are disposed of?
may I, my lord? My lord,
Who is the SPIO?
my lord,
Yes. Who is the
my lord, may I-
SPIO?
No, the SPIO is the Kamarhati municipality. My lord, respondent number.
You're appearing with the
municipality, my lord. May I?
So
My lord, in this regard, my lord, already several writ petitions has been filed. In one of the writ petitions, the Honorable High Court has given us certain directions. My lord, according to that directions in appeal, according to that direction, we have already executed some portion. After that, my lord, chairman resigned. Now it is pending. My lord, regarding this, the plan and all, it has already been there to provide him.
to provide.
Yes, my lord. Inspection has been conducted.
Inspection is not necessary. Kindly see the prayer, the C. C is with regard to whether the sanction plan have been obtained for construction of the ground of plus 1-story building with metallic shed. C, and with regard to the D, if answer yes, please provide the copy of the application of such sanction along with the enclosure.
Well, it is actually his father's sanction plan in 78 or something.
It may be.
78. Well, that the record we have to search for. It is a 78 plan. It is not current plan. It is a building plan of 78. Even more than that.
So
we will find out. We will find out now. The board is not functioning, my lord, at present. So give me a
administrator is there. Administrator is there.
Has not been appointed yet. My lord, it will function from next week, I guess. So give us some time. We will provide it. We will take
Only
it.
one submission, my lord, if my lord kindly permits me. My lord, good bad, there is an order passed by the respondent number 1, 7 September 2023. That order was not complied by respondent number 2, for which a proceeding under section 18 and section 20 have been invoked by the petitioner, my lord, which is also kept pending since 18th October 2023. If my lord kindly see page number 42, my lord, page number 42 is the petition which is being presented before the respondent number 1 under section 18 read with section 20, only for the reason that despite there being a subsisting order which is not being challenged by the respondent number 2, they have not provided me information since 2023, my lord. And the petitioner before your lordship is a septuagenarian, my lord, aged about 74 years. Page number 42 of my lord's brief, 13th October 2023 complaint. I just want, my lord, implementation of the order, my lord.
No. Who is Subrata Goswami?
The petitioner before your lordship.
So, query number 3, what yes? Sanction plan was submitted by you.
No, my lord, that is the malafide, my lord, I am harping, my lord. I want the sanction plan and he gives my lord, a letter that sanction plan has been filed by you. That is incorrect.
Actually, my lord, this is a dispute between two brothers. My lord, one brother has the sanction plan.
Certain information.
One brother has the sanction plan in his possession of the property.
Yes, so you can challenge it. How they already given the answer. Kindly see the
No,
page
my lord, as
41.
per section 18, read with section 22, if any wrong information or any malafide information is being given by the SPIO, my lord, I have a remedy under section 18 and 20.
Correct.
I have specifically stipulated that the information which they have been provided on the face of it is wrong and illegal, my lord, for which this representation is being presented under section 18 and 20. And why I am before your lordship is only seeking a direction for disposal of my this complaint proceeding.
What?
This complaint proceeding under section 18, read with section 20, which is being
Where is the
pending.
complaint proceeding?
That is at page number 42. This is my complaint.
To whom you have made the complaint?
Madam, to the respondent number 1. Page number 42, my lord, annexure P5.
When you made the complaint?
This is the, my lord, the letter, my lord, this page number 42, my lord. 18th October from Shubroto Goswami to the State Chief Information Commissioner. Who is the, has my lord got that? Page number 42, running page number 42, annexure P5.
Yes.
Complaint under section 18, read with section 20. I just want disposal of this proceeding, my lord.
Commission was defunct, lordship, now. 2020, March 2026, from commission was defunct, lordship.
Why?
Chief Information Commissioner retired.
So retired.
Lordship, and the subject.
Now newly, not no one is appointed, lordship, in this.
Appointed.
My lord, the subject matter, whatever was in the RTI, that has already been agitated in the appeal. And appeal court has said that give us all the, and we are following their process. So this is nothing.
The petitioner has initially filed an application before the SPIO for supply of certain information. As the SPIO has not provided the said information, the petitioner has preferred an appeal. The second appellate authority, that is the State Chief Information Commissioner, by an order dated 7th of September 2023, directed the SPIO to provide the information in connection with query number within bracket small c and d. C and D. Full stop. In compliance of the order passed by the State Chief Commissioner, Information Commissioner, the office of the SPIO and the Executive Officer, Kamarhati Municipality, by a letter dated 4th of October 2023, has answered to the query number C and D. Full stop. Then it is the contention of the petitioner that the information supplied by the SPIO dated 4th of October 2023 is a false information and not in compliance with the order passed by the State Chief Information Commissioner dated 7th of September 2023. Accordingly, the petitioner has made a complaint to the State Chief Commissioner and State Chief Information Commissioner under section 18, read with section 20 of the Right to Information Act, but in spite of receipt of the said complaint, the second appellate authority, that is the State Chief Commissioner and Information Commissioner, has not considered the same, and the same is still pending. Full stop. Land Counsel appearing for the State Chief Commissioner of State Chief Information Commissioner submit that after the superannuation of the State Chief Information Commissioner, the office is vacant, and as such, it is not possible at this stage to dispose of the complaint filed by the petitioner. Consider the submission made by the counsel for the respective parties. This could find that the petitioner has already made a complaint against the SPIO for supply of incorrect information dated 4th of October 2023, and the same is pending before the second appellate authority. In view of the above, the second appellate authority is directed to dispose of the complaint filed by the petitioner dated 13th October 2023 under section 18, read with section 20 of the Right to Information Act within a period of 6 weeks from within a period of 4 weeks from the date of appointment of the State Information Commissioner. WP dispose and to communicate. You are not at the order. After appointment of the State Chief Commissioner within a 4 weeks, after giving an opportunity of hearing to the petitioner and to communicate the said order to the petitioner within a week thereafter.
Extremely. With your lordship.
Yes.
The lordship rises. Number 33, I was appearing, my learned friend is the petitioner. At 2 p.m. today, I have a fixed matter at court number 30. I can come back around 2:30 p.m. Your lordship can accommodate for that much of.
Okay, I will get it passed, or if the 2 p.m. matter is not taken.
Yes.
If 2 p.m. matter taken, continue till 30, I don't know. On 3 p.m.
If it is called on, one of my junior will be there.
Which number?
33. I'll come back by 2:30.
Okay.
That will not go much. But
Lord, item number 32 is already item number 32 is already infructuous. I believe the petition because bank freezing matter, my lord.
32.
Yes,
Yes,
bank freezing matter, my lord. It has already been unfreezed.
Subsequent to it, my grievance was freezing of my account. Subsequent to that, my lord, Mumbai police has given the instruction to the bank to unfreeze. And they have unfreezed it, I believe.
Well, it is
Kindly
clear.
record submission of my
Yes,
learned
it has
friend.
been unfreezed, my lord.
The petitioner has filed the presented application for with the prayer upon the bank to defreeze the saving account number of the saving account number 50-100-429-322-425 of HDFC Bank Limited, College Street Branch. Then counsel for the respondent bank has handed over the communications dated 13th March 2026 and submit that on receipt of the report from the investigating agency, the bank has already defreezed the account of the petitioner and nothing remains in the presented application. In view of the submission made by the counsel for the respondent bank and the communication submitted by the bank, the writ petition, this court find that as the bank has already defreezed the account of the petition, no order can be passed further, accordingly then disposed of.
My lord, 34 is also adjournment is required.
Lord, I appear on behalf of the petitioner. Lord, I am led by Mr. Odindam Banerjee. Lord, please come and join me. Lord, permit me to start, Lord, the matter, Lord. Lord, I think state is represented now.
Yes, you are appearing. Yes, what is the matter?
Lord, yes, Lord. Lord, the petitioners, Lord, before your lordship, Lord, are and the business of the petitioner, Lord, are cattle sheds, Lord, cattle owner, they produce milk, Lord, khatals, Lord, they are Lord, cow sheds, Lord, khatals, Lord, my Lord will remember this matter. Now, Lord, the forefathers of the petitioners were, Lord, engaged in this business. Now, my Lord, initially, Lord, khatals, Lord, they were situated, Lord, within the vicinity of Kolkata. Lord, they are Kolkata, Lord, Calcutta. Lord, thereafter, Lord, under the scheme of the government, they were rehabilitated. They were rehabilitated before the outskirts of Kolkata, Lord, in the Modhamgram, outside Lord, Modhamgram, Lord, outside the vicinity of Modhamgram. Lord, thereafter, Lord, they were paying rents. The rents were accepted. Everything was done, Lord, till 2014. Lord, after 2014, Lord, they were asked, Lord, to vacate the property because the area, Lord, which was there, in which, Lord, these khatals were operating, Lord, the cow sheds, cattle were operating, Lord, they were blocked under the vicinity of Modhamgram municipality. So, Lord, the very purpose for which, Lord, they were first rehabilitated from Kolkata to Modhamgram, Lord, again that portion, Lord, came into, Lord, effect. Lord, after that, Lord, they were given notice of eviction. Lord, challenging that notice of eviction, Lord, we filed a writ petition before the Honorable High Court, Lord. That is the first round of litigation, Lord, which was ultimately dismissed, Lord, by His Lordship, Lord, Honorable Justice Ravi Kishan Kapoor. But that order is there. Lord, we prefer an appeal against that order before the Honorable Division Bench. Lord, now the Division Bench hold in our favor, stating that no, they were operating a valid business. Now there were maybe some dispute with regards to payments of rents and everything. Lord, all these facts, Lord, which were initially argued that this project has been uprooted from Kolkata to other places. Lord, all these facts were there, Lord. Now, Lord, knowing, Lord, all these facts, Lord, the Honorable High Court, Lord, the Division Bench permitted us that pay the entire dues, Lord, which are there to the licensing authority and apply for fresh license before the authority. Lord, we applied that. Lord, that was rejected. Lord, against that rejection, Lord, we have preferred, my Lord, this particular writ petition. Now, Lord, kindly come, Lord, first to page 78. Lord, I will show, Lord, the documents one after the other. Page 78. Lord, the 78, Lord, type copy is at page 79, Lord. 70, sorry, yes, Lord, 78, Lord, sorry, Lord, 78, yes.
Yes.
Lord, this is, Lord, how, Lord, the government, Lord, allotted cattle shed in CSR project Ganganagar. Lord, this was initial, Lord, this is the allotment letter of 1997. Lord, the petitioner were forefathers were working, Lord, prior to that also. In reference to your application dated 28/8/1997, you are hereby allotted with sheds number 6 having capacity of 102 at cattle resettlement project. My Lord, pausing here for a moment, my Lord, this is a cattle resettlement project. Because I tell your Lordship, I have told your Lordship that initially, my Lord, this project was within the vicinity of Kolkata. Now, my Lord, there was again a law that cattle cannot be kept within the municipal limits. That's why, my Lord, we were rehabilitated. Now, my Lord, our business has not been declared as illegal or anything like that. With effect from 1/11/1997 in accordance with the terms and conditions mentioned in the bond. My Lord, thereafter, my Lord, bonds were executed. My Lord, we went on going making payments, but this is the first time, and my Lord, the bonds were also executed only one time.
Yes.
But after where rents were paid, my Lord, there was no dispute. My Lord, payments are an acceptance of rents, my Lord. Already, my Lord, it was constituted that this arrangement is continuing. My Lord, thereafter, what happened? My Lord, till 2024, my Lord, there was no effect. My Lord, now, my Lord, page 85, my Lord, is the agreement. My Lord, that was also executed. My Lord, execution of bond, Miller, it's written as sold, Miller, bond in respect of renewal of license, Miller. These were the bonds, Miller, that's were also to be executed, Miller, there, Miller, of other persons, Miller, everything, Miller, is that is there. Miller, thereafter, what happened, Miller, in the year 2024, 2014, Miller, but termination, Miller, please, Miller, page 109.
What the agreement says?
Lord,
There is an agreement with regard to the extension or whatever it
My lord, only bond. The bond says, my lord, I will go through the bond, my lord, that I have gone through the terms and 85, my lord, it is that I have gone through the terms and conditions in respect of allotments of cattle shed for keeping cattle for commercial purpose at the cattle resettlement project Ganganagar Airport. That I have clearly
and it comes
understood.
up page 87.
Yes.
Clause 13.
Yes, that I am liable to vacate the shed. Milord, I will come to that portion. Yes, I will come to that. I am no, Milord. I am liable to vacate the shed, if allotted to me as and when the government desires.
Correct.
Yes. That in the event, Milord, prior to that, in the event of any default in respect of payment of seat rents cover, reserve the right to set and forfeit my animals. Now, Milord, kindly come to page 109. Milord, the type or Milord, a better copy is Milord, page 116. 116. 116. Milord, a better copy, Milord. I am just looking for because there are a lot of petitioners and all copies, Milord.
Yes.
Yes. Whereas the undersigned is satisfied that it's
116.
Yes, 116. 115, 116, Milord is the same, Milord. Does the same thing. Whichever Milord takes.
Yes.
Yes. Whereas the undersigned is satisfied that so and so, son of so and so, is keeping a large number of cattle at shed number so and so at cattle resettlement project Ganganagar, district not since long situated in the premises under Modhamgram municipality. Whereas the license issued by the undersigned for to him for keeping such large animals cattle has long been expired. Whereas the undersigned is satisfied that the aforesaid license yet has not renewed till thereafter till date, and whereas the undersigned is satisfied that as per relevant provisions of section 3 of the West Bengal Cattle Licensing Act 1949, the person is allowed to keep or import in any large animal cattle within the area of Kolkata Municipal Corporation and its surrounding urban age consideration, including the said Modhamgram municipal area except under its valid license. Now, Miller, pausing here for a moment, this is the termination clause. Now, my lord, the question is with regards to valid license. My lord, now, my lord, this was issued in the year 2014. Now, my lord, payments were accepted. My lord, there is no dispute with regards to that. So, my lord, the formal understanding, my lord, there are necessary.
Till which date you have made the payment?
My lord?
Till which date you made the payment?
My lord, when in the 2016, when the first writ petition was filed, Milord, till that time it was paid till 2016. Milord, necessary pleadings and all those documents are there. Milord, the rent receipts are also annexed. Milord, after that, under the Milord, thereafter, after filing of the writ petition, there was a status quo, Milord, order to maintain Milord status quo. Milord, that time they refused to pay, they refused to accept payment. Milord, thereafter, Milord, under the order of the Honorable Court, Milord, we have paid till the disposal of the matter, Milord, and after that also, Milord, under the order of the Honorable Division Bench, Milord, till March 2025 it has been paid. Thereafter, again, Milord, we have.
So what has happened after this?
Milord, we have sent by speed Milord, send the checks, Milord. Milord, they have received.
Now, whatever happened after this order?
Yes, Milord. Milord, thereafter, Milord, this order, Milord, we challenged that we have paid. So the question of Milord license, Milord, it was automatic presumption that the licenses were being renewed because they have never raised this objection. Milord, this was Milord, we initially challenged. Milord, thereafter, upon Milord, this challenge is made, Milord.
So this is the main order.
Yes, Milord. This is the main order.
The impugned order.
No, not
initially.
Initially, Milord, this was the impugned order. Milord, after that, Milord, kindly come to page 154. Milord, the hearing took place. Milord, there were interim orders passed where status quo, and one order, Milord, I would like to also indicate that during the interregnum, Milord, the period when this matter was pending for the first time, Milord, the state respondents who appeared, Milord, they said we have to give them a suitable position. My lord, we will take instruction to that. That is recorded by order of Justice Tandon. My lord, as my lord then was over here, my lord, Justice Tandon's order, my lord, that will also I will show. My lord, thereafter, my lord, the writ petition was disposed of by His Lordship Honorable Justice Kapoor. My lord, kindly come to page 154. Lord, kindly come to page 154.
Yes.
My lord, now, my lord, the petitioner, I am coming, my lord, the entire order, my lord.
No, what has happened?
My lord, the writ petition got dismissed.
Then
Yes,
what has happened?
My lord, dismissed on the ground of maintainability, saying that these are contractual obligations. My lord, the writ petition will not be. Kindly, my lord, kindly come to page 158, paragraph 10, last portion of the order. Paragraph 10, page 158.
Yes.
The writ petition fails on the ground of maintainability and the same stand dismissed. Liberty is granted to the petitioner to seek appropriate civil relief, if so advised in accordance with law. The state respondents are also at liberty to initiate appropriate steps both in respect of outstanding occupational charges or any dues insofar as unpaid electricity bills are concerned. Any payments made by the petitioner during the pendency of the writ petition would stand to the credit of the petitioner. My lord, by way, my lord, this writ petition got dismissed. But we prefer an appeal against that order. We prefer an appeal, my lord, against that order.
Yes.
Yes. Now, my lord, kindly permit me to allow to read, my lord, the entire order, my lord, which was passed by the revision bill because it is a series of observation in between. The certified copy, my lord, page 159, the next. The certified copy filed by the learned advocate for the appellant shall be kept on record. The inter-court appeal filed by the writ petitioner is directed against the order dated 25th February in so and so. The said writ petition was filed by the appellant praying for issuance of the writ of mandamus to direct the authorities to restore electric supply to the sheds allotted to the appellants in the cattle resettlement project at Ganganagar. The appellant writ petitioner also challenged the notices issued by the competent authority dated 27th August 2014. My lord, that order of termination at page 109, which we have showed, by which the writ petitioner were directed to vacate the area by removing large number of cattle sheds within 1 month from the date of issuance of this said letter, failing which they were informed that legal actions will be taken. It is true that the writ petitioner did not file any petition immediately after the notices dated 27th August 2014 were issued, but was filed in the year 2016 after electric connection was disconnected. However, as on date, it appears that the electric connection has been restored. My lord, pausing here for my modern, my lord, the initial writ was on two grounds. My lord, the notice of 2014 and my lord, on 2016, my lord, the electric supply connection was disconnected, which was there in the premises. Now, my lord, as per my lord, the agreement, my lord, they were to pay.
Now, what is the condition? You are still possession of the
yes,
property?
we are in, now we are paying rents, electricity bill separately, my lord. That was
and you are paying.
My lord, rent we are ready to pay.
You are paying or not?
My lord, we have sent them the checks. They have refused.
I am asking whether they are not accepted.
No. Okay. My lord, now we are ready with the checks also. Even today, my lord, I have filed a supplement. I have prepared a supplementary affidavit also annexing all those details. Lord, we have already sent them checks regularly. We are sending them checks regularly. But they are not disclosing the bank details so that we can continue. Yes. The appellants had a benefit of an interim order passed in the writ petition dated October 4, 2016, directing status quo to be maintained by the state until further orders to enable the court to assess the case of the writ petitioner. With regards to the extraction of electric supply, electricity, as the writ petitioners were granted liberty to fulfill their need of electricity by using the generators in the intervening period. However, the respondent licensees were directed not to remove the transformer from the site until further orders without taking leave of this court. As mentioned above, electric supply has been restored and the benefit of the interim order of status quo was invoked in favor of the writ petitioner till the dismissal of the writ petition by the impugned order dated 25th February 2025. The learned single bench was of the view that the writ petition is not maintainable since the dispute is purely civil dispute and certain facts are involved in the matter. The correctness of the finding recorded by the learned single bench is called in question in this present appeal. We have elaborately heard the learned advocates for the parties and carefully perused the materials placed on record. The first issue to be considered is as to whether the petition is maintainable. Admittedly, the petitioner were rearing cattle and carrying on milk business within Kolkata city for several generations. Miller, this is very important. After the event of the West Bengal Cattle Licensing Act 1959, the applicants and the similarly placed person were required to obtain a license under the 1959 Act, and which act was enacted in the interest of public health and sanitation to regulate the keeping of cattle in urban areas and for the purpose to provide for the licensing of cattle. Millard, I think. No, Millard. Okay.
Yes, yes.
Yes, Millard.
It is not in dispute, not paragraph 9.
Yes.
It is not in dispute that the writ petitioners applied for license under the 59 Act and the license was granted and a bond was also executed.
Yes.
Copies of the license and the bond have been annexed in the stay petition, from which it is seen that the licenses were being renewed on a yearly basis. The resettlement of the appellants of the writ petitioners was pursuant to a decision taken by the government, keeping in mind the public health and sanitation and to regulate keeping of cattle in urban areas. Precisely for such reason, the cattle resettlement project in Ganganagar, No.25 Parganas was conceived, and the appellants and other similarly placed persons were required to shift their cattle to the said resettlement area. Therefore, undoubtedly, there is a public element involved, and it is not purely a civil dispute, but it is a matter concerning the rights of the appellants of the petitioners to be granted a license under the 1959 Act. At least up to 2014, the license fee has been received from the appellants, for which receipts have been issued by the cashier in charge, WFB ARD department. It appears that thereafter the appellants did not remit the license fee, nor a formal order of renewal of license or fresh license was granted, nor a fresh bond was executed. All this is noticed by the division bench.
Yes.
According to the learned advocate appearing for the respondents, the total outstanding payable by all the 11 appellants with petitioners as on March 5, 2025 is 1,08,52,268. This amount has been shown to be due and payable as per the accounts officer, project office for WFB so-and-so department, Government of West Bengal. Details have been furnished in a tabular format. The format has several columns, of which one of the columns is the amount due as on 28th of February 2025, and the last column is the amount received as on 28th of February 2025. Admittedly, as on February 28, 2025, a sum of rupees 27,93,206 has been received from all the appellants of the writ petitioners. Thus, one can infer that though a formal renewal of license was not granted in favor of the appellants, but the license fee has been received, which can be construed to be deemed renewal of license. However, we cannot infer such deemed renewal in the instant case, as the payments were made by the appellants pursuant to the interim direction issued by the learned writ court, and the payment has been received by the authorities without prejudice to their rights. Nonetheless, the license fee has been received up to February 28, 2025. According to the respondents, there is still an amount of rupees 1,08,52,268 outstanding as on March 5, 2025. Learned advocate for the respondents refers to third paragraph of the notice dated August 27, 2014, which was impugned in the writ petition, stating that the appellants cannot have cattle within the Modhamgram municipal area. However, the notice itself states that no person is allowed to keep cattle within the area of the Kolkata Municipal Corporation and its surrounding urban agglomeration, including the said Modhamgram municipal area, except under its valid license. Therefore, if proper meaning is given to the notice dated August 27, 2014, it would mean that a person intending to keep cattle has to possess a valid license. Of course, the appellants also have to be faulted for not applying for license promptly prior to the expiry of the license in the year 2014. However, considering the fact that the appellants were resettled in this particular area presently, where they are carrying on their business, and if according to the authorities, they cannot carry out the activities in the resettled areas, then they should be informed accordingly. And this is more so because the appellants were allowed to have their cattle in the area in question pursuant to a cattle resettlement project framed by the government. Therefore, we are of the view that the matter does not involve any civil dispute, and it is concerning the effect and operation of the 1959 Act and matters connected therewith, and therefore we hold that the writ petition is maintainable. In the light of the above conclusion, we are inclined to issue appropriate directions to enable the appellants to apply for a license before the appropriate authority, which should be considered in accordance with law by passing a reasoned order. This liberty can be granted subject to the condition that the appellants clear the entire arrears of rupees 1 crore 8 lakhs and odd, which is said to be due and payable as on March 5, 2025, and continue to pay the license fee at fixed rates till the application for grant of license is decided by the concerned authority. Accordingly, appeal allowed, order passed, set aside. And the direction is that set aside with a direction to the appellants to apply for a license before the licensing authority under the 59 Act within 2 weeks from date. And if such application is filed, the licensing authority shall consider the application in the light of the 59 Act and the connected notification and pass a reasoned order on merits and in accordance with law, directed to comply within a period of 6 weeks. Insofar as electricity supply is concerned, since it has been restored as of now, same status quo shall continue subject to a condition that the appellants continue to deposit electricity consumption charges to whether the deposit called upon to be paid. Now, this was not appealed from by the state government. This has now become final and binding. Every objection that was there prior to this has been watered down. I won't say it has been completely taken away, but watered down. As on the date of the order of the division bench, there was a direction for consideration under the 59 Act. So, we made en masse, my lord, applications. We've also made, my lord, payments. And if your lordship kindly sees, this is the reasoned order at page 165, annexed to P5. All the things that were historically there have been cited to be the reason for non-grant. May I just satisfy your lordship without, my lord, taking your lordship through the entirety? No, please come, my lord, to the last part.
Yes, 168 paragraph 13.
Yes, yes, yes.
168 paragraph.
Yes, yes. Now, my lord, kindly sees up to paragraph 12 entirely. It's a summary of facts and history. Now, this is the consideration. Now, it is seen from the records that after 2001, 2002, and 2005, the appellant petitioners did not apply for renewal of license as per the Cattle Licensing Act 1959. They have applied for the same on 19th March 2025, only after the judgment dated 10th March 2025 of Honorable Court. They didn't even bother to pay the fees which were due since long until 2024. Instead, they filed a writ petition after the electricity got disconnected due to non-payment of the bills and have obtained a status quo order on 4th October 2016 and have since continued to enjoy the premises without renewal of the license or paying the due rent. Keeping cattle within the jurisdiction of a municipal area without license of the appropriate authority is an offence as per the West Bengal Municipal Act 1993 as well as the West Bengal Cattle Licensing Act 1959. The applications submitted by the appellant petitioners for renewal of license are not as per Rule 3.1 of the West Bengal Cattle Licensing Rules 1985. License granted to the appellant petitioners expired long ago. Moreover, clause 13 of the bond agreement states that the licensee is liable to vacate the shed if allotted to him as and when the government desires. Therefore, in the light of the foregoing and going strictly by the West Bengal Cattle Licensing Act and the fact that the submitted applications for renewal of license are not as per Rule 3.1 of the West Bengal Cattle Licensing Rules, and since the land where petitioners were rehabilitated long ago is required to be vacated for projects of a public nature or purpose, the applications of the appellant petitioners for renewal of license are hereby considered and rejected. 4 points of rejection. Historical points crop up. In my reciprocal submission, those historical points could not have been pressed by them after the order of the Honorable Division Bench. Second, they are saying that the applications have not been made in terms of Rule 3.1 of the rules. Now, my lord, we had made the applications, my lord, and if it was not in terms of the rules, they should have indicated that the rules want that these are the compliances you are required to be made. Order of the division bench could not have been watered down by the fact that perhaps there has not been perfect compliance of the rules. Rules are handmaids of justice. They are there for the purpose of the provisions of the Act. So this couldn't have been a substantive reason. They ought to have informed. They have not informed. On that ground, they cannot disqualify. So this is one. Second is licenses expired long ago, therefore we will not give. The entire situation has been gone into threadbare by the division bench. No appeal carried by the state government, so they are also bound by whatever the division bench has done. The division bench has directed them to consider the question of license in presenti as on the date of the division bench's order without taking the historical baggage into consideration, because otherwise the division bench would have dismissed the writ petition much as the Honorable Single Judge has done. So the second part is also, according to me, irrational. it hits Article 14. Third, land is required to be vacated for projects of public nature or purpose. This is as vague as it can be. If there is a project for public purpose which has come up, then they ought to have furnished details. And even if a public project comes up, this is also a public project. We were resettled in that land pursuant to a resettlement made by the authorities. So there, an Article 12 authority, a state, cannot sit on its haunches and when it comes up says, I think we'll leave that land, therefore you get out. If there is already a public project of similar or better public interest, then it is for them to record that in the order. There also they should give us time and place to be rehabilitated, because cattle rearing and ancillary activities have been carried on by us from the time of our forefathers. This is a right, a freedom protected under 19(1)(g). I'm not suggesting that we are inviolable. The only thing I'm saying is the state, sitting in its armchair, cannot really act as a private landlord or even Lord a Gunda. Now, Lord, not that they're acting as one, the latter. Now, Lord, the last one is, there is absolutely no bar to keeping cattle as a law. What is required is the cattle has to be kept in terms of a license, which means there is no bar under the law. If there is no bar under the law today, my lord, then this does not amount to, these laws do not amount to a reasonable restriction on my right under 19(1)(g). My freedom under 19(1)(g) cannot be curtailed by this particular requirement of taking a license. And after accepting the order of the division bench, falling back on this is actually really sitting in appeal over the order of the division bench, which the authority could not have done. There's only one very encouraging development. I'll give you take your lordship's 30 seconds more time, and this should be resolved. Encouraging development is that, my lord, sometimes, lord, when the river from the right goes to the left, it goes to the right again. It's the same river, but the alluvial soil that it brings in is different. Sometimes
you can change the direction of the river by cutting
and make the direction of the river, and the color of the alluvial soil sometimes will be yellow in one place, it might be orange in another, it might be green in another, but it's the same river. So because it's the same river, and we are at a place where it has
might be a witness of this Bhutan area.
Since we have just in the near past seen another meandering of the river into other colored soil, the chances are that whatever we are doing here should be lauded rather than scoffed at, because we are doing interest for the seva of Go, and we are also deriving our sustenance from that 19(1)(g), and things even aside of that, outside the constitution also tend to be helping this meander. So, my lord, one respectful submission is, if my learned friend could take instructions, we don't want to, who wants to fight a government who wants to support cows as much as we do? So, my lord, why does my learned friend not, I'm just humbly submitting, take an instruction on what policy the government will be making in respect of ours, and I'm sure that we are going to get some policy which will consider our interest, the interest of the cattle, and the interest of the state.
How many cattle are there?
The total more than 1,000, I'm told. More than 1,000. It's part of a government policy. Earlier government had other important things to do. Therefore, they decided not to take care of us. It's the same state, but
so
different.
How are you maintaining the 1,000? Where are you getting the all grass and all this?
My lord, we are
feeding.
Feeding, my lord, we are bringing it. Oh, it's a project. I'm told that even fodder grass and all are being grown there.
Yeah, that's
so right. They are taken, cut, and otherwise not. Yes, if the cattle have even half the appetite that Lord I have, then it's very difficult to satisfy their hunger by external import. So, Lord, only one prayer, my lord, I had. We are at loggerheads technically because she's on the other side of verses in the writ, but I don't think that we are actually at loggerheads. He can rebut me on merits. I am ready. Constitution and all that, I have come ready with those judgments. But I do not think that that need might arise. If my learned friend can go back to their authority and the concerned ministry now and take instructions on what they are going to do about a cattle resettlement project, I think that will be the best win-win situation for everyone.
Yes.
My lord, due to respect to my senior, I have some points, my lord, submit to the court.
On merit. Before that, what I'm requesting my learned friend is, before we become adversarial, let us see whether we can become synergetic before becoming adversarial. I've come ready with my ammunition. You've also come, sister. I'm ready. We are surely will consume the time of court at an appropriate time. Only submission I'm making today is let them take instructions as to whether there is any such policy that can be done or has been done. If they say no, and then they toe the line of the earlier government, then this meander of the river doesn't matter. Then I go by the fact that it's the same river.
That's it. I shall
No, take because
Take
whether
instruction, come
the
back.
government is facing any further project or what or thinking about any further things what is to be done for resettlement of the cattle project, whatever it may be. I don't think there will be any adversely effect.
Yes, I don't think there will be anything adversarial. We are all on the same boat now.
Yes, ma'am.
It's just that different parts of the boat.
I shall take instructions.
She take instructions, let her come back, একটু জেনে আনুন, একটু সময় নিয়ে
Within
ফর্টনাইটের মধ্যে বলেই তো পারবেন, আমার চাপ নেই, আপনি বলতে পারবেন ফর্টনাইটের মধ্যে
3 weeks.
3 weeks, maybe 4 weeks, মানে for her to come back with it. If she comes back, it's all right. If we fight, we fight.
It is a ministerial decision is to be
So it will take some time. It has to go up to cabinet and all. আমরা 3 সপ্তাহ হয়ে যাবে.
I don't think the cabinet will be there within 15 days. Okay, whatever. Learned counsel for the petition argued the matter at length. Learned counsel for the respondent state pressed for time to take instruction. Accordingly, case is adjourned. Let the matter appear on September.
এর মধ্যে নিয়ে রাখুন, যদি ওরা বলেন যে না আমরা কোনো কিছু নেই, তাহলে তারপর আমি আপনি লড়বো যেমন লড়ছি, জেতা হারা যা হবে। হ্যাঁ, না আমিও প্রিপেয়ার লড়ার জন্য, কিন্তু লড়ে কি লাভ, যেখানে লড়ার যদি স্কোপ না থাকে। হ্যাঁ, কবে?
At 2 p.m. 15 September at 2 p.m. Come with the instruction.
Yes.
What? Entry mode is there?
Yes, it's still disposal. I'm grateful to your lordship. Lord, is your lordship has heard us. Is your lordship considering, my lord, marking the matter partly heard? In this case, my lord, not only me, but 1,000 cows are also at stake.
Okay.
Lordship will not mark it part, my lord.
No. That will come.
Fair. Obliged, lord.
Kindly fix the time, my lord.
2 p.m.
2 p.m.
Yes, call the matter.
Obliged.
My lord, item number 30.
Yes.
My lord, item number 33. I am appearing on behalf of the petitioner, my lord. This is, my lord, that matter.
For the other side.
Strategy was here. He was just here, my lord. This is that matter where my lord had released the matter on the ground, my lord. That
recalling of the order.
Recalling application, my lord. If my lord sees the.
Who is for the other? Where is?
My lord, I'm praying for short pass.
Let he come.
My lord.
I appear for election commission
Hmm.
on same issue. Our division bench of our
34.
election commission.
No. 34 is Howrah improvement trust.
34 is not SIR, not election commission.
35. Yes.
My lord, 34 is read petition.
Yes.
My lord, only we are on the point of holding the execution of the registration of the deed. Kindly see annexure P6, page P6. I have the page to follow.
Declaration of permanent injunction. Decree passed.
No, my lord. No.
P6 is a suit.
My lord, kindly see the page. Page 29. We have already served ABDB service, my lord.
Page 29.
Page 29.
Yes.
My lord, in order to rehabilitate the shopkeeper, shopkeepers, effect of improvement of junction of Benares Road, the newly constructed shop owners, 43 Benares Road, PS Batra, District Howrah will be allotted to the shopkeeper for the purpose of rehabilitation on 99 years for lease as follows. Accordingly, the petitioner, my lord, serial number 8. Serial number 8, and he has already paid all the amount, that is 3 points, my lord. 541 square feet, 544 square feet, and 169 square feet. And total accumulated amount 12 lakh 43,000, sorry, 12 lakh 91,620. My lord, that is in page. No, that is in page. My lord, no. Thereafter, my lord, next page 30. Page 30, HIT respondent number 2 and 3, my lord, asked for 150 lakhs. Kindly see in modification to the office memo numbers such and such, you are hereby requested to deposit an extra amount of 1,50,380. 380 on as lease premium for the personal allotment of staircase, reservoir, and toilet. My lord, 1,50,000. And that's why, my lord, total amount 14,42,000. And thereafter, my lord, page 32. Page 32.
Yes.
Page 32, you have already paid the said amount in the year 2012, that is 19th November 2012. My lord, what happened? Practically, there are two partners. One partner who looks after debts, he was seriously ill in various ailments and illness. My lord, what happened? Thereafter, my lord, some of the agent of the improvement of respondent number 3 came, sometimes come before the, very often come before the shop and demand extra amount and threaten to evict. And that's why, my lord, my client filed a title suit that without due process of law, your petitioner cannot be evicted. My lord, first of all, my lord, possession certificate. That is agreed. Possession already signal running, so shop is running, my lord, and everything is on a record. My lord, thereafter, my lord, kindly see page 35. Two title suit was filed in connection with the in connection with the possession of the said land, not to disturb and not to evict without due process of law before the Howrah court, my lord, district court Howrah, and thereafter another regarding only to not to evict without due process of law. No registration has been paid for. My lord, thereafter another title suit was also filed in connection with the staircase and others and go down whatever may be. But my lord, I am on the point, whatever amount I have paid for that square feet area, please give me the registration. But what they have said, kindly see. Page, my lord, kindly see page 49. It is sufficient, my lord. Page 49.
Yes.
With reference to your letter dated received through email dated above, this is to inform you that your client Topon Kumar Guho Chaudhary has filed a case being TS number 1605 of 2023 against KMDA. Against KMDA such and such. My lord, what happened? What title suit has been filed? We have made answer to the KMDA. Kindly see page 56. Page 56.
Yes.
Page 56. We have already said page 56, contest, my lord, page 57, that is second para. Second para. Honor, before making the said reply, you have not properly briefed for your file, or perhaps you may have overlooked the subject matter of the aforesaid title suit, TS number 1605 of 2023, which is not at all with the execution of the registered deed and list deed, and any prayer of relief has been prayed for. No relief has been prayed for. And thereafter, my lord, they have not given any reply, nothing. And that's why, my lord, this is considered. We have again prayed for execution to execute the said title deed as asked for in the letter dated 8 September 2025 without any further delay. And thereafter, my lord, the instant petition has been filed.
Yes.
My lord.
Yes, madam. What is the matter? Don't have any.
I don't have even any copy also, my lord.
My lord, it is kind enough. My lord has seen last 2 months ago, we made the urgency and your lordship has considered this one. This is the urgency, and several times we have mentioned 2000.
But your client is very intelligent.
No, my lord, what happened?
Then the advocate filed 2 civil suit, same prayer. How the civil judge is maintaining the 2 civil suit in the same prayer?
My lord, generally.
And you file the suit for permanent injunction without asking for the declaration.
The declaration, my lord, regarding the not to disturb. Without.
That's what I'm telling. You are asking for the permanent injunction without declaration. Permanent injunction for what basis?
Yes.
Yes.
My lord.
And on the second way, you are asking the what? Where
No, we are ready to withdraw the suit.
What is the wrong in the order passed by the authority? Yes, you went to the civil court. You go and fight in the civil court. Why you file the writ petition here now?
My lord, that we are ready to withdraw, but execution of the title deed is our, my lord, right.
So you could have been you could have been taken the declaration from the decree from the court for the execution of the deed.
But we have not prayed for.
I am giving liberty. Either you made a prayer before the civil court or whatever. With the pending civil court, the writ will not. I will not entertain the writ.
My lord, kindly see that relates completely for the purpose of the not to disturb. We are ready to, as soon as the registered deed is
You
perfect.
will tell. You are in the bar room.
Yes,
Your bar room. You are having a chair and table. Unless and until you are not having the enrollment in the bar, can you say my table and chair may be given to me? Can you say?
Yes, my lord. They have said
you are claiming your right over the property in terms of the notice issued by the authority wherein you have deposited the amount.
Yes.
So you have deposited the amount, you are entitled to get the shop room. They have received the amount, but the deed has not been executed. Correct. Then you went to the civil court for permanent injunction not to disturb your possession, but you have not went to the civil court for registration of the deed in terms of the payment received by the authority. Now you are filing the writ petition.
It is a wrong drafting on the part of that concern. My lord, what
That
happened?
two suits.
That suit was filed on the basis of torture from the agent.
And 2 suits, not 1 suit, 2 suits.
2 suits, my lord. There are 2.
Of the similar prayer. Can you see the prayer? Similar prayer.
I have seen that.
Can it maintainable? That's why you came to know that the suit is not maintainable. Immediately file the writ petition.
No, my lord. Suit was, I will withdraw the suit as soon as
you came to know that yes, your suit will be defeated. You file the writ petition so that you can get the remedy before the writ court.
No,
don't play with the court, sir. Don't play with the court. At least before this court.
No, I am not.
So why you file the civil suit? Why you are coming before this court registration? Why you are not paid for
that
the
civil suit
decree?
With the bylaw not to dispose of, not to disturb, without due process of law. You cannot.
What type of the advice you are providing to the your client?
I am not going to deal with that. Howrah court, my lord, that is NBIR.
So why you are accepted for filing the writ application? You have filed the writ application. Why you accepted the brief?
My lord, let the liberty be given to the writ petitioner. Liberty be given to the petitioner before the civil court for right of the execution of the deed.
What liberty? You are having all liberty. Civil suit, plaint can be amendment at any stage.
My lord, it will be.
What is the liberty is required?
Liberty is required, my lord, as because.
What is the stage of the suit?
Stage of the suit, my lord, of the injunction hearing is only.
What is the stage of the suit at present? The suit is filed 2022. Now we are on 2026, entering 2027 now.
Still, my lord, only hearing of the injunction.
It's still going on. Yes. I got the interim order.
There was no
got the interim order.
Yes, my lord.
You got the interim order.
Because there was no judge.
You got the interim order or not?
Yes, got the interim order.
Yes. Yes, madam. You accepted the amount. Why you are not registering the deed?
That I shall take instruction.
What instruction? Because of the civil suit, you have taken the 14 lakh rupees, and you are telling the civil suit is pending. Then counsel for the state press time to take instruction. with regard to the prayer made by the petitioner in the present date application. Accordingly, case is adjourned. Let the matter appear on 7th August. Next,
7th August.
call the password matter.
Lord, I appear on behalf of the petitioner, my lord. This
Yes.
CAN 3 has been filed, my lord, praying for recalling of the order dated 2nd April 2026 passed
CAN
by
3.
CAN 3, my lord.
Yes.
CAN 3 has been filed seeking recall of the order dated 2nd April 2026 passed by your lordship, releasing the matter, my lord.
Where is the order?
The order, my lord, will find at page 10 of the application, my lord.
CAN 3 or CAN 2?
CAN 3, my lord. CAN 2 is for a different.
Page?
Page 10, my lord, of the application. My lord was of the view that since the at para 1, since finds that the petitioner have prayed
Yes.
for quashing.
Not having the determination.
Yes, my lord.
Yes.
So after this, my lord, what we have done, my lord, we have at page 17, my lord will find a letter which we have issued to the special officer on special duty, praying for assignment of the matter. At this stage, my lord, we were informed that this matter cannot be assigned because it was released on ground of determination. So we were directed to mention the matter before the judge having the determination regarding police inaction. We mentioned the matter before the learned judge on 2 occasions, my lord. And the learned judge, my lord, has handed over to us an order which is appearing at page 20 of the application, my lord, passed by the division.
Yes, Mr. Chatterjee. What is the submission?
But I said that also, my lord, so far as determination is concerned, I cannot comment.
No. See, that is not. Kindly come to the page 19. Administrative order.
Yes.
The Chief Justice has declared that
Para 3.
CBI will be treated as a police.
CBI, no, my lord, kindly come to para 3.
Yes, para 3, CBI and
Matters
central
related-
agencies.
And central agencies, it will go before the subject category police.
Police. Then thereafter, this is of 30th September. This is administrative order.
Correct.
Then the same judge in the judicial side has passed the order.
Correct. Judicial side has passed the order. Thereafter, in another matter, we sought for clarification. Then the successor in the office of the Chief Justice said that the September 30,
That's why.
2022, we
This is not taken into consideration.
this judicial order was also there, my lord. If I can show what I wrote before his lordship then, when the matter was
But there is a judicial order.
No, administrative. My lord, what I suggest, my lord is taking up ED matters regularly. Other matters are also being heard by your lordship. Your lordship can take up this matter on any date as convenient.
I am
to you.
clarifying this. Recording, na?
Correct.
Recording,
What is difficult on my part, my lord, I tell your lordship honestly. Some matters are going before police action. Some matters are coming before your lordship. So what are my intention, Lord? Let this be decided once for all.
That's why I am clarifying this. I am clarifying this in this CAN
That will
application.
be very much convenient to us also.
I am clarifying this. The petitioner has filed the present application being CAN 3 of 2026, praying for recalling of the order passed by this court dated 2nd April 2026, wherein this court is of the view that this court is not having the determination to hear the present application and release the matter with the liberty to the parties to mention before the appropriate court having determination. After the said order, after the order dated 2nd April 2026, the petitioner has, where is that letter?
Page 17, my lord.
Has requested has requested the office of the Honorable Chief Justice for assigning the matter before the appropriate bench for disposal of the present writ application. Full stop. Full stop. On receipt of the request of the petitioner, it was informed the office of the Honorable Chief Justice informed the petitioner to mention the matter before the appropriate bench. The petitioner has mentioned the matter before the appropriate bench taking the police in action matters. The Honorable Judge, by referring the judgment passed by the Honorable Division Bench of this court in MAT number 1762 of 2022 with Can 1 of 2022 dated 23rd of December 2022 has directed the petitioner to mention the matter before this court as this court is having the determination. Accordingly, the petitioner has filed the present application. Full stop. When this court has taken up the matter on 2nd of April 2026, the administrative order the order passed by the Honorable Chief Justice in the administrative site dated 30th September 2022 was placed before this court, which reads as follows. Page 19, Eta Corina. The said order specifying that the matter relating to CBI and central agencies in writ petition under 226 of the Constitution of India are already included within the comprehensive reading of subject category police in the appellate side rules. As this court was not dealing with the police in action matter, accordingly this court has released the matter. And the police in action matter is being taken by is having the determination with the other honorable judges, honorable judge. Now, police talk. Now the honorable judge, when the matter was placed mentioned before the honorable judge, the honorable judge has relied upon the judgment in the case of Directorate of Enforcement, Ministry of Finance versus Menka Gambhir and another.
Right.
In MAT number 172 of 1762 of 2022, dated 23rd December 2022, wherein the Honorable Division Bench has held as follows. Paragraph 8. Set out query. 23-24. Okay. Full stop. Considering the administrative order passed by the Honorable Chief, considering the order passed by the Honorable Chief Justice in the administrative side and the order passed by the Honorable Division Bench in MAT Division Bench dated 23rd December 2022, wherein the Honorable Division Bench has held that the process envisaged by Section 50 of the PMLA is in the nature of inquiry against the proceeds of crime and is not investigation in strict sense of the term for initiating prosecution, and the authorities under PMLA are not police officers as such. Full stop. Thus, the contentions of the appellant that the London single judge has not jurisdiction to hear the writ petition cannot be accepted. Considering the above, this court find that about the administrative order, the judicial order will prevail, and as per the judicial order passed by the Honorable Division Bench dated 23rd of December 2022, this court having the determination to hear the matter accordingly, order dated so and so is recalled. Full stop. Let the writ petition be placed before this court for hearing.
I would maybe request for a date for hearing because
yes, can number 3 of disposed of. List the matter on.
Because we require some urgent interim release, my lord. My lord, may kindly
You are roaming here and there for the last 2 years, 1 year.
We require urgent interim release, my lord, because
एक 12 अगस्त में लास्ट में देखो 20-22 अगस्त को देखो can dispose of.
My lord, may I pray for any date after 27th?
27th August.
No, July.
August.
I am fixing in August. Not in July, it is not possible.
ওরা তাড়াহুড়ো করছে তো আমি ডায়েরি দেখে বললাম ভাই
সেখানে নেই।
ছুটি হচ্ছে না।
Saturday, হ্যাঁ তাহলে তো
19th August at 12 noon.
Very grateful to you. I'll just indicate in short, the only point which we are going to urge in the writ petition is that the predicate offence is closed and hence, my lord. That is the only point which we are going to urge.
That only point has a bigger implications and plenty of arguments because of the same point they are filed application in criminal code. I indicate to
We'll
your lordship.
indicate that, my lord.
Your lordship will find that.
We brought everything on record before you.
Nobody can deny what is on record.
Very grateful to your lordship.
Yes, thank you.
Deeply obliged.
34 হয়ে গেল।
My lord, I am for the.
Your lordship, I appear for election commission.
I'm appearing for the state.
This was the action challenging returning officers order. In this regard, in a PIL, a decision has come wherein your lordship, the honorable division bench has held that the only remedy available is under election petition.
My lord, this writ petition was originally filed to challenge the nomination of the candidature of the respondent number.
Writ petition?
Yes.
What is your challenge?
My lord, the nomination.
So how the nomination will be challenging the writ petition?
My lord,
It has become infructuous. No, in the very initial stage, I passed one order.
My lord, praying for.
You had appeared, I think. No, you are not appeared in that matter.
My lord.
It's not maintainable also.
My lord, praying for leave to file a supplementary event.
What?
But for subsequent event, there is.
You will lose your right also. I think that also will
I'm handing over the order copy by which he is protected. He has to approach the.
Otherwise, you will lose your right also for the election petition. Can't be. Can't be in the writ petition, sir.
And then we liberty to file.
If, as you, the court is not forcing you.
Election petition like way.
Even this writ petition is other way around is not maintainable also. This is becoming infructuous. The election is over, everything is over.
Election is over. But what order will pass? Again, your nomination is to be accepted. So if your nomination is accepted, what will happen?
My lord, I have to take instruction from my senior. And he is in serious ill.
If suppose, if today your writ petition is allowed, your nomination, I will direct the returning officer to accept your nomination. What will happen? What will happen? Yes, what?
Page 4, your lordship. Petitioner case is that he had migrated from Bangladesh, so he cannot put himself under any caste. This seat was reserved for a caste on caste basis. So any Hindu has to wherever he is located, the caste will be there. Intrinsic ground to be challenged.
What do you want? Tell me. Take instruction.
Very nice. Liberty,
Liberty to.
Liberty to? File a.
Liberty to
before the appropriate court.
an appropriate court in accordance with.
Learned counsel for the petitioner. Petition has filed the affidavit service let the same be kept with the record. Counsel for the petition prays for withdrawal of the present date application with the liberty to take appropriate step before the appropriate court. In view of the submission made by the counsel for the petitioner, WPA number 9536 of 2026 is dismissed as withdrawn with the liberty to the petitioner to take appropriate step before the appropriate court of law.
Grateful.
Yes, cross.
My lord, prior, my lord takes up the original site matters. My lord,
Yes.
my lord, prior taking up the original site matters, my lord, I'm apologizing for one fact, my lord, to mention a matter, a leave matter, my lord. My lord, the auction sale will be conducted on 17th, my lord. And my lord, I'm challenging that notice, my lord. Kindly, I'm praying for leave to file the.
Now you want to leave. Where is your writ petition?
My lord, I have it. My lord, this is.
When you are found?
My lord, today itself, my lord.
এটা দে দেন 17 तारीख को रख दो leave granted short notice 17 within 10-15 matters
I'm grateful to Lord.
10 matters में कर
My lord, upon notice, I'm mentioning this matter for extension of interim order. my
which
lord.
one
My lord, the original side, my lord.
appellate side
Original side.
yes
Upon notice, my lord, I'm mentioning this matter. My lord, the interim order is going to expire on 16th July.
16 July who is for the other side
My lord, the copy been served and through mail.
it is not in the list
No, my lord.
the petitioner the plaintiff has mentioned the matter ये हमारा कोर्ट का है तो लिस्ट में क्यों नहीं हमारा तो सब लिस्ट में है it is before this court
Yes, my lord. The matter is
Specially assigned matter.
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 Yes, my lord.
the land counsel for the petitioner mentioned the matter and submit that the interim order is still 16th of July 2026 and prayed for extension of interim order. In view of the submission made by the counsel for the plaintiff, the interim order is extended till 27th of August 2026 or until further order.
My lord.
My lord, may I wish to mention, my lord, item number 203 and 204 of today's list, my lord. There was a direction to file the opposition by my client, my lord. I am slightly delayed. I have served the copy to my learned friend on 14th of May, my lord. There is some delay. I am ready.
Okay, when the matter call, you serve the copy to the other
But
side.
there was a time to file the reply have also expired. So
Okay.
unless the order is extended, my lord.
That you submitted the supply the copy.
Yes, my lord. I have supplied, but
where is the other side?
Your lordship, I appear for the defendants.
Item number
203 and 204 analogous. It is in respect of 204, my lord. May I file the opposition, my lord?
203.
203 and 4, my lord. 204, I am filing the affidavit in opposition, my lord. Assigned matter, my lord. Sangita Shah versus Jaya Shah, 204, my lord.
Lordship kindly extends the time to file affidavit.
So you have filed the affidavit in opposition in which matter?
204, my lord.
204. 204. Huh? The counsel for the defendant has filed affidavit. Defendant, you are the defendant.
I am for the plaintiff in 204.
The plaintiff has filed affidavit in opposition in connection with GS 7 of 2026 after serving the copy to land counsel for the defendant. Counsel for the defendant prays for time to file reply to the affidavit in opposition. Let reply be filed within 2 weeks. 2 weeks, let the matter remain in the list. Yes.
Good. Yesterday the matter was Monday it was fixed, Millard, a matter at 3 p.m.
Which one?
Millard, it's Millard Harish Kumar Agarwal versus Tamil Nadu Mercantile Bank. Millard, well, Lordship, as I have more or less the only point remains in the fraud case of a bank that whether, Millard, I was heard by the committee. I was admittedly heard by the senior manager, committee is not there. So the order has to go on such basis. Millard, the interim order, Lordship, was pleased to extend from time to time. That's till 17th, Millard. Any date, Millard? Lordship, I'm seeing every day, Lordship is having.
It is 17 को to be mentioned नहीं कर दो.
17.
My lord, I am appearing on behalf of bank.
To be mentioned, let it come in.
Lordship, that point I'll address that. Only
Let
that.
me see.
My lord, any date may be fixed, my lord,
Yes.
because they are in. I am appearing on behalf of bank, my lord.
Which one?
This mentioned.
That's why I am fixing on 17 as a to be mentioned. I will extend the time. I will fix it. I will extend the interim order and fix the date for hearing.
Great.
May I have your lordship's kind leave to mention item number 141 from the day's list? Not a case of cyber fraud admitted by the bank. The urgency is this. Not a pre-approved sanction loan was debited. Bank admits it's a case of cyber fraud, but they are sending recovery agents to my house, and it has also affected my CIBIL score, my lord. That is the urgency. CIBIL score, my lord. My lord, that is the urgency. If your lordship may kindly, my lord, I fix it under urgent motion or, my lord, any day as per your lordship's convenience. I won't take more than 2 minutes.
You will not take. Where is the bank?
My lord, leave
The
stop.
bank has to appear.
They are
on
upon notice. My lord, whenever your lordship fixes, I'll give a notice and come back again.
Item number?
141.
141. I don't think where cover August. Before that, I don't know. If you want a time fix, then 14 before 14th August, it's not possible.
Otherwise, my lord, may kindly list it under the heading urgent motion, my lord.
Urgent motion, I've read that the fixed matter is not been taken up.
My lord, in that case, your lordship will fix it on 14th August, my lord.
Item number?
140.
Item number 140. Or query then. 14th August at 3 p.m. Na?
That's it. I'm grateful.
14th August. Yes, next.
My lord, I'm for the
Lord,
plaintiff.
I'm appealing for the defendant, your lordship. If my lord recalls, my lord, in this matter, your lordship, the plaintiff intended to withdraw the suit. However, my lord, there was some communication or instruction they were to come up with today.
Yes, my lord, after receiving necessary instructions from the client, we have decided not to press this matter any further, my lord.
Not to?
Press this
Where is
matter.
the written instruction?
Ma'am, sorry, my lord, the written instruction, I don't have it with me right now. If my lord,
you are the advocate on record.
No, my lord.
Then who is the advocate on record?
My lord, Mr. Jha is advocate on record. He is currently occupied in courtroom number 35.
So, and you are not having the written instruction?
Then my lord, kindly
got the written instruction?
That I don't have any information as to that, my lord.
Because the old case, then you record the written instruction.
I've got
Otherwise it will be
instruction.
difficult.
I've been instructed, my lord, that my senior have had the necessary communication with the client and that he doesn't want to press this matter any further.
Recorded. Learned counsel appearing for the plaintiff submits that the plaintiff has received an instruction from the plaintiff that the plaintiff is not intending to proceed with the present suit. Accordingly, press for withdrawal of the suit. In view of the submission made by the counsel for the plaintiff, CS number CS Com 2022 2022 with of 2024 within bracket old CS number 367 of 1999, along with all connected application, and is dismissed as withdrawn. Full stop. Consequently, all applications are also disposed.
My lord, kindly records that all the dues have also been paid. Apologies, my lord. Grateful.
Grateful, my lord, grateful.
Yes, next.
Well, at the basis of I am for the respondent.
This is an application. Inter alia, what they have taken the point that we are asking for money. What has happened, there was a PP.
All are money matters.
All are money matters, and there was a PP Act proceeding against my client, that ultimately culminated, into an order from the appellate court, where it was held that my eviction proceedings was bad, damages was bad, and my rent was 8,000 odd. But in the meantime, I paid them nearly in excess of 25 crores. So, after that order, obviously, according to that judgment, they were not entitled to that money. So I have claimed this in this proceeding. But I must point out, in the pending, while the writ petition was pending, when my learned friend came and started taking time for oppositions, they have now preferred, after nearly a year, a 227 from that appeal order. So, the point I'm sure which he's trying to take is that, that
Revision is
is
pending.
That is pending. Only thing what I can say in my defense is, my lord, there is no stay. So therefore, my lord, I would like to proceed, but obviously, my lord, I'll leave it to your lordship, my lord, because I understand the absolute nitty-gritties. Because, my lord, today, my lord, on the face of that judgment, it's a res judicata. So whatever is there, it is there. There is no stay. So, my lord, if your lordship allows me, my lord, if I can proceed, my lord, I think that is what
I
you
tell
want
you,
to
lordship, if lordship, the purport of the order passed in the section 9 appeal, is that, point 1, in respect of a public premises act, transfer of property act will apply, number 1, which is against all the laws settled by
that point if he's taking.
No, point 2,
your lordship.
I have not interrupted you. The point 2, for a 10 bigha, 15 bigha of land, port will charge 8,000 rupees, as it was some point of time 20 years back. So obviously, such order is illegal, and I have challenged it. Now, my point before your lordship, there can be a situation where the two the benches can have different opinions. So it's better to wait for that, because the legality of that, and if that order goes, there is nothing left in his writ petition. There is nothing left in his writ petition, because he is paying for 15 bigha of land. He is paying 8,000, and he claims that he was
your party.
Yes, of course.
Sorry. Malad, he filed it against me.
And it was hard also.
But,
One
Malad,
day it
there
was
is
hard.
no stay. So, Malad, I would only request your lordship, Malad, if your lordship is not minded to take it up, fixes a day for this. Because, Malad, they can't, if the matter is not taken up, I cannot lurch in the dark. So that cannot be the case. They have not got a stay. So, Malad, if they want to, they can get it heard out. But on that, Malad, this cannot continue. Because, Malad, today, Malad, what my learned friend was saying, Malad, that I cannot, but if the agreement says so, I can. My learned friend's client is not over the law, obviously, neither am I over the law. So if there is an order binding of the appellate court, so Malad, that is why I'm saying, Malad, these points cannot be taken before your lordship at this point of time. But yes, I do appreciate that. Is why I brought it to your lordship's notice, Malad, that is pending. But if your lordship is not minded to take it up because of that, but kindly fix a short date, because let them finish it off. I don't have a problem, but they don't have a stay. Therefore, Malad, today nothing prevents. But Malad, if your lordship is not minded,
order.
Malad, which order, Malad, if your lordship?
Which revision is preferred? That is there? No.
The order from which the revision is, yes, Malad, definitely. Malad, that is my main stake, Malad.
Oh, that's very sad.
Malad, yes, Malad. And that your lordship will find.
It's 192.
Page
190.
192, Malad. Volume 2. Malad, kindly take from 196, Malad. Malad, they have made a claim, your lordship had directed, Malad, that whatever rent they think they are entitled to, they can make a calculation before your lordship. They have gone on the basis of schedule of rates. Now, Malad, kindly see the decision with reasons, Malad, that is from 196.
Yes. Lengthy order.
Impugned order. The respondent company's contention that it continued to be a tenant by holding over was accepted by the estate officer. However, the estate officer misdirected himself when he failed to appreciate the legal consequences which that accepted status was bound to generate. Has the lordship got that? And then there is, Malad, obviously, lease remaining in possession of the demised property after the determination of lease of the lessee.
Okay, let us see.
Malad, it goes on and it holds that I am a holding over till, Malad, I am evicted under 106. That is the purport. That there was no 106 notice. Till I am evicted, Malad.
That's why he has prepared an appeal.
Sorry, Malad.
There are judgments galore.
Once your state appeal is
it's an afterthought, Malad, after 1.5 years, Malad.
Once their state proceeding has gone, so nothing then.
No, Malad, why we came before the lordship, I must point it out. We came, Malad, in spite of that order, they started issuing me, Malad, compensation bills, which was completely contrary to the order of the appeal court. Therefore, an interim order was passed by your lordship.
Okay.
So, Malad extends the interim order.
Which is expiring in 7.
Well, the civil divisional bench is also extremely overburdened. Kindly grant me 6 weeks time.
No, Malad.
No.
Fixes the next date where your lordship.
You tell me which court is not overburdened.
Everyone is overburdened. This cannot be, Malad. They are Matlab, they are
No,
not.
but it was hard one day, but he cannot also deny it.
They are not. Matlab,
It was fixed and thereafter determination changed. Matlab, I have to mention again, matlab.
And if there is no intimate, he can go up to the Supreme Court if he wants to.
Learned Counsel for the respondent submit that the respondent has
After the 28th of July, when the CO is fixed, matlab.
preferred a revisional application against the order passed by the additional district judge, 10th Court Alipur, dated 2nd December 2024. And the same is pending before the Honorable Court.
এটা চান্সই নেই দুরান্ত চান্স দুরান্ত
তোর নেই জানি
তোমার
Alipur, and accordingly prays for adjournment of the present writ application. Concerning the submission made by the counsel for petitioner, respondent, the case is adjourned. Let the matter appear on last 19th August.
3 p.m.
19th August at 3 p.m.
First one.
Lordship.
And same position, well, kindly, man.
3 p.m.
Very short.
Is the interim order is still disposal?
Till 17th, my lord. 17th of
Interim
August.
order is extended till the next date of hearing.
Very good.
Yes, call.
My lord, I appeal for the petition along with Mr. Akbar is here.
Yes.
My lord, I'll address your lordships both because the facts are more or less similar. So, my lord, petitioners are in management of 6 tea gardens in North Bengal. Now they are all under the MSME companies. Bank had sanctioned loans to us, CC loan, term loan, as also security, knowing fully well that in the sanction letter it was written clearly that this is an MSME company. So, my lord, it's not a case that the bank was not aware that it was not an MSME company. So loan was sanctioned, loan was being utilized, but nearly 6,000 people have been benefited till the time bank started putting ORI. Thereafter, my lord, we have filed an application before the bank under Section 4 of the framework for rehabilitation, revival, and for ensuring a fair and
Yes, you filed an application for revival. Yeah, then what has happened?
That is there, your lordships. Now, my lord, the bank was well aware this was an MSME company. Your lordship judgment is also passed several orders in this on this issue that till the time the bank does not refer the matter to the board, there cannot be any coercive steps taken against the borrower.
Declaration.
Now, my lord, your lordship will see, your lordship will kindly come to the first matter, section 3, item number 3. Now,
item number 3.
That is
3.
Yes, my lord will see this has been filed to the bank on 13th of June. They have received it.
Page? Which matter? Which WPA? 329?
Yes, your lordship has 329 and 544, please, madam.
544.
Supplementary.
Yes.
Well, this is there to fight. Bank sees stand over the matter. and she said over the matter. Does not refer it to the board, which they are duty bound to do. It's mandatory. The Supreme Court has clearly held that irrespective of the fact whether the borrower sends it to the board or not,
When the NPA was declared?
NPA was sought to be declared on, my lord. Let me both. The
27th February 2026.
And the other one is March.
Yes.
My lord, your lordship is well aware.
And when 13 notice was issued?
13 notice first was issued on January, 29 January, and the other one was issued in March.
March 26.
26.
Yes. I'm going to both the.
So you given the reply to the 13 informing with
Yes,
regard to
yes,
the
we have given
revival
reply.
package in the notice, in the reply.
Yes.
They're not
Separately
considered.
also.
Separately
On June.
Separately
Separately you have given
that
June.
time also.
But reply you have informed with regard to the revival package of yes. Then
No action.
And Bharat, your lordship is well aware that now thereafter they publish it to the newspapers. Very well. Some of the fundamental issue which is before your lordship is when the bank is aware that this is an MSME company and is precluded from taking any steps under any act whatsoever. We were first exhausting the badge given to the borrower under the MSME Act. There is a well settled law, Bharat, and your lordship has followed that also. My learned friend is perhaps argued for your lordship in police school.
Mr. Gupta has got matter.
Your lordship, I think, is Mr.
Gupta mentioned the matter yesterday.
Yes, he was there. He's on there.
Well, I'm there virtually, my lord.
yes.
So just interim protection.
Governor, your lordship was pleased to pass an order in that petition that they will file an application within a week stating that they are MSME companies and the bank will take a step in accordance with law and till such time. Till such time, not to take any steps, coercive steps. In my case, I am on a better footing. Today we are on the 15th of July. They have received the application way back in June 2026. And if they were serious enough, they would have sent it to the board.
Yes. Yes. What the bank is doing?
Lordship, the entire facts has not been placed before your lordship.
Now, whether they are the MSME or not.
Lordship, they are the MSME not in respect of both the accounts. In respect of Merchant Monger Agrotech Private Limited, it is not a MSME. Hospitality is the MSME.
Merchant Monger Agrotech is not a MSME.
It's not. It's agriculture. It's agri loan. Moreover, before that, your lordship, my learned, with due respect to my learned senior, he stayed away and jumped to the MSME, suppressing all the backdrop of the facts, which required certainly affidavit in opposition. But before that, your lordship, before filing these two writ petitions, already two writ petition has already been filed by the writ petitioner before the coordinate bench of this honorable court. Earlier writ petition was filed. The Honorable Justice Amrita Sinha was pleased to direct the bank to dispose of the representation of the writ petitioner within a certain period of time. The facts were involved over there. Your lordship, the Merchant Monger Agrotech Private Limited initially, your lordship, because I have to aware your lordship the facts. They have obtained a case credit facilities of 8 crore and term loan of rupees 5 crore. And they're supposed to, since they were using, admittedly, the tea gardens, they're supposed to provide the securities to the bank, but they failed to. Since the entire loan credit facility of 13 crore was unsecured, the bank has said that since you have given an undertaking to give a security of the garden, but you fail to obtain any necessary permission from the government, so we won't be able to continue with that credit facility. You have to close the same. So then the petitioner has agreed to such proposal of the bank and said, requested the bank to kindly, we are providing you the security because it's unsecured loan. kindly grant a security in respect of a merchant monger hospitality. So we will close this account. Kindly grant us a fresh credit facility. The bank has duly granted 16 crore 25 lakhs, 23 crore 25 lakhs, and odd has been granted, Your Lordship. So as for the 19 crore 25 lakhs, in terms of this 19 crore 25 lakhs, Your Lordship, same hai na? Lordship, kindly see. There was a terms to close the Merchant Monger Agrotech Private Limited. Your Lordship, kindly take trouble to the just above the table, exit option. That's the exit option to be executed by the branch in the account of Merchant Monger Agrotech Private Limited. Sir.
You should know where you're reading it from.
Yes, I will.
So I have to backdrop of the case, Lordship, very quickly. So they disputed these facts before the court. They are saying that we are completely unaware, we are not aware about these facts. But the Honorable Court taking cognizance of this, where the bank has, since they're supposed to exit the credit facilities of Merchant Monger Agrotech, so they have given an undertaking to the bank, they will start repayment for the closure of the same. Kindly allow us to hospitality credit facilities of rupees 16 crore and odd. Bank has allowed him to operate that account, and on the basis of this exit, the bank has freezed the account. That freezing, they have made a representation before the Honorable High Court challenging the same. Illegally, the bank has freezed. Honorable Court directed the bank to close the same in accordance with law, their dispute. Accordingly, the bank has closed their dispute, and they have made a representation before the bank and given an undertaking. Your Lordship, they are saying in the writ petition, petitioner is the guilty of suppression and misrepresentation of facts. दो सेट बनाई थी ना, एक सेट और कहाँ है? एक और सेट था. Lordship, they are saying that after the disposal of the writ petition by the Honorable High Court, the bank has flouted the order of the High Court and did not call us to the bank, and initially it was freezed. Because of that reason, we won't be able to run our account, or our account has turned NPA. So there was illegality on the part of the bank. A categorical averment on affidavit in this writ petition. Lordship, kindly take trouble to their affidavit after the disposal of the writ petition by the coordinated bench in this Honorable Court. So let's say this was 24th of September 2025. Let me clarify. This is an undertaking by the petitioner in terms of the direction before the Honorable Court of the coordinate bench.
Yes.
So on the basis of this affidavit, the bank has defreezed their account and allowed him to close the same in terms of this clause.
So what has happened to this after this undertaking?
After this undertaking, the bank has defreezed the account.
Defreeze account, yes.
In respect of Merchant Monger Agrotech. In the writ petition, they are making an allegation that defreezing of the account by the bank is whimsical without our consent. So at the threshold, if a petitioner is the guilty of stating false statement or oath before the court, my first respectful submission is this writ petition, without going into any facts of the case, liable to be dismissed at the threshold for stating false statement or oath. I am inviting your Lordship to that categorical paragraph where the petitioner has stating a false statement or oath before the court. They were completely in dark. Lordship, kindly see page 23, volume 1.
Yes.
Lordship, kindly take trouble to page 38.
Yes.
It is worthwhile to mention here that defreeze was lifted on such and such day, just a day prior to Durga Puja such and such, at point of time, Lordship, before that paragraph, your Lordship. They are saying they are completely in dark. Yes, page para 37, your Lordship. Kindly take trouble to para 37. Surprisingly, the respondent bank did not invite the petitioner for hearing in terms of the observation made by the Honorable Court in order dated such and such, and unilaterally lifted the debit freeze of the case credit account of the petitioner. Such a decision of lifting of debit freeze of CC account of the petitioner number 1 was also done without intimation to the petitioner. As such, it is crystal clear and apparently.
So the order passed by this court on 18th of
18th
September
September.
2026, correct?
Yeah.
And the undertaking,
25.
undertaking which you rely upon, that is
4th of September, subsequent to disposal of the writ petition.
correct.
On the basis of that undertaking, bank has lifted.
Bank has
Lifted the debit
That's
freeze.
why before the High Court, this notification, this undertaking was not placed before the High Court, this court.
Subsequent to disposal of this writ petition, this undertaking was given subsequent to disposal of the writ petition, whereby the Honorable.
How you can say this court has disposed of the writ petition on 18 September 2026.
No.
And the undertaking.
2025, lot 26 has not yet come. It's I tender apology. That's my part. 25, your lordship. 25. They have written wrong. They have also traveled, but 2 months before, in September 2020.
That's why I'm asking you.
But see, I also read that.
Yes.
2025, a subsequent date.
Okay, September. Then they have submitted this undertaking. Then you have defreeze that.
Defreeze. But kindly see his categorical statement on affidavit before the court. It was not in consonance with the order of the High Court. I was completely in dark. I was not called for in the bank.
Okay.
And who is the person affirming this affidavit? You'll also kindly see the name and kindly see the name of the affirmation in the same person. The person who has affirmed the affidavit is the same and identical person.
Yes. Then.
So let's see. First of all, sir, at the outset, let's say, was substantiated by the corroboration.
This is with regard to the cash credit account.
Cash credit account. So cash credit account, he's supposed to. He did not defreeze the account, but he failed to. Now, not only that, let's say he's also suppressed. He's diverting the funds. He's the guilty of diversion of funds. Bank ought to have taken appropriate steps, which the bank will do in accordance with law, for declaring him as a willful defaulter. Let's say I'm placing the documents to that effect. So let's say they are maintaining an account with the Indian Overseas Bank, whereby a lordship is aware if any borrower maintaining an account with the bank, all the transactions should be routed through the account which they have availed. Let's kindly see. We have written multiple mails to the Indian Overseas Bank for closure of the account maintained by the Merchant Agrotech Private Limited. Multiple exchange of.
So you are appearing for whom?
I am for the Indian Bank. Just to substantiate diversion of funds case. He is asking for rehabilitation. Kindly see his conduct. Thereafter, your lordship, kindly see, we have given multiple communications to the Indian Overseas Bank. He has obtained a loan, he is not making repayment, kindly close their account and transfer the balance amount to the loan account. Moreover, lordship, your lordship also well aware, your lordship, with due respect, whenever the borrower is account, a bank is under authority to make a visit of the unit. What is the status, whether the goods are there or not, etc., etc. You kindly see, they are threatening the officers of the bank. The visit report prepared by the bank officials. A person approached the court must with clean hands. This is the visit report, lordship, dated 13th March 2026. Lordship, kindly take trouble to clause 21, second page. Lordship, may I read? Lordship, the property is on the second floor of multi-storied building named DN Tower opposite to Vinayak Hotel. The name of the Merchant Monger Agrotech Private Limited was seen in the building. One of the room is used as an office space of the company. Some parts of the floor were still under furnishing and maintenance during the time of visit. During this visit, we received a threatening phone call from Mr. Ritwik Bhattacharya via staff number such and such, stating that an FIR would be lodged against the visiting officials at the police station and also against the branch head's name. We wish to clarify that during our visit, we did not force entry into the property. We were then instructed the higher office to abort the visit with immediate effect. Photo of geological location taken during the visit is enclosed herewith.
Yes.
So they are not allowing the officials to take inspection of the property. They are enjoying the credit facilities of more than 16 crore. They are the guilty of diversion of fund, whereby they are under obligation as per the agreed terms and conditions to maintain all the transactions to the accounts maintained with the bank. Lordship, they have stated false statement on oath before the Honorable Court that they are not aware about this clause. Your Lordship, the clause, exit clause, whereby they are supposed to exit. Lordship, kindly see the date of freezing. In their application, they are saying on 25th of September, bank has lifted the freeze. Yes, on 24th of September, you have given an undertaking. You will close the account and you will continue with the hospitality. So these are the entire misrepresentation, suppression of facts, sitting false statement on before the court. One writ petition.
What about the MSME account? Which account is the MSME account?
The hospitality is the MSME.
Where is that? Which one?
The hospitality in the sanction letter itself, Your Lordship. The sanction letter which I handed over to you, the second page itself is saying it's a MSME.
What about that account?
That account, Your Lordship, that account has turned NPA. Because in order to rehabilitation in terms of MSME unit, so only mere asking or request will not suffice. With the request, they're supposed to submit a report, the viability of the company, etc., etc. But you kindly see one pager, 4 lines. I am a MSME unit, kindly allow me. And in the teeth of this conduct,
okay.
In the teeth of the conduct, Your Lordship, at the outset, false statement on oaths, suppression and misrepresentation of facts, threatening the officials if we will lodge a complaint, don't dare to visit over here, and guilty of siphoning of funds. So Lordship, bank, considering his conduct, is afraid of.
How you can say the siphoning of funds? What?
Lordship, the mails which I have handed over to you, Lordship, addressing to the Indian Overseas Bank, where we have made multiple requests for transfer of the fund routed through their account, because we are the petitioner have obtained a loan from the bank. Third paragraph, we are bringing to your notice that the borrower has a total credit facilities of 13 crore, which include OCC facility of 8 crore with us in accordance with the extent of regulation. The current account should be maintained with other banks when exposure conditions mandate routing transaction through the main leading bank. Additionally, your branch may consider such as such. So all these facts, Lordship, not a single whisper in their writ petition.
Yes.
Everyone, my friend is exhausted. One Lordship kindly comes to agro. And first, this should my friend explain that agro is also not an MSME company. Your Lordship will kindly come to page number
395.
395. My friend part of the not read is petition. Agrotech is also a MSME company. The loan is given also under the.
Yes.
The first statement which he makes hopelessly against the sanction letter itself. So both the companies are MSME companies.
Where it is mentioned?
Yes.
Page 395.
395, Your Lordship has, my lord. Page 395 is the sanction letter of the bank, volume 3 in 329.
395?
Yes, please, my lord. Your Lordship has volume 3 of writ 329.
Yes.
329, my lord. Kindly come to 395. Is the sanction letter issued by Indian Bank?
Yes.
To Merchant Monger Agrotech, subject sanction of fresh OTC limit of 200 lakhs under MSME.
Okay.
IND SME secure scheme, Merchant Monger.
One of my learned makes his first googly in the match itself.
No, not a googly. It's a simpliciter caption. It's nowhere it has written.
My lord, the MSME certificate is there. If my learned friend wants to persist on this, kindly
Maybe.
have the Udyam registration, my lord.
Even if he cannot improve his case of suppression, diversion, misrepresentation of facts, even if he is an MSME, supposed to close the account.
But same volume 392 is the Udyam registration, my lord, just for his satisfaction, my learned friend's satisfaction. Not for us, but his satisfaction. 392 is the Udyam registration.
Maybe.
Without Udyam registration.
Maybe.
Not everything, sir. If you a merchant monger agrotech is MSME, you're supposed to close.
If my learned friend will permit my
Listen, sir.
Yes.
Sir,
You take seat. You take seat.
Sir.
Yes.
Obviously.
So one of the same question. Whether my plans have given an undertaking. Now, what was the order passed by the earlier court? Your Lordship kindly come to the order in 18th of September 2025. Your Lordship kindly take it.
Page 442. Yes.
Lordship kindly come to. No. Lordship kindly come. My learned friend will kindly read the in the order sheet. And the second page is very important. Page 443 at the top. Your Lordship will see.
By directing the branch, may I place my lord? By directing the branch manager of the bank to take into consideration the prayer of the petitioners as appearing in the aforesaid representation in accordance with law, after giving reasonable opportunity of hearing, call the parties at the earliest or within a fortnight.
I call upon the bank to produce any document to show that the branch manager had held a meeting on this account and there was a meeting held. On that basis, whether my two representations were considered. Now, what were the two representations? I'll show your Lordship the two representations. One is 15th of May 2025. Lordship comes first.
So why you are given the undertaking?
No. Undertaking was your Lordship. I don't have a copy.
I have handed over, sir.
No.
Just now I have handed over. Just now I have handed
over. For the first time, they have produced a copy of the undertaking. Now your Lordship will see the copy of the undertaking.
That's the executor is disputing.
If you please allow me to argue, then I can always have not be able to argue the matter. You are making one after the other submission to your Lordship. And that too without any record.
Yes.
I could have understood that he had come with records, but he shows one paper, he shows another paper, you are giving us a copy of it.
The representation at 429.
At page 49, Lordship will come to page 49. We were exactly. Now what had happened was on 25th of March 2025, there was a sanction letter in so much hospitality on the secondary petition, in which the bank had said that a security for the tune of ₹19.25 lakh crores was being granted to the hospitality. The credit was made in the account of the hospitality on 9th April 2025. The actual copy of the sanction letter was received by us on 25th of April 25, where for the first time we come to learn one existence of an exit clause, which we denied on the very first instance, and thereafter on 15th of March, May, we made a representation. Your Lordship, my learned friend will read this, saying very clearly that this clause was not there in our sanction letter. At the time when we had negotiated,
with reference to our letter.
Which page?
Page 429. We are willing to foreclose Lordship has, my lord.
Yes.
We are willing to consider foreclosing the said 8 crore credit facility.
429.
429.
Yes.
The security attached to this sanction is to be released forthwith. Further financial assistance must be provided under any scheme comfortable for both of us so that our business operations can run smoothly and without any hindrances.
Yes.
In no document was it mentioned that our sanctioned amount can be frozen. Yet you have forcefully frozen the amount in our cash credit account, which caused huge losses to our business. The same must be made operational with immediate effect to allow us to continue our business operations smoothly. The current season is the season for tea production. If you restrain from conducting our business by freezing our funds without cost, all the losses incurred will be borne by you. The above terms and conditions are clear. We are willing to consider foreclosing the said credit facility by 15 November 2020.
Now, the second representation is at page 1.
This is the second one. This is the I just to save time I pointed out the second.
Yes. So, my lord, therefore, they did not, I did not with regard to the sudden freezing of the debit record CC account of 21st of April 25. We went to the bank seeking withdrawal of money to pay the laborer. At that point of time, we were suddenly made aware that there was a Lordship knows nowadays the system is not one doesn't give a check, they give this thing and it's automatically transferred. There was a stoppage. On 25th, the year after we come to the bank, we come to learn that they are frozen. What are the reasons? Not even. Whether some authority had directed them to freeze our account, not proved to us. Thereafter, we had moved the boom, this honorable boom, on the ground that our tea gardens have been closed for lack of fund mobility because they are illegally frozen the account. This honorable court passed an order that within 7 days you take a decision, which decision is still being awaited on the bank manager to take a decision. On 25th of September, that the day before the closure of the court, that was Shorty day. The bank suddenly refroze the account, but it never called the meeting as a directed. Second part of the order, which my husband has shown it to your lordship, that the bank manager was required to make a sitting and come to a reasonable conclusion. They have not done so. The immediate effect of the refreezing was that during the puja time, they had the bonus, and this time the bonus was increased from 8.31% to 20% by the government of West Bengal under notification which have also an interpretation. And we had to pay the entire amount, which was otherwise supposed to adhere to the running of the tea garden, which we could not. Naturally, but we wrote a letter to the bank calling upon them on them to pay us damages. That letter is also there. Having regard to that, this so-called undertaking, you will see not the undertaking. Therefore, you will see what is the undertaking.
Yes. Page 2. This is in respect of agrotech only, my lord.
Yes.
Company will use the said cash credit account number so and so for the purpose of the business of the company. That by February, the company will close the cash credit account and will not continue the said account.
Yes.
Company will hear all the directive. The bank will not raise any dispute, and if dispute arises, bank's decision will be final. Company will not contradict the same. All disputes will be null and void in the eye of law. If permitted as per norms of the bank in the meantime will provide another loan facility of
Yes.
equivalent amount
Yes.
or more to closure value.
This was, there was a reciprocal obligation on the part of the bank as well. That they have never provided. So they are harping on that we would have to close the account. But conveniently forgetting that there was a reciprocal obligation on the part of the bank to provide us equal facilities, which let them show. They have given this option to us. The 19.25 crores was paid way back in April 25.
So what has happened to this account?
I don't have any money there. The frozen and there is no money thereafter. I have to run the six gardens.
No, they already defreezed. Bank allowed defreezed.
That amount, as I said before, it was defrozen on 25th of September 2025. At that point of time, we had to pay the entire bonus to the tea garden workers. And thereafter, there is no further inflow or outflow. There is no further inflow or outflow of the bank. The bank was under the obligation to give us an equal, if not higher value of the same.
When the section 13 notice was given?
Section 13.2?
Yes. Thereafter, much thereafter.
4th of March.
4th of March. 4th of March.
Where is that?
Page 453.
And all the time, they were well aware that this is an MSME company. And now they are only coming to your lordship and saying that, no, this is not an MSME company. Only hospital is an MSME company. I shudder to say, but I would not dare to argue also this.
What is stated about this account? CC account?
Kindly similar. CC account is number 577.
777.
Yes, the last 577. 577, they show the book outstanding.
Limit 8 lakh, 1 crore.
And your lordship, it was submitted that there was no security asset. Kindly see page 455. Security was not created. That was the submission. Kindly see 455. That was the reason they said we had to close the account. Now kindly see the security assets. Serial 1, 2, and 3.
Sufficient
submission was made to your lordship. There was no security asset. That is why they had to debit freeze the account. That was the submission made. If I understood my learned friend, all this is without affidavit, but that was the justification given that we had to close the account because the borrower did not create the security interest.
So what you have prayed? What you have prayed for?
My lord, I have only prayed that this NPA declaration should not be acted upon till the MSME procedure is carried out. Because now, my lord, I'll tell your lordship that after this, they did the 13.2, then there's a 13.4. I've filed a SARFACI application before the DRT. Otherwise, the limitation kicks in, my lord, it has to be filed within that time. So
Have you filed 17?
I've filed the 17. I've not moved any IA there because my contention is that if the NPA declaration itself is wrong for not following the RBI guideline, then the entire action will fail. It goes to the root of the matter. There, my lord, I just want to trouble your lordship with the division bench decision of the Bombay High Court once, please, my lord. At the interim stage, this is following a decision of our court delivered by my lord. Your lordship will kindly come to notices in paragraph 7. Pronits and Sri Swami, both of the Supreme Court are noticed. Paragraph 7, your lordship sees. Pronits and Sri Swami.
Yes.
This has been considered by your lordship also. Your lordship has also. Then Mahua Malik of our court, my lord, paragraph 8 bottom. In this context, reliance is also placed on the judgment of Calcutta High Court in the case of Mahua Bhaumik versus Union of India. I am carrying this also. Now, and kindly come to 17 reliefs akin to that. Mahua Bhaumik was sought before the division bench. And division bench, my lord, admitted the writ and granted interim protection. In that case, NPA declaration had not taken place. It was prior to NPA declaration. Kindly see paragraph 18. We are of the opinion that while the respondents can be permitted to file their reply affidavits and to oppose the present petition on merits, including, this is exactly my learned friend's submission, my lord, including on the point of inapplicability of the notifications issued, because all this has to come on oath, issued by the Union Bank of India and the RBI to non-banking financial companies till the next day, limited interim relief can be granted. We are of the opinion that prima facie it would be counterproductive to leave the petitioner number 1 without any protection at all, and the creditors, that is so-and-so, they were a consortium loan perhaps, being free to take this issue has also been covered by a decision of your lordships. Not all banks have to do it individually. Prima facie, we are of the opinion that since the petitioner number 1, the test is prima facie, we are of the opinion that since the petitioner number 1 is indeed registered as an MSME, it is entitled to the protection of framework of rehabilitation and revival of MSMEs specified by the RBI. Respondents will restrain. The prayer which was granted was from declaring the petitioner's account as non-performing asset. In our case, my lord, we've been declared asset as a non-performing asset, but the 3-stage procedure has not been followed. Now, my lord, if the 3-stage procedure has not been followed and the mandatory guideline of the Reserve Bank of India, which has statutory flavor, is not complied upon by the bank, then, my lord, this declaration itself is bad. Why they say I'm not entitled to this scheme? They may have multifarious reasons. I'm showing you, my lord, just one more submission was made, my lord, slightly unfortunate, that the account, he said that hospitality was an MSME, he admitted, but he said the application, there was no application worth its name. There's a 4-paragraph. Kindly see the application made by the hospitality, my lord, with affidavit, detailed application with a chartered accountant's report. Lordship sees the application, please, my lord, made by the owner. Supplementary a copy. Hospitality. Kindly come to, my lord, page. I'm sorry, my lord, page 12, page 11. This is of hospitality. My learned friend said that application not worth its name given. Even if not worth its name, it's a summarily rejected. But now kindly see the application. 12th June, and kindly see page 12 onwards. This is the affidavit which is required. And kindly see the detailed application which is filed. Continues till page more up till page 31 with the annexures, and kindly see at 31, kindly see the enclosures, please, my lord. My learned friend says there is no plan given. Kindly see 31. Kindly see tea production reports, because this is also tea industry. Business revival plan and operational strategy for the forthcoming years. Projected viability assessment report.
Yes.
No action.
This is hospitality, and second is the
agro. Agro, he said, I am not going to answer at all because it's not covered by the.
Correct.
So that was his answer to agro. Then why he made all these submissions about suppression, I don't know. Nothing on affidavit. As far as hospitality is concerned, he says there is no application. This is the application of hospitality also.
So you filed an application with regard to the agro
and hospitality.
Hospitality and
agro.
Agro.
Agro is in that other volume which your lordship saw, my lord, of 329, page 544. These can be disposed of in accordance with law, my lord. I have no difficulty. 544.
The merchant. Agrotech.
This is agro.
This is agro.
Agro, my learned friend said, is not MSME.
And some supplementary that
is for the hospitality, my lord.
Hospitality.
Yes.
प्राइमा फेसी भी जाके ना देखते लेट्स सी
Yes.
And my lord, if your lordship sees the prayers, excellent. Your lordship kindly see the petition once, please, my lord. The prayers only.
So these are the two.
These are the two petitions. These are the two companies, both MSMEs. Factually incorrect submission, not MSME. Applications not made. Now, kindly have all the relief which I ultimately seek is, my lord. Kindly come to page 66, 65.
Of 329.
Like a 329, my lord.
Page
Page 65. A, B, and C, I'm not troubling your lordship with, my lord. Perhaps your lordship will not entertain A, B, and C, but kindly see D. Kindly see D at 67. Commanding the respondent.
These writ petitions can be disposed of. You consider the revival package if they are entitled or otherwise.
For whatever reasons he had.
Lordship, subject to your lordship kind consideration. Your lordship, with due respect, your lordship, don't take me amiss, your lordship. In order to get an interim order of injunction, he has to substantiate a prima facie case.
Correct.
First.
Correct.
Your lordship, at the outset, I have substantiated before your lordship is that the execution of page 420, the execution of sanction letter, where the exit clause was not in dispute. But you kindly take trouble to the page 420.
This is not the subject matter of this.
Sir, with due respect.
Not the subject matter of
Sir,
this.
मैं बता रहा हूँ 420. 420 lordship, kindly take trouble to.
329 का बता रहे हैं.
हाँ sir, हाँ. मैं उसी का बता रहा हूँ. So lordship, the execution of this document is not in dispute. Page 419 starts from the exit clause. The document, your lordship, which I have handed over to your lordship, the same documents, kindly see the signature of the borrower is appearing. Kindly see.
No, what you want to say?
I want to say, your lordship, the submission of my learned senior friend before your lordship is that both accounts are agrotech and hospitality, both are MSME.
Correct.
They're supposed to, in terms of this sanction letter 25th of March 2025, they're supposed to exit from the agrotech, which is also MSME. On instructions, I have made a false, I made a wrong submission. That is also, for the sake of argument, that is also MSME unit. But they're supposed to close in terms of this agreement of the sanction letter of 25th of March 2025.
Where is that?
Page 419.
Exit to be agreed.
Exit from the agrotech. Then how can he say that? Kindly regularize that account because he's abide by these agreed terms and conditions.
So you take a decision on that.
And also kindly see the representation subsequent to
fresh sanction of the credit facility.
Yes.
Of Merchant Mogra Hospital.
Subject to closure of 13 crore of agrotech. Subject to closure of agrotech 13 crore. 8 crore of CC, 5 crore of term loan. Lordship, that the exit option to be executed by the branch.
That's why you read sanction on the following.
Yes.
Correct. Sanctions on the following.
Fresh sanction
of SOD.
SOD means a security overdraft credit facility.
Correct. Security overdraft facilities.
Of rupees 19.25 crore on the closure of agrotech having credit facilities of 13 crore.
So the 19 crore for 25.
Yes, against the closure of
MSME. Under the general MSME.
No
Correct.
dispute.
Correct. Now the approval of the following.
Yes.
Approval of the movable security coverage 18.7%. And 19 exposure is 19.25 crore.
Lordship.
Correct. Then approval of the ROI of the repo rate, that is nothing here, not there.
Lordship.
Approval of 100% concession, that is again all other services charges, that is your
Lordship.
So exit option to be executed by the branch in account Merchant Monger Private Limited.
Yes.
So
they have to close that account.
Exit option to be executed.
Exit, with due respect to your lordship, exit option means they have to close the account upon repayment in order to enjoy these credit facilities of 19.25 crore.
Correct.
Which they have not. That is why the freeze was there.
That why?
That is why in terms of this exit clause,
correct,
the bank has made a freeze, not allowing him to debit because they're supposed to close.
Correct. You have freeze that.
We have freezed that.
Okay.
They filed a writ petition before the court.
Correct.
Bank
directed to consider.
We have considered it.
You have considered and defreeze.
The submission from the bar is the petitioner never called before the bank. If the petitioner never called before the bank, how the affidavit come?
No. Come. So after this, they have not complied with the exit provision. As per your submission,
Lordship.
so they have not complied with the exit option.
Lordship, they supposed to close.
They have not complied with.
That is why it has been freezed.
That's why you have freezed that.
Yes.
After the freezing, they challenged this freezing order before this court.
Lordship.
This court remanded the matter to the bank.
Lordship.
In the bank, they have submitted the affidavit, undertaking, and it was defreezed.
It was defreezed on the one clause my Leonard Senior was placing before your Lordship. The bank will make an alternative arrangement of that. This is what? 19.25 crore. In order to avail this, they're supposed to close that. The bank has defreezed. Defreezing is not disputing. Now, after defreezing, what they're supposed to? They're supposed to make an endeavor by debit credit, immediately close the account by the February 2026. Their affidavit is saying that I will make all possible endeavors to close by February 26.
Correct.
There is a clause, so kindly see.
Yes.
And I will not
company will use the said cash credit for the purpose of company that by February 20 the company will close the cash credit account.
Yes.
Yes.
Which they have not. And this is not in dispute. Let's say kindly pause here for the moment and kindly visualize a person giving an undertaking.
Okay. I accept your submission. So they have not closed the cash credit
account has been because.
Correct. Okay, no problem. Then
Agrotech is an MSME unit. If I have to make an endeavor, they're supposed to close.
Okay.
They cannot say regularize.
Okay.
But he is making a contrary submission with regard to their undertaking. I will close. Now they are asking for regularize because I am an MSME.
Correct.
That's
why I'm telling. This is the plea with you.
This
is the plea with you with regard to initiation of the procedure under 13.2 issuing the notice.
Lordship.
Correct. This is the case.
Yes.
Because they, as per the sanction clause and as per the undertaking, they have not closed the cash credit.
They flouted the terms.
So they have flouted the terms.
Defaulted.
That's why you have initiated.
Defaulted. Account turned NPA.
Account and NPA.
Lordship.
That's why you initiated.
Lordship.
Correct. But rightly and wrongly, the accounts are under the MSME.
Lordship.
Rightly or wrongly, the accounts are under the MSME.
Lordship, with due respect, subject to Lordship approval.
Yes,
obviously, the Lordship, mere an account is an MSME is not an obligation. Sir, with due respect.
Please, Mr. Speaker.
It is my submission. I may be wrong.
Okay.
Give me more.
Yes.
Lordship, there is a principle of bona fide. Because I am a MSME.
No, that's why see what the court proposed.
Lordship.
So admittedly, both accounts are MSME. Both amounts are MSME. Both companies are MSME. Correct. Sanction is under the MSME.
But he cannot ask for regularization of one of the MSME Agrotech which is supposed to close.
I am coming.
Lordship.
So they have not complied with the conditions of the sanction letter by closing the CC account. So that's why the account also become NPA. You have initiated the process.
Lordship.
Now they are claiming, no sir. See, this is both the accounts of the MSME. They are covered under the scheme of the revival package.
The time is important when subsequent to issuance of 13.2 in the month of March and April.
Whatever it may be,
Lordship.
they are asking for that.
Yes.
So you have to decide whether they are entitled or they are not entitled. They are not entitled. You pass an order. Consider the representation, sir. This is you have done this mischief. You are not complied with that, and you have already initiated the 13.2. Prior to that, you rejected. But you cannot sit tight over. You cannot sit tight over the matter. The request made by the party.
That's it. What is
where is your decision?
Yes, your Lordship. Where is my decision? I have asked my officer to give me the decision. So, Lordship, subject to your Lordship kind consideration, only 2 minutes or more because I don't want to, because I have to also protect my cases also.
Correct.
So, I will try my level best to satisfy your Lordship, subject what is fallen from your Lordship.
What I propose, instead of all this exercise, what I wanted to propose, let whatever the bank wanted to take, you take your decision. I am sending back to the bank. They have already
yes.
They have already filed the application in form with an affidavit along with the document.
Yes.
So the writ court cannot decide whether that you are entitled or not entitled.
Yes.
It is the bank has to decide.
Yes.
Correct. The committee has to, not even bank.
Not,
the committee has,
Lordship, not only because of that representation he has flouted. Your Lordship, other two submission or four submission which I have made, he has rooted diversion of fund.
correct. Whatever it
no
may
answer.
be, whatever it may be.
Lordship.
So you decide it and take a decision.
Lordship, may I, subject to your Lordship card consideration. Two things is hurdling me. Lordship, the bank has initiated 13-2. Bank has issued possession notice. So the law is well settled by the Honorable Apex Court as well also. If the bank has initiated a surfacey proceedings, the read court should not upset the same. The appropriate forum is DRT. For whatever reasons, whatever.
Revival package can't. Revival package, the court, Supreme Court has held, if the bank has not considered, if it is the MSME, then the bank has to, the petitioner has to inform the bank with an affidavit along with the document.
Here the writer will come. Here the writer will come. The conduct and malafide on the part of the petitioner, whether he is a bona fide borrower or not, whether his conduct good or not. Let's say I have substantiated, he is the guilty of diversion of fund. I have substantiated, there is no answer. I have not opened the account. I'm not maintaining diversion of funds. No answer. Number two, let's say he is the guilty of stating false statement on oath, misrepresentation of facts. I was completely in dark. Kindly regularize my MSME agrotech, whereby his own undertaking, I will close it by February. Second. Third, he is not allowing the bank officials to inspect the premises, inspect the security. Rather, he is threatening my officers to, I will lodge an FIR. Under these three circumstances, prima facie, I have substantiated before your Lordship, there is no rebuttable from the adversary. Save and accept, I have put it on affidavit. Certainly, you put it on affidavit. It's a first instance. I will certainly rebut by the documentary evidence. But you cannot deny your conduct. So the law is also settled, your Lordship. There are judgment of the Honorable Apex Court.
Then if you're telling that this court has to decide all the things on receipt of affidavit.
No, not that. I'm on otherwise. I'm on other points subject to your Lordship. The law is well settled. I'm also guided by the Supreme Court judgment. Your Lordship, first of all, your Lordship, one of the judgment is saying I was not aware about the clause of exit. Lordship, kindly take trouble to the judgment of the Honorable Apex Court. 2010 volume at Supreme Court 129. Approbate and reprobate you cannot. You approach the court with clean hand, with clean facts. Your Lordship, kindly, without troubling your Lordship. Lordship, straightway, without troubling internal Lordship, the head note. Lordship, the rate of interest, entitlement of change, effect of equities. Borrower having availed of loan.
Where from? Which
the head note A.
Which head note you are reading?
Lordship, the judgment of 2010 volume 8.
Correct.
Lordship, the head note A. Debt, financial and monetary loss. Lordship, got it? Then in bold letters, very top. Your Lordship, second line, borrower having availed of loan and other financial credit facilities from the creditor bank for long period, more than 10 years in this case, without questioning the terms thereof at any stage, held could not be turned around. Here, after availing loan, he disputed. After disbursement, turned around and challenged the interest rate per annum with quarterly rate and unconscionable, expropriatory and contrary to law. More so, when he had signed the agreement with open eyes, here I am, and agreed to abide by the terms on which the loan was offered by the bank. Hence, the doctrine of unconscionable contract not applicable.
Yes.
So, hospitality credit facility not in dispute. Execution not in dispute. The dispute is I am not aware of clause. With open eyes, your Lordship, the document which I have handed over to you, to your Lordship, from there your Lordship will find the seal and signature of the company.
Yes.
Now, after putting his signature with open eyes, can there any scope for dispute? The answer is no, in the guise of the judgment of the Honorable Apex Court. So at the outset, he has made a misrepresentation before your Lordship.
Yes.
So Lordship, there are the judgments of the Honorable Apex Court also. If a litigant approach the court with unclean hands, not disclosing the entire facts by suppression and misrepresentation of facts, such a litigant cannot be allowed to touch the fountain of justice. 2013 Supreme Court cases, Your Lordship. So at the outset, I have substantiated before Your Lordship, he is not entitled to, even if he is a very good case on merits, for the sake of argument. Because of these facts of diversion of funds, because of threatening my officers, because of after executing a document disputing the agreement, it says his intention is not bona fide to repay the loan. Mere I am a MSME unit. So Lordship, the MSME Act has been made to cure the bona fide borrowers.
Why the bank is not considering all the things and pass appropriate order?
Cut short the matter. Let me cut short the matter. Lordship, the stage whereof to I have reached, Lordship, kindly do not disturb regarding surfacing. I will consider is represented and disposed of. No question of board whether his conduct is at all entitled up to his up to board. The question is that.
Okay.
Such a bona fide borrower is not entitled to. And I am dealing the public money. Why should I take a risk to such a borrower who is threatening my officers? Lordship, do not disturb my surface. I will still my hand till disposal of his representation. Thereafter I will proceed. And if he agreed, he has forum.
There has been or to have apprised your lordship that having his officers being threatened, the first duty of the bank ought to have been to file an FIR.
Yes, the bank will take it in accordance with law.
When? In March, and now we are in July.
Person, before your lordship, I shows his conduct.
Yes. March, we can talk about everybody's conduct.
Person doing something when he's asking for justice. Doing injustice to the public money.
That's all. Formally cite decisions of our court, my lord.
MSME, I'm not on that. Yes, MSME, but he is entitled to what I am got.
I placed the latest decision of the Bombay High Court, which has considered our court's decision also and granted interim protection.
Lordship, whether malafide borrower is entitled to or not, this is the moot question to be considered, which I have argued before your lordship. I am not disputing the judgment of the Honorable Apex Court, Division Bench, and on the order passed by your lordship. I am on the malafide borrower.
That's why I'm telling whatever. If see, there is a procedure.
Lordship,
correct.
I have to follow, being a nationalized bank. Yes.
You have to follow. So once you have received the request from the borrower that, sir, see, I am the MSME and I am entitled to that. See, these are the documents which you have to consider in terms of the revival package of the Reserve Bank of India. Correct. So maybe, so you have to consider and you take your decision.
Lordship, do not disturb my surfaces. Till such time, I will not proceed. I will consider in accordance
I will dispose of this.
Yes.
I will dispose of this.
Without disturbing my surfaces, I will still my hand till the disposal of his representation.
Correct.
So, law issue, your lordship, in accordance with law. He is asking for what?
I've gone through the Mahua bombing case. That the same order is passed.
Lordship, no, but the malafide borrower was not there, certainly.
What is
Malafide or not, that is to be taken into consideration by your bank by considering this.
I will.
Humble submission is very clear what the consideration is going to be. Knowing from my learned friend's submission, his submission is all this while he has argued, I'm a malafide person, I'm not entitled to. His case is that I'm not entitled.
Even the court will not grant any stay.
I am not entitled to this. Let him take that stand on affidavit. Let him bring all my malafide on.
That means he wants to stay.
I don't want any stay.
I will consider. I'm asking. Do not disturb my surface.
I'm not. That one of two things. If I am not entitled to this, is that is his case. If I am not entitled to this, then I cannot get disposal of this writ with the order which I was humbly praying before your lordship. If I am entitled to this, then he has to consider my representation in accordance with law, in accordance only with the MSME guideline. There can't be any external factors. That is that is so. If he is saying I'm malafide and it will be summarily rejected.
The bank shut his eyes over his malafide. Giving public money, I will shut my eyes over his malafide.
He says that it's going to be summarily rejected for these.
Kindly see his prayer, your lordship.
What is the stage of the 13.2?
Protection notice has been issued only.
I am not aware, my lord. I have not.
They have filed section 70. They are not aware. Section 17 filed, admittedly, and they are not aware. Kindly see the
Notice
submission.
given, I have to file because there's a time limit within I have to file. There's a limitation there to file. And kindly see whether there is any delay on my part.
So there is affidavit on affidavit, their submission. Bank has filed section 14 application on affidavit. They are aware. Again, wrong submission from the bar.
I have not said.
I am not aware anything.
I have said that we have come to
Whether you
learn.
got an order or not, I don't know. What is this?
He don't know. He has siphoned it, he don't know. He made false statement, he don't know. He is threatening my officer, he don't know. He is supposed to close one of the account, he don't know. Such a malafide borrower, with due respect, subject to lordship kind consideration, do not deserve any clemency before the court. However, lordship, I leave it to a lordship. I will stay my hand till disposal of his representation. Subject to what is fallen from your lordship.
Section 3, your lordship is aware, man.
Only for the bona fide borrower. I will add the rider to the bona fide borrower
He will add
for
a
their
rider-
rehabilitation.
He will add a rider to the RBI scheme.
He is siphoning the fund and asking, allow me statutory
Let it be decided
benefits.
before your lordship then finally whether I'm entitled to this.
So then prima facie is not entitled to get any interim order.
That is how
I have
the
no
committee
agitation
has
to file affidavit.
constituted. That is how it has to be done.
Yes. Okay. Anything further? Hearing concluded, CAV.
Obliged, your lordship. That's the only I am concluding my submission subject to lordship kind consideration. The entire judgments regarding MSME from this honorable court to the apex court is only for the bona fide borrowers. He is not at all a bona fide borrower. His conduct is not good, and he has made a misrepresentation stating false statement on oath. Kindly consider all these
But
aspects.
kindly also
I leave it to your
record-
lordship.
Kindly record.
I leave it
that
to your
the
lordship.
penetrant does not wish to use an affidavit.
That's why CAV I kept it.
Yes, because no, he doesn't want to use an affidavit.
I have not said so. I don't want to.
That is the problem, my lord. The judgment will come. He'll say I was not allowed.
No, I'm not in that.
Let
I'm
him
saying
submission whether he wants to
If
use
you
an
want
affidavit.
to
or not.
affidavit, then I will keep the. I will not say. I will keep say order. If you
Sir,
want to
have both
affidavit,
ways.
then
That's
it's
it.
not a fund.
For us regarding,
Both ways. Changing his stand every minute now.
I'm not changing.
That is what I'm afraid
If
of.
you want to file the affidavit, then I will pass an order with regard to the interim. If you say that the writ petition is disposed of without the affidavit, then I will pass.
After the writ then the lordship, it will be writ petition may be disposed of subject to their disposal of the representation only. I'm on that.
Dictate the order also.
I'm not dictating, your lordship. What was followed from the lordship?
See, with regard to the consideration of the representation, that is consideration of the application for under the revival package under the scheme.
Under the scheme.
Yes.
Under the scheme.
Under
Your
the
lordship,
scheme.
but with due respect, subject to your lordship, what is fallen from your lordship subject to? Your lordship, whether the argument, I will not reiterate, the argument which I have advanced before your lordship, before reaching and before invoking that section, can bank shut his eyes over that facts?
So that's it. The
I will consider, and my submission is till disposal of that, I will not further proceed. I will. These are my submissions. But so far as allegations, except made in the writ petition, I am vehemently denying the same. And if the court wants to put me on affidavit, I will file my put on affidavit. This is not a problem. You want an interim order, nothing more, nothing.
Recorded. From the submission made by the counsel for the respondent bank, this court find that the respondent is not yet decided whether they intend to file the affidavit in opposition or whether the writ petition is to be disposed of at the time of hearing. So accordingly, the respondents are directed to file affidavit in opposition within 3 weeks. Reply, if any, they are to be filed within a week. Within 2 weeks. With regard to the interim order, regard to the interim order, let the matter be fixed on. आज कितना तारीख है? कितना तारीख है? 16. Let the matter fixed on 23rd for orders.
Obliged. Consider your lordship malafide. If your lordship so required, I can file a judgment. Subject to assist your lordship.
Otherwise, I will release the matter.
Lordship.